Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I am your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the U.S. Supreme Court, and I hope you're having a great day. For today's story, we cover the Karen Read trial, which hopefully will be coming to an end today if fate is kind. To remind you, Karen Read is on trial for the supposed murder of her boyfriend, John O'Keefe. According to the state, here's what happened. Karen Read was mad at her boyfriend, possibly relating to an affair that might have occurred in Aruba, and they were on hard times as a couple. Karen Read dropped off John O'Keefe at a party at the Alberts house, and then apparently immediately changed her mind. After making it just a brief distance from the house, she then jacked her Lexus into reverse at 25 miles an hour, which, by the way, anyone who's driven in reverse at any speed knows that that's a bit terrifying. And she's doing it at 25 miles an hour in the snow, but never mind. But she has murder on her mind, according to the state, so that's not going to be a problem. She then drives her 7,000-pound vehicle directly into John O'Keefe, hitting his arm, mind you, leaving no bruising, no fractures, and no broken bones on his arm or anywhere else, causing him to maybe hit the ground, spin through the air, and land in the snow to die of hypothermia. That is the state's case. It's not great, but that's what they are going with. All right, in support of this proposition, they had a lot of people to testify that, in fact, it was snowing. Okay, it might have been snowing. I think we might be able to draw that conclusion. Yeah, so it was snowing, and we heard some text messages, read some text messages and stuff, and this supposed confession of I did it. A confession, incidentally, that even though cops heard it, didn't immediately arrest her. Even though they heard it, wasn't caught on a body camera. Even though they heard it, was in no police report. Even though they heard it, was not testified to in any grand jury proceeding. This critical statement of I hit him, not recorded anywhere else. The state's star witnesses, I suppose, would be Proctor and Paul, the double P team. Yeah, they're great. Proctor, there are some problems there. Missing video, missing 42 minutes of video. The video just happens to be missing the time when the car arrives at the Sally port. Just happens to be missing that critical time, which might show the car in the condition in which it arrived at. Just a weird coincidence. Just a weird coincidence that that particular part of video is missing. Also, the video from inside was inverted to make it look like they were on a different side of the car than they really were. Also, the police reports were wrong because, of course, they don't contain the statements. Also, the Celebrate data is wrong. And so forth and so on. And then, of course, from Trooper Paul, we learned about this exciting new field of science. I'm not sure it has a name yet, but he is definitely a trailblazer in whatever it is. And we heard from him about the miles per hour and stuff that he used to draw his critical conclusions. Fun. That's great. And even the state's own medical expert, of course, testified that she did not think this was consistent with what she's seen in motor vehicle crashes because, yeah, that's great. From the defense, we heard from the snowplow driver, my hero and yours, Lucky, who is the greatest witness of this case. A just normal, average, unpretentious guy who just came here and told you the truth. He didn't need a lot of words. He didn't flaff around. He didn't fight things. He just said yes, no, and other things like that. It was pretty great. It was a very refreshing change with just someone telling you the answer with no fighting and just telling you the honest truth. It was pretty great. Lucky, the snowplow driver, was on that road 3 different times in the evening in question. 2:30 in the morning, 3:30 in the morning, 5:30 in the morning. and he did not see a body with his big spotlights on his Franken-truck. Despite looking for things, didn't see a body, a 6-foot tall body, didn't see that lying in the snow. So yeah, but he did see a car, not Karen Reed's car, mind you, but he did see a car, a Ford Edge. Who owns a Ford Edge? Why, the Alberts do. Where did he see it? Well, exactly where the body would be, perhaps to block the view. Did he see a Lexus SUV? Did he see Karen Reed's car? No, he did not. And so, that's kind of a critical blow to the state's theory of the case. And then, of course, we learned that the lead detective did not interview our friend, the snowplow driver, for a year. I mean, it was almost a year to the day. Actually, it's just slightly longer. It was like 13 months or 12 and a half months. It was just a little bit longer than a year. But almost a year to the day it took him to interview a potential eyewitness to the murder. Which makes you wonder what's going on, right? Makes you wonder what's going on. And so that's a whole thing. And apparently did not interview him until after he learned the FBI did. So that's just really thorough work, not trying to find potential eyewitnesses, especially a snowplow driver. Presumably the police are aware that the streets are sometimes plowed, I would think. So that might be, who would be a regular on this route that might have been there would be a reasonable thing, like a newspaper driver or a mail truck or a snowplow truck. Like, who might be there that we could see might be a regular, might be a reasonable thing to see. But we didn't do any interviews for any of those reasons, for whatever. And then, of course, we heard from 2 medical experts, one of whom literally wrote several papers on animal bites and dog bites. Been around for a while. Saw emergency medicine in LA, one of the busiest trauma centers in the nation. So she's seen a few things. And she's like, yep, this looks like a dog bite to me. And then we heard from another ME with the 13,000 autopsies. And they're like, yep, this doesn't look like a automobile accident to me. I don't see it. No bruising, no broken bones, no fractures. Doesn't really seem like it to me. And then, of course, we heard from 2 engineers, one biomechanical engineer and one just straight engineer, one of whom studied the body and one of whom studied the car. And they're like, nope. There are multiple PhDs between them. They are brought in by the Department of Defense and another entity for their expertise. They know what they're talking about. And they're like, nope, this doesn't look like. And they're completely independent. They were not hired by the defense nor the prosecution. They were completely independent because they were asked to do this by another entity. And so they're like, no, that doesn't really look like an automobile accident to us. But then again, I don't think either of them had an associate's degree. So maybe they're not qualified. Unclear. Last night, the jury got the case. They had the case for about 3 hours yesterday and apparently did not come to a verdict. Unclear why. And they're going to be back at it this morning as they try to decide whether or not there's any evidence to convict Karen Reed, which there's clearly not. It's insane to even ask. Lawyer, apparently was of the opinion that Karen Reed proved her innocence beyond a reasonable doubt. Yeah, I certainly feel that. I certainly feel that, to be sure, that there is manifest weight against it. And if there is a conviction, it should be overturned because this is absolute crap. Karen Reed is back. Yep, the jury is back this morning as they get their instructions this morning to resume doing their charge. And so hopefully we will get a verdict today if fate is kind. Karen Reed is on trial for second-degree murder, which faces a 15-year to life sentence and other charges of various versions of vehicular homicide, all of which, of course, required Karen Read to kill her with the car. So if Karen Read didn't kill him with the car, then she's not guilty of all of it. So manslaughter from DUI, involuntary manslaughter, and other associated charges along those lines, plus leaving the scene of an accident. But, you know, yeah, whatever. So let's see what's going on. All right, doesn't look like there's anything going on. She's just asking the lawyers to stay around. Wow, the judge says be ready to go on 5 minutes notice. So, okay. All right. So the judge says be ready to go on 5 minutes notice. So it looks like if there's a verdict, we're not going to get a lot of lead time. So it's like, you know, better stay around the building because, well, there's nothing left to do. So we'll see what's going on. Yeah. Also, there was a huge crowd outside today, and there still is. So let's turn briefly our attention to the channel LTL Media, which is showing the crowd. This is a live shot as we speak right now. And this is all people there for Karen Read as he conveniently walks through the crowd to show us the size of the crowd. Apparently, it is around the corner. Something like 200 to 300 people is a rough estimate. And they're all there to support Karen Read. I noted the juxtapositional irony in this case versus the comparison to, for example, the George Floyd case relating to the murder of George Floyd, in which the crowd outside was calling for the head of the people on trial. But this is exactly the opposite. These are people calling for the freedom of the person on trial. So I did note the juxtapositional irony in considering how the crowd outside the courthouse and what they're asking for. So I think that's pretty amazing. So we got all this pink. We got some pink shirts. Lots of people out there in the crowd, and they're very happy. Very cool. Fun times. So they are out there protesting in a mostly peaceful fashion. So we will see how it all turns out. All right, let me have a little water. Then we'll tell you about the plan for today. Okay. Plan for today. The plan for today for our stream. We are going to start this morning editing. We've got about 45 minutes. And then at top of the hour, the Supreme Court comes down with its decisions for the day. It's the end of the term. There are 3 days left of decisions, and there's something like 15 cases left to be decided. And so we're going to do a Supreme Court speed run, old school. We're going to do a Supreme Court speed run. I'm going to explain each decision within 10 minutes. By the time the next decision comes down, because it takes the Supreme Court about 10 minutes to move from decision to decision as they read from the bench. So it gives me about 10 minutes to read each case and explain it to you as we move from case to case. So we're going to do an old-fashioned, old-school Supreme Court speed run, and that will be fun. And depending on what they come down with, perhaps we'll stick with that and do a more thorough explanation. Then we'll go back to editing, and then we'll publish we'll publish the video for today because, well, if the jury comes back before I publish, then it kind of sounds moot. So it would be helpful to get the verdict. It would be helpful to get the decision out first because it may wind up being moot. If the Supreme Court overturns Chevron, none of the rules will be immediately overturned. So that is not correct. None of the rules will be overturned. The question is not the validity of the rule. The question is the validity of the interpretation of the rule or statute. So none of the rules will be overturned by overturning Chevron. It's just that they will be given their proper interpretation, which is fine by me. In terms of interpretation of rules, 5% max, but still, like, that 5% is not nothing if you're on the wrong end of the federal government stick. So, you know, in some senses, it's not that big a deal, but it's the proper interpretation of law, and I want that. So I want that better. So yeah, I would say, I'd say 5% max of the federal interpretations will be impacted by this. Not even necessarily overruled, but let's say impacted. But hey, that 5% isn't nothing. If you're on the margins, you know, and you have the federal government's boot up your ass, you know, you're going to be a lot happier. So we'll keep them within their proper domain, and that's more than enough for me. I'm a happy camper. What's the most egregious error made by Judge Bev and Lally? The most egregious error is not dismissing the case at the end of the state's case. It is clearly not supportable. Obviously so. Good morning, everyone. Good morning, Kim. Just getting the editor booting up. So we will start soon. When bringing the biggest error in bringing the case in the first place? Legally, I mean, legally, the bigger error is not dismissing the case because the standards are different. So the bigger error is not dismissing the case. Legally, that's the bigger error. Defending bringing the case is easier legally because I don't have to work very hard to bring the case. Legally, the standard is so low that it's like I can do that, right? So yeah, so the bigger error legally is in not dismissing the case, in my humble opinion. Ever been to the Doritos farm? It's a cool ranch. Well done, sir. Well done. I approve. When do you think they should have dismissed it? At the end of the state's case. That's what I said. The biggest legal error was in not dismissing it at the end of the state's case. That's what I said. If it was dismissed, it could not be brought up again. Double jeopardy had attached. No. So if the judge had dismissed it, then it could not be brought again. Double jeopardy. Any idea what the FBI investigation about? It must necessarily be about state officials depriving people of civil rights under color of law. 18 USC 242. Because that's really only the jurisdiction they have here is 242. So let's see. Now I have to find the right video. All right, let's see. Let us see. Which one is it? .312. Is it this video? It might be this video. Kurt, where was the vehicle black box info? I believe there was testimony regarding that. We didn't explicitly cover it. We didn't cover everything, but I think there was some testimony regarding that issue. Happy hump day. Happy hump day to you too. Thank you. I appreciate that, Margaret. I try to be very intelligent. It's one of the things I try to aim for. How about not going to trial when both the prosecution and defense asked the judge to wait? I can't speak to that. No, it's not. It's not the Supreme Court. Not yet. Later.
Look the other way. Look the other way. 4 words that sum up the Commonwealth's entire case. 4 words that sum up the hopes of those who have tried to deceive you. Conflicts of interest? Doesn't matter. Just look the other way. Magic hairs, magic glass. Look the other way. Late night calls and Google searches, falsified affidavits, inverted videos, and butt dials galore. Just look the other way. That's what they want. That's what they're counting on, but the uncontrovertible fact is you have been lied to in this courtroom. And your job is to make sure you don't ever, ever look the other way.
We can talk, by the way. We can still talk. So if you have questions and stuff, you can ask them, and I'll try to answer your questions. I'll just have to pause what I'm doing, but that's okay. So you can watch me or we can talk. It's fine. It's a little hard to do both at the same time, but we'll do what we can.
Ever look the other way.
All right, really strong opening here and really strong thematic elements. This is really good. So in the same way he started his opening with Karen Reed was framed, strong thematic, strong element, he chooses the phrase look the other way as his thematic element. And so he echoes that phrase several times and gives an example. So this is an example, once again, of a very strong, powerful opening. He starts with a simple phrase. In the opening, it was Karen Reed was framed. Here, it's look the other way. It doesn't have to be complicated, and it's not complicated. It's very simple, sets the tone, and establishes... Can you ask questions about other cases? Sure. If I know about them, I'll try to give you my best answer. Outstanding job, as always, right from the start. I am intrigued. Yeah, you can ask questions about other cases. It's fun.
Your singular duty is to stare down the evidence and do it unflinchingly.
No, Karen cannot sue if found not guilty. She has no cause of action.
You see, you're the only thing standing between...
Yes, I have an Instagram page.
And the tyranny...
Same username.
...and injustice.
All right.
It's your job you didn't ask for, probably a job you didn't want. But it's the greatest responsibility we have.
How's Houston today? 82 and sunny. Always, right from the start, I am intrigued.
Your singular duty is to stare down the evidence and do it unflinchingly and do it unwaveringly. You see, you're the only...
I should edit the episode where I'm editing an episode.
And the tyranny of injustice.
All right.
It's your job you didn't ask for, probably a job you didn't want. But it's the greatest responsibility we have as citizens here in America.
All right, there you go.
The government stop answering to us, and we start answering to the government.
I mean, you know, I love the patriotism and the spirit. That probably goes better even in Boston, in the Boston area, because, you know, of the whole Tea Party and everything. So that strong, independent spirit. I love it, man. That's good stuff. I like it. Thank you, Margaret, for the 20 euros.
Woe betide any one of us, who might find ourselves in the crosshairs of a Michael Proctor.
Truth. Court TV stopped the verdict clock? No.
Of a quote.
You're right, they did. Uh, okay. Well, the verdict clock has stopped. So, all right then. Hold on. Okay.
117. I believe we have a question from the jury.
Oh,
yes,
good.
it's simply, good morning. The jury is kindly requesting to conclude deliberations in time to board the bus at 4 p.m. A juror has a long existing scheduling conflict. So I'm just going to simply say yes and send it back.
Yes.
Objection.
That's fine, Your Honor.
Okay, thank you. All right, can we mark this, please?
That would be triple P for identification.
Thank you. Do you want the envelope too?
Is the jury contemplating being there over the day?
All right, thank you. We will send it back in with you, Officer Delano.
All right, panic over. Panic over, back to the edits. Trying to edit something that's still going to be relevant when I release it. Jury, you can't make a decision yet. I have to release my video while it's still relevant, damn it. I need time to edit. I can only edit so fast. I'm one man.
Quote. It's a quote about the truth, and I want to share it with you. It is of great importance to set a resolution never to tell an untruth. There is no vice so mean, so pitiful, so contemptible, and those who permit themselves to tell a lie once find it much easier to do it a second time and a third.
Yep.
This falsehood of the tongue leads to that of the heart, and in time, it depraves all its good dispositions.
Nice.
What does that mean? It means that it's been observed that to tell an untruth, to exaggerate, to make a false claim, it's a cancer. One lie begets another, and it's a malignancy that grows over time.
Can the O'Keefes bring a wrongful death suit?
really
Yes,
like
they
the
can.
poetry.
Very good there with a nice quote there. Where the
And
odds
then
of it
he
happening?
follows
Pretty
the
high, I would
quote
imagine.
with this nice verbiage, this very rich language, the malignancy, cancer, very descriptive, very evocative. It's very, very thoughtful and very caring language. It's just very solid.
I really need my second chin to disappear. That's what I need in my life. Hopefully my continuing workouts and diet plan will work, but I really need to not have this big ass frog flap thing going. It's not a good look.
Solid language. And so I really appreciate the way he follows that with such rich language. It shows a real mastery of the English language. Shows someone who actually thought their closing through. Nice job.
Defense does not have to prove anything. 100%. You better believe it, baby.
Folks, is how a cover-up is born. That's how a Massachusetts state trooper says in whispered tones to his friends when he thought no one was looking or listening.
Mm-hmm.
You don't have to wonder if times they did lie.
Powerful. Very
Over
nice.
And over and over, they and others were caught deceiving you. Big things, small things, to cover up the truth. The Alberts, the McCabe's, Higgins, Lank, Michael Proctor. You may ask yourself, how does this happen? How could this happen? It's 2020.
Can't get rid of that part. Oops.
How the girl? You may ask yourself, how does this happen? How could this happen?
Put the edit in here. Delete this part. Boop.
And it's 2024. Surely people aren't going to come to this.
How long I've been doing the meal prep
justice
service? This is
and
week
lie to us just
4, I
because false
think.
information.
Or week 3.
They wouldn't do that. They wouldn't try to cover up the truth. The Alberts, the McCabe's, Higgins, Lank, Michael Proctor, Yuri Buchanan, Brian Tully.
Mm-hmm.
You don't have to wonder if they would lie to support their narrative. You need only wonder how many times
100 degrees
they
in
did
Clemson.
lie.
Oh dear. Powerful. Very
Over
nice.
and over and over, they and others were caught deceiving you. Big things, small things, it didn't really matter. They feared nothing. They'll look you in the eye and deny phone calls. They'll deny secret meetings. They'll claim that calls are butt dials and butt dials are answered. They'll show you a video and tell you left is right and right is left. They'll magically turn 3 pieces of plastic into 5. Folks, look the other way.
Yep, that's good. Let's cut it there. Cut out that silence. Cut that. This editing program is DaVinci Resolve. It's free. Free is good. I was thinking about getting Fillmore or Wondershare. Nate the lawyer uses it. He says it's good. So I was thinking about maybe paying for that, but I just use DaVinci Resolve, so easy peasy.
Look the other way.
I mean, really, what can you say there? Really, it's just a nice choice of exemplars to bring the point home. Look the other way is what the state wants you to do, and here are a couple examples. Doesn't overstay its welcome either. I mean, he could have gone into more examples, but his choice to make them a little bit more tailored is also a very logical choice to not overstay its welcome. And I think he gets in and gets out in a very powerful way. I think I'm going to drop that entire part.
Ladies and gentlemen, there was a cover-up in this case, plain and simple.
Yeah, I'm going to
So you
drop.
say to yourself, I don't want.
I'm going to drop that entire thing and its reaction because I don't need it. Make this a little shorter. Thought they're closed. Turn up the volume more. Okay, I'll turn up the volume more.
Making calls as butt dials,
Sorry.
but they were answering calls as butt dials. And Higgins seemed awfully defensive about that call, didn't he? Remember on cross-examination when I was asking him, can you have a conversation in 22 seconds? Ladies and gentlemen, there was a cover-up in this case, plain and simple. You'll surely say to yourself, I don't want to believe it. I don't want to believe that could happen in our community. But sadly, over the past 8 weeks, you've seen it right before your eyes. So how does a cover-up happen? How could that happen? Well, let's count the ways, shall we? Handpick your investigator. Make sure it's someone we know, someone on our side. Keep him close. Offer him help. Offer him a gift. Have secret friends and family meetings. Get your story straight. Delete your call history. Make mysterious phone calls at 2:22 a.m. Delete Google searches. Monitor police activity. Get rid of evidence. Get rid of your dog. Destroy your phones. Destroy your SIM card. For the investigator, decide on a narrative early on. Don't go to the crime scene. Don't take witnesses
Good morning.
for questioning.
Good to have you here,
Question
Bridget.
all the witnesses together. Ignore witnesses who don't fit your narrative. Allow friends and
Hello,
family to
Sweden.
contact
Good
those
morning.
same witnesses. Don't record interviews. Write
Watch the
vague and
emojis,
false
though.
police
The bot
reports.
doesn't like too
Omit
many
witnesses'
emojis.
names. Omit witnesses' interviews altogether. Don't photograph the evidence. Don't conduct any forensics. Don't document the evidence. Don't document the logs. Don't create any logs whatsoever, and don't maintain a chain of custody. Keep all the evidence in the hands of one person, and then manipulate that
Don't
evidence,
play Lally.
including videos.
But we have to edit the closings.
Don't turn over videos.
We have to edit the
Invert
closings.
videos.
It wouldn't be complete if we
Turn
didn't do Lally, right?
4:16 p.m.
We've got to do reaction
into
to Lally,
5:30
right?
p.m. in affidavits. Turn 3 pieces of taillight into 5 pieces of taillight. Delete 42 minutes of surveillance footage. Hide personal relationships. Make this case cut and dry, and ensure the homeowner, quote,
The number for
never
the
sees
egg.
any shit
That's a good one.
because he's a
Good,
Boston
good one.
cop. But most importantly, pick your patsy and pin it on the girl.
Yeah, that's my favorite part of the closing right there. I
All
love
right,
that
for
part.
my money,
That is still my favorite part of the closing. I just think it's really, really good.
And pin it on the girl.
all right, for my money, this part of the closing is my personal favorite part of the closing. And if anything, I would only want it to be a little bit more enumerated and a little bit more broken out because it was so powerful. You want to hear my thoughts on Lally's closings? My thoughts on Lally's closing roughly are... That concludes my thoughts on Lally's closing.
I really like the way that he just basically goes through, here are all the reasonable doubts in a very long list. And he shows basically shows all the reasonable doubts, just one after another, after another, after another. And he really does very well with the pacing. At points he pauses so he doesn't step on his own lines. He's very good with enunciating. He's very good with his vocal variety and presentation, very good with his energy. He breaks it up in a way that makes it very easy to listen to. This went on for quite a while. It was quite a long tape. It was, 2 minutes, 3 minutes that segment went on, but it was just so easy to listen to, and it just basically distills everything and shows you all the evidence at once. So it's like, if you needed a reasonable doubt, here's reasonable doubt 50 different ways. And so I just really like that at one point in this closing argument, he just puts them all together, and so that you can see them all together. And then of course we'll talk about them more in detail later in the closing, but to just show them all together and show them all at once so that their accumulated mass is more apparent is a very, very strong move. Maybe my only thing that I would have done differently is perhaps number them so it's more explicit that how many there are, so that you could actually count them, and then I could refer to that number at a later point in the closing. So when exactly did I start with upspeak? That's only my question right now as a creator. When did I start speaking like this? Or I inflect the end of my sentence and I inflect up? Have I been doing that for a while? If so, I need to stop because it's kind of annoying. I can actually say it, but other than that, and that's just a stylistic change. Other than that, this is my favorite part, just smashing the 799 Australian says, hi Kurt, I get needing all 12 to find guilt, but why all 12 for not guilt? There's no real answer to that question other than that's the way it is. Well, I suppose that's the way that England did it, and therefore we're stuck with it because England. So we can blame the English, which is an Australian. You should be well familiar with this concept, I would imagine. It's the English's fault. Doesn't seem not fair if 1 or 2 holdouts should be 10 out, 12 for not guilty. Anything else hung. I am not necessarily opposed to this idea. I understand this idea. It's just not the way it is. It's the damn English. Damn you, England! 8 all at once, all in one go, and you just see the holes in the colander appear. It acts as a sieve, and the case just falls through. Brilliant work on this close. Yeah, that's the money shot right there.
It's not that it could happen. It's that every single...
Did I see what Al's chat was saying during Lolly's close? No. What were they saying? What were they saying?
one of those things I just mentioned did happen.
Yep.
Right in front of you.
Yep. There you go, baby.
But this sort of injustice can't happen in a vacuum, so what about the prosecution? What about the Commonwealth? What does it look like when the government picks a narrative?
Okay. And then, like, what I can do here is I can delete this, and then I can move this clip before the other clip. It puts it technically out of sequence, but no one will know. And then it'll be a little bit more interesting on the flow. So I can put that. See, it's the magic of editing. I can move things around. Butterfly in the sky. I can move twice as high. Take a look. It's in a book. Reading Rainbow. Okay, so now that segment goes there. And then it flows into that.
And pin it on the girl. It's not that it could happen. It's that every single one of those things sort of injustice.
All right, for my... Yep, that makes way more sense. Fantastic. Editing is magic. Editing is magic. For much, too much, reasonable doubt. I love it too. The workout results notwithstanding. The workout results have been fine. The problem is I've just been overeating for way too long. So the workout results I'm not sad at. The sad part is that I'm a fat ass and I just need to work out harder. And it's been successful, and people have noticed the change in my attitude. Have noticed the change in my face. So it's not that it's been unsuccessful. It's just that I'm trying to make 150 pounds disappear. And that's hard. Because I've been overeating for too long. So it's probably going to take a hot minute. Yeah.
Justice can't happen in a vacuum. So what about the prosecution? What about the Commonwealth? What does it look like when the government
use
picks a
DaVinci
narrative
Resolve for
and then
editing
tries to form
because
a
it's free.
prosecution around the narrative instead of the other way around? Looks a lot like this. If you don't have actual evidence, just throw everything. They'll spend much of their time and resources trying to vilify
Gastric
Karen
sleeve.
Reed.
I've
They
been
desperately
very much
resorted to
trying to
calling
avoid any
witnesses
sort
to
of
talk about
surgical
Karen
option.
Reed
The
and
only,
John
the only
O'Keefe's
surgical
arguments.
option I
They
would
even
consider
stooped-
really at this point would just be liposuction, because then you could just literally suck the fat cells out of my body. But that would be like the only, and that's a non-permanent solution, which is kind of ideal. But I don't really want to do any kind of gastric bypass. I don't want to do any kind of sleeve. I really don't want to do any sort of permanent surgical options like that. There are a lot of horror stories with those kinds of options, and so I'm very hesitant to use them. So I the only thing I would consider would be like a mass liposuction and just literally suck the fat out of me. But other than that, I'm not really interested. And I hope that makes sense. There's just too many horror stories of those things going wrong.
So low as to call the children and put them through this ordeal. All to say that John sometimes got upset because Karen was too kind, too nice, spoiled them too much. Their arguments illustrated what anybody could imagine is a normal set of ups and downs for any couple. Even on January 28th, they talked it out, they communicated, they worked out their issues, and they had a nice, affectionate evening out with their friends. And you don't have to take my word for it. Pull the tape, as they say. Look at the videos. C.F. McCarthy. Waterfall.
Mm-hmm.
What are the words that every single person who testified in this case used about Karen Reed and John O'Keefe that night?
Okay.
Getting along.
Can trim out that segment. Member for 2 months. Who's been a member for 2 months? Feral Dragon's been a member for 2 months. Who says, love you, but can you tell us if the FBI can provide the proctologist the case needs? By the way, it took 9 years to lose 129 pounds. It's a journey, not a sprint. Well, I'm not sure whether to be encouraged or discouraged by that last part, but thank you anyway. The FBI's jurisdiction here is fairly minimal, but, you know, if they really want to put on a show, they could try to have some fun with it. But yeah, fair enough. You know what I'm going to do? I'm going to open up the super chats, at least in a different tab, so if I don't miss them. Have I tried 5-2 fasting? If you mean intermittent fasting, yes, I've tried that with the diet. With the diet, I've been not eating before noon. So I've not been eating before noon. So I don't eat from noon till, well, let's see. The last time I would eat would be before 10. So I'm not eating for at least 14 hours. So I'm doing the intermittent fasting with the meals too and the exercise. So I'm trying it all. So yeah, it's just, you know, it's frustrating being fat. What can you say? Let me read all the super chats so far so I make sure I didn't miss any, and then we'll keep reading them as we go. JT Goldfish has been a member for 10 months. Thank you. Miss Mandy Reacts has been a member for 1 month. Thank you very much. Bird, $4, gave me a woman holding a coffee cup that says for you. Thank you. Hilde has just became an uncivilian. I feel like I should be able to say your name and I'm failing horribly. I'm so sorry. Allison gifted 5 gift memberships. Just Gold said good morning, afternoon, morning, uncivilians. Hilde gave NOK. That's Norwegian krona, right? Hey you. Thank you for the nice pair in the exercise band. TJM for $1.99 said, ever been to Doritos Farm? It's a cool ranch. Awesome. Jennifer Adams became an uncivilian. Ashley B for $10 said, Kurt, was there a vehicle black box info that said Karen Reed was going 24 miles in reverse at the time she claimed they hit him? I vaguely remember that one of the witnesses had a chart on screen relating to this info. Not sure necessarily where it came from, if it was a black box or otherwise, but presumably it came from somewhere. Although I say presumably, like the government's been playing fair. So I think there might have been black box info. I'm not sure. I just vaguely remember it being talked about at one point, but I missed that part of the testimony. Margaret Glasser gave €20. Thanks for being you, giving me a pair looking at themselves and admiring themselves.
like Vanity Smurf, I guess. Tall Skinny Geek for $20 says, I know there's a lot of damning evidence in this trial. Not really. I don't think there is, to be quite honest. But I still think the defense proved the prosecution is guilty. They still could be very incompetent. Fair enough. I mean, I appreciate that. I mean, all you really have to know, and I've said this before, like, let's keep it simple, stupid, right? Keep it simple, stupid. Kiss philosophy. Okay. Here's the keep it simple, stupid. The state has the absolute, total, unqualified burden of proof. The defense does not have to prove anything. The state must prove guilt beyond a reasonable doubt. Thus, you must ask yourself exactly one question. Do you have doubts based on reason? If the answer is yes, you must vote not guilty. See, I told you it was simple, right? And you don't have to worry about anything else. Anything else is not, strictly speaking, within the province of this case. So the keep it simple, stupid philosophy will give you the right answer. It's very easy at the end. Nikki Lewis has been a member for 15 months. Rebecca Zarkowski. Rebecca Zakarwiski. Rebecca Zaskariski for $4.99 said 100 degrees today here in Clemson. That's way too hot for Clemson. Too hot and humid. I tend to agree. Pie Man became an uncivilian. Ashley B. Where'd you go, Ashley B? There she is. Ashley B became an uncivilian. Cece's been a member for 13 months. Emma Davis gave Australian $7.99 to say, hi, Kurt. I need getting all 12 to find guilty, but why not 12 for not guilty? Doesn't seem fair. If 1 or 2 holdouts should be 10 for 12 not guilty, anything else hung. I'm not necessarily opposed to this idea. The reason it has to be unanimous is because England, let's blame the English. I believe the Australians are also fans of blaming the English. So let's just blame the English and we can unite in our mutual loathing of the English. That will be fine. Thank you for being part of here. Feral Dragon became a member for 2 months. Love you, but can you tell us that the FBI can provide the proctologist this case needs? The FBI's jurisdiction here is fairly minimal, but we'll see. Bringing charges here is difficult for the federal government. Their jurisdiction here is very, very minimal. So it's the probability that the feds will bring charges is minimal, but you know, we'll see. I mean, they have to really show a lot to bring charges, to be fair. I mean, their jurisdiction here is very, very minimal. So the feds, you know, yeah, their jurisdiction here is minimal. I don't have high hopes, but you know, you never know. Samantha's been a member for 1 month. Jill Graceful Answer has been a member for 7 months. Parallel Jen's been a member for 17 months. Eddie's been a member for 17 months. Crypt Keeper VT has become an uncivilian. Thank you for hitting the join button. Bridget Oster became an uncivilian. Thank you for hitting the join button. D Flash 60 gave $5 to say, it just takes longer the older you get. I'm in the same boat as you. Is this to imply that I'm older? Lame. Allison for $5 said, Kurt, I just missed what the note said from the jury. The note said, can we please make sure to go home exactly at 4? We have other things to do. That's all the note said. So fine. Muzzolina for $1.99 said, did catch any of Canton's town management? I did not. I did not. Was it fun? I might have been fun. Jay Leslie gave $5 to say, go Tigers. Go Tigers indeed. What, if any, side questions, I think, said, all of our bodies unique. Do what works for you. Intermittent fasting works great for many, but eating small meals throughout the day is better for me due to health issues. Fair enough. And Buttercup 203 has been a member for 5 months. Fantastic. Now that I have this chat up in a separate window, hopefully I will not miss any of your super chats going forward. And that would be good because I want to make sure that you guys, you know, are honored for your super chats. Okay, so Zach Rawiski apparently is pronounced Zach Chefsky. Okay, I wasn't really very close. Lame. Thank you for the $1.99, Zach Chefsky. I'm not sure how chef is coming out of that combination of letters, to be quite fair, but you know, all right, fair. I mean, sure. I'm sorry, my bad. Yeah. Yeah. All right, let's see. And also I wanted to talk about my merch store. So let's talk about my merch store for a while
because there's some good merch, and you should check out the pinned comment. The pinned comment would be a good thing to do. Let's talk about my merch store. Oh dear, how do I make this like not horribly big? Hold on. All right. All right. The pinned link will take you to the Uncivil Law merch store. Callie the Beefish welcomes you to the Uncivil Law merch store. We have some cool stuff, in my humble opinion. First of all, we got this nice little black uncivilian shirt, very sort of subtle with it. I kind of like this. It's just because it's subtle, you know, uncivilian with gray on black with the logo. Kind of understated. I think it's kind of cool. I hope you think it's kind of cool too. My personal favorite item on the store. This is actually my personal favorite item, and I'm getting one. I'm getting the large mouse pad. It's just a mouse pad, but it comes in two sizes. It comes in roughly square and big ass rectangle. And I'm going for big ass rectangle. Why? Because I literally sit at my computer every day, all day basically, because I'm a streamer, editor, and all the rest of it. And so I can literally look at this mouse pad because I will literally use it all the time, constantly. And I can learn from the misfortunes of others. I mean, what is not to be celebrated by this mouse pad? This is the best mouse pad of all time. You should buy one. Or if you prefer just the logo mouse pad, we have just the logo if you like that way. We have the evidence collection cup sticker that you can apply to whatever. You can put it on your laptop or your notebook or your office door, the nameplate by your office door. That'd be good. Right, just there at work where your nameplate is, just stick it right on the nameplate. That'd be fun. You could put it on memos. You can put it in your correspondence. All kinds of things for the sticker. It's all kinds of great sticker. But of course, the most popular item on the store, the one that has sold the best, is the evidence collection cup. Yes, my friends, it is true. You yourself can have a glass solo cup. It now comes in glass form. Amazing. And you can use it for all your evidence collection needs. You will see here that it is property of the Canton PD, but that is okay. You can have your own. I have managed to somehow acquire from the Canton Police Department, don't ask how, but I've somehow acquired this wonderful, wonderful cup that is available for you and all your evidence collection needs. It is an awesome cup. You should buy it. Limited edition item, though. This item will be removed from the store very soon. Not necessarily when the trial ends, but it's coming to a close. We have the very limited edition Canton CSI sticker. It's holographic, it's shiny, and it features the Canton CSI official logo, which is, of course, a Stop and Shop bag and a solo cup, because of course it is. So you can have that, and you, again, stick it to your notepad, your laptop, your door plate at work. You put it on your car. If you're in Canton, that'd be good. Maybe just put it on your bumper or your glass of your car in 5x5 form, and you can show your love for the Canton CSI. It'll be great for all your needs there. We also have the Learning from Misfortunes Others mug and some stuff in purple. Don't forget, of course, the Taint Team Data Scrubber mug. You too can be part of the Taint Team. If you like, Callie the Beefish knows all about the Taint and is more than happy to introduce you and welcome you to the Taint Team so that you can have that mug in your life. Plus, we have this wonderful Uncivil Law logo. I like this one. It's very Western themed. Uncivil Law, legal education with an edge themed. Texas with the hat. I mean, what's not to love there? And the same logo again on a tumbler, plus some pint glasses. There's some cool stuff in there. Please check out the shop, and I hope that you like it. All right. Well, my friends, we're coming up on the top of the hour. So that means it's Supreme Court time. Supreme Court time. Supreme Court time. All right, for those of you who don't remember or have never seen this before, we're going to do a Supreme Court speed run. Here's what we're going to do. The Supreme Court starts releasing decisions at 10 a.m. when they release decisions. They're releasing decisions every day this week. And we're expecting something like 5 decisions to drop this morning. They usually take about 10 minutes. between decisions because they have to read it from the bench and it takes a little time. So that gives me, so we're doing a Supreme Court speed run. That gives me 10 minutes to read, understand, and explain a Supreme Court decision to you before we move on to the next Supreme Court decision. It's a fun challenge for me because it's like, well, how much of an expert am I? Really? It's like, how much of an expert am I? Can I read, understand, and redistill this to you in 10 minutes or less? So it's a good little challenge for me, and we're going to do a speed run. So it'll be fun. All right, let's see. Exercise is the only sensible way to lose weight. Well, I'm not sure necessarily that's true. I think it's more diet related, but either way, I've been doing exercise, and you can check out my community tab. Although to be fair, I haven't been very good about it in the past couple days. I've been lazy, but we will get back into the swing of things. So I appreciate your super chat. What are they deciding? We don't know what. We don't know what they're deciding because they don't tell you what decisions they're coming down with. You just have to wait and see. So I don't know what they're deciding. It will be a surprise to literally everybody. I don't know. We'll find out together. That's the fun. If I knew what they were deciding, I could maybe do some kind of prep. Right? If I knew what they were deciding, I could like look and research the case and find out about it in advance and do some kind of prep so that I, know exactly what the hell's going on. But I can't do any of those things. So it makes it a fun exercise for us all. All right, we are at SCOTUS blog, which is not official, but they do little verdict watch announcements. So we're going to get our links and stuff from SCOTUS blog and go from there. Kylie needs something. I can't quite read the last of your name. For $7.99 Australian. It says, hope the verdict is in before I take the kids away, so I'm not checking my phone every notification. I booked activity like koala cuddles. Koala cuddles sound awesome. The verdict is not more important than koala time. Although be careful of the chlamydia. All right, we have our first decision. Let's read. Murthy, Surgeon General versus Missouri. Okay. Under the longstanding content moderation policies. Okay, this is a big case. This is a big case. All right, I know exactly what they're talking about already. All right, during the time of the unfortunate disease that paralyzed the world, the federal government was arguably putting pressure on social media to not publish certain things relating to the unfortunate event that was happening in the world. Now, there's a line here about where they can do this and they can't do this. But there seemed to be some evidence that the federal government was crossing the line and was entering into forbidden First Amendment territory. So we're going to find out if there's evidence that the government violated the First Amendment when it came to their interactions with social media, it sounds like. All right, great. In 2020, with the outbreak of a certain disease, the platformers announced that they would enforce policies against users who post false or misleading content about the disease. The platforms also applied misinformation policies during the election season. During that period, various federal officials regularly spoke with platforms about the disease and election-related misinformation. For example, White House officials publicly and privately called on the platforms to do more to address vaccine misinformation. Are they merely using the bully pulpit, or are they being a bit more coercive? How is this line looking? Yeah. For example, White House officials publicly and privately called on platforms to do more to address the vaccine misinformation. The Surgeon General issued a health advisory that encouraged platforms to take steps to prevent disease misinformation from taking hold. The Center for Disease and Disease Control alerted platforms to misinformation trends and flagged example posts. They are directly saying what posts are and are not misinformation. Okay, the federal government is encouraging them not to spread misinformation, and they themselves are designating what is and is not misinformation. and suggesting the social media platforms not publish certain content. This sounds like a First Amendment problem. This sounds like a First Amendment problem. All right. The FBI and the Cybersecurity and Infrastructure Security Agency communicate with the platforms about election misinformation in advance of the election. The FBI. So now we're using a law enforcement apparatus to provide suggestions. Yeah, good times. The respondents are 2 states and 5 individual social media users who sued dozens of executive branch officials and agencies, alleging the federal government pressured the platforms to censor speech in violation of the First Amendment. Following extensive discovery, the district court inserted a preliminary injunction. Hey, federal government, stop doing that. The Fifth Circuit affirmed. The court held that both the state plaintiffs and individual plaintiffs had standing to seek relief. On the merits, the court held that the government entities and officials, by coercing or significantly encouraging the platform's moderation decisions, transform those decisions into state action. That is a thing that can also happen when there is enough interaction between a private entity and a governmental entity. The private entity can be deemed to be a state actor, which means they can be sued for a 1983 violation, because 1983 requires you to act under color of law. Normally speaking, of course, a private party such as Facebook is not a color of law because they're not the government. Normally they're not the government. But if they become intertwined enough, if they become involved enough, if they become close enough, then guess what? Congratulations, you're the government too now, which means we can sue you for acting under color of law because you're now the government. Congratulations, Facebook / whomever. Yeah, that is a thing. Okay. The court then modified the district court injunctions to state defendants shall not coerce or significantly encourage the companies to suppress speech. And then the court says there's not standing. That's very disappointing. There's no standing. That sucks. So they don't have a basis to sue. That sucks. Let's find out why. What? Court's back? Not on my end yet. Are we not doing Supreme Court speed react? They had an argument in court. They had an argument in court I missed? Okay, they did. I'm sorry. I apologize. We'll go back. This is interfering with my speed run. Karen Reed is interfering with my speed run. I'm trying to do speed run time.
What is back to session? You may be seated. 22117.
All right, so why are we out here?
Your Honor, I just saw the verdict forms, and as we discussed yesterday, the amendments the court indicated it would make.
Oh, no. Okay, I did not say I'd make it. I said I'd think about it. I said I was tired and I needed to think about it.
You said before you were tired and you needed to think about it was you agreed that there needs to be not guilty options for subordinate charges under count 2.
I said that it made sense to me, but no, I did not change it upon looking at it because this verdict slip as submitted to the jury is exactly how it always is in Massachusetts.
I ask you a question then. I don't really care how it always is in Massachusetts. I care about whether or not it's appropriate.
It's appropriate.
Different things.
It's appropriate.
Let me make my argument, if you wouldn't mind, Judge, why it's not appropriate. For a superior charge, they have to decide that she is not guilty of the superior charge, and that is the starting point of whether or not she is guilty or not guilty of any subordinate charge, often called a lesser included. Once they decide that she's not guilty of the superior charge, now there's two additional charges that they've been instructed they must decide whether she's guilty or not guilty of. How do they decide that she's not guilty of the first subordinate charge, involuntary manslaughter?
Okay. Anything else you want to say, Mr. Jackson?
I'd like an answer from the court. How do they decide that she's not guilty of involuntary manslaughter on that verdict?
That's their decision to make.
And how do they make it if they don't have an option to check a box that says not guilty?
They don't check the box that says guilty, do they? And then when they go to the next block, they don't check the block that says guilty, and on the top, you're left with not guilty. Okay?
So it's the absence of the check mark that the court determines is the not guilty finding by the jury.
Yes, that's what the verdict slip reads. It reads not guilty. If they don't check block 2, 3, or 4, the verdict slip reads not guilty. Okay? That's how it is, Mr. Jackson.
Well, apparently that's how it's going to be because of the court's order. That is not how it should be, and it's over our strong objection. They need to see that there is a not guilty option for the subordinate charges. If they come back guilty on, for instance, involuntary manslaughter, that's immediately appealable. They didn't have an option on the verdict form to find her not guilty. It's almost like the court is directing a verdict of the subordinate charges.
Okay. I disagree with you. Ms. Giannetti, you've seen verdict slips exactly like this. Okay?
I actually haven't really.
Have you had no lesser includeds?
No, we've always had lesser included, but I have not seen a verdict slip there where not guilty is not an option for the rest.
Okay. I disagree with you. All right. Excuse me? This is funny, Ms. Reed? All right, we're done.
It is a little funny, to be honest.
To the court, please.
It's absurd. Well, just when I thought this case couldn't get any more stupid, apparently not guilty is literally not an option. Just when I thought the state case couldn't get more stupid, not guilty is literally not an option. What do I think? I think it doesn't make sense. You're literally, there's only one checkbox. There's only one checkbox, guilty. Yeah, I'm kind of with how is the jury supposed to find not guilty? Well, all they do is they don't check the box. Yeah, no, yeah, that seems like an error to me. That seems error to me. I'm just going to need a moment to myself here, guys, because that was... I just need a moment to myself. Is that reversible error? Yeah. Yeah. You're literally not giving the jury the option to find not guilty. You're literally not giving them the option. How could that not be appealable error? Yeah, Jackson's right. Right? Jackson's right. The only way you get to the lesser included is by finding not guilty on the parent. That's what makes it a lesser included. Right? If you find guilty on the parent, it necessarily is guilty of all the lesser includeds because they're lesser includeds. So that's logical, right? To find guilty on the parent is to find guilty on all the children. That makes sense. That makes sense. But if you find not guilty on the parent, it doesn't really imply anything about the children. Guilty implies something. Not guilty does not imply something. So now, having found not guilty on the parent charge, you now need to go to the child charge and now consider that charge unto itself as a separate charge, which it now is. And you get to the bottom of the thing and it says guilty, and it doesn't provide a not guilty option. That's obviously error. That's obviously error. So, yeah. My email address and my contact information is available on my About page on my YouTube. It's available on my link tree. So, there's no way Karen will win an appeal if found guilty. Oh, I disagree with you, my friend. I disagree with you, my friend. She should win an appeal. Yeah, and she probably has a pretty good shot at a habeas as well.
because this case is so fucked up. Yeah. Anyways, pressing back to Supreme Court time when I'm trying to determine why there's not standing in this case. Yeah. We can talk a little bit about lesser includeds before we go back to Supreme Court time. Right? So a lesser included just means there's less things, because what makes a lesser included is that it has fewer things than its parent. You're just dropping things along the line. So suppose the parent charge has 5 elements. Okay? Suppose it has 5 elements. Then the child charge would have, say, 4 elements. All 4 of those elements are in the parent. Okay? It just lost an element along the way. It changed something in a lesser way. It had to decrease. So maybe it changed the mental state from, for example, intent to reckless, right? That would be a decrease. It decreases. Intent implies reckless because it is more severe, right? Because it goes down, but not the other way around. Intent implies reckless. So if you had a parent charge that said intent and the child charge said reckless, it's lost an element. It's lost the element of intent and replaced it with the lesser element of reckless. So to find the parent charge implicitly finds all the children, because all the children, what makes them lesser included is that every element in the child is in the parent, but not the other way around. Every element in the child is in the parent, but not the other way around. So by finding the parent, you find every element of the child, but not the other way around. So that's what makes it lesser included. So from a charging stand frame, it is typically the law in every jurisdiction that I'm aware of that being charged with a parent is sufficient notice of being charged with all the children because they're included. And therefore you can ask for lesser includeds because you were charged with them the whole time because they were lesser includeds. They were always there. They were just implied. And so they're necessarily implied. And so that's what makes it lesser included. But the defense is right that so if you find guilt on the parent, you have implicitly found guilt on all the children, because if you found every element of the parent, you've necessarily found every element of the children because they were there the whole time. But the other way around isn't implied, right? If you find not guilty of the parent, that isn't implied because, well, what element did you miss, right? It's unclear. It's not clear what element you missed. So not guilty doesn't imply anything about the children. So now having dismissed the parent charge, you are now faced with the child charge unto itself. It is now a standalone, as if it was brought completely on its own. And so now you're asked, okay, do you find these elements? And you're literally not given an option of not guilty. You're literally not presented with the option. That doesn't make any sense. And the judge is like, well, all they have to do is not check the guilty box. I'm like, well, that's kind of confusing, isn't it? It's a little bit confusing. Leandra has been a member for 10 months. Kevin's becomes uncivilian. Leandra's gifted 20 gift memberships. Emma Daisy for $2.99 said England's fault again. This one is not England's fault. This is some Massachusetts bullshit. Red guy 123444321. Court prejudicing for guilty. Say it ain't so. That sounds a lot like what they're doing. It does look suspiciously like a directed verdict for guilty, which is very, very illegal. Carton Luna became an uncivilian. Jesse Golightly became an uncivilian. Leandra 999 said, unlike the jury, you have a chance to show your appreciation. Hit the thumb up. And say, why do Karen's lawyers do this in this situation now? Well, because they just know about it now. There was no reason that they would know about it. Because they just got the form. And they apparently did raise the issue before. They raised the issue before. And the judge said, well, they think about it and apparently decided against it. So they're like, wait a second. You didn't do what we said. So that they're timely. They're raising the issue in a timely manner. But yeah, this is some fucked up shit. This is some pretty fucked up shit. So your odds of conviction just went up from pure error now.
Your odds of conviction just went up from pure error. Yeah, that sucks balls. Excuse me. All right. Megan Farewell gifted 10 gift memberships. Thank you very much. I'm going to try to get this anger out of my soul very hard and move on to something else. All right, let's go back to Supreme Court as I try to understand the standing issue on the whole social media thing. Jonathan Aguilar gave $5 to say, I wonder what actor would best fit the part of Bev in the Karen Reed Netflix documentary. Bozo the Clown's dead, right? So I don't think it can be him. Moving back to Supreme Court analysis, where I was trying to decide, trying to understand why these people don't have standing to raise the issue. Article 3's case or controversy requirement is fundamental to the proper role of judiciary. I agree. A proper case or controversy exists only when at least one plaintiff establishes they have standing to sue. That is, they've suffered or will suffer an injury that is concrete, particularized, and actual imminent. Are they going to say it's not particularized enough? Is that what they're going to go with? All right. Fairly traceable to the challenged action or addressable by a favorable ruling. Here, the plaintiff's theory of standing depends on the platform's actions, yet the platforms do not seek to enjoin the plaintiffs from restricting any posts or account. Oh, they don't seek to enjoin the plaintiff. They didn't sue the social media companies? Oh, okay. So they didn't sue the right people. Oh, okay, that kind of makes sense. All right, that kind of makes sense. They didn't sue the right people. All right, that kind of makes sense. All right, where were we? Here, the plaintiff's theory of standing depends on the platform's actions, yet the plaintiff did not seek to enjoin the platforms from restricting any points or accounts. Instead, they seek to enjoin the government agencies and officials from pressuring or encouraging the government officials to suppress speech in the future. The one step removed anticipatory nature of the plaintiff's alleged injury presents two challenges. Yeah, they fucked up on the lawsuit. That's what happened. Yeah, they didn't sue the right people, and they were only seeking apparently future relief. They fucked up. They didn't apparently sue the social media companies, and they apparently didn't seek declaratory relief, which would have given them standing. They fucked up in the lawsuit. Lame. First, it's a bedrock principle that a federal court cannot redress injury that results from independent action of some third party not before the court. That's fair enough. Second, because plaintiffs request forward-looking relief, they must face a real and immediate threat of repeated injury. Fair. They apparently did not seek the past relief. They did not seek past problems. They only sought future problems. Yep. That sucks. Putting these requirements together, the plaintiff must show a substantial risk that in the near future, at least one platform will restrict the speech of at least one plaintiff responsive to actions of at least one governmental defendant. Here, the preliminary injunction stage, they must show they're likely to succeed. On the record of this case, that's a tall order. Yeah, that makes sense. Okay, that's annoying. $1.99 from Greg that says, hopefully the jury has the same question. I hope so too. Fatal Bite became an uncivilian. Jay McCarthy became an uncivilian, actually slightly better, joined one of our upper membership tiers. He joined a higher membership tier than a mere uncivilian. He has become an uncivil posse member. Highly appreciated. We do enjoy everyone who joins at those higher tiers. Emma David gifted a very generous 50 gift memberships. Thank you very much, Emma. Mad Mods for You became an uncivilian. Thank you very, very much. Yeah. No, I don't want chat on screen. That's what I'm trying to do. Trying to put the donation alert on screen. There we go. All right. All right, cool. Now I got the donation alert on stage. Jinx became a member. Awesome. We like Jinx. Anyways, continuing on with this. The court considers whether the plaintiffs have demonstrated traceability for past injuries. Because the plaintiffs are seeking only forward-looking relief, the past injuries are relevant only for predictive value. The primary weakness in the record of the past restrictions is a lack of specific causation with respect to any discrete instance of content moderation. And while the record reflects the government deliberate defendants played a role in at least some of the platform's choices, the evidence indicates the platforms had independent incentives to moderate content and often exercise their own judgment. I don't think that's enough, incidentally. I'll disagree with the Supreme Court on that part. That doesn't sound right. The Fifth Circuit, by attributing every plaintiff's decision, at least in part to defendants, glossed over complications in the evidence. The Fifth Circuit also erred by treating the defendants, plaintiffs, and plaintiffs as a unified whole. Because standing is not dispensed in gross, plaintiffs must demonstrate standing for each claim they press. This requires a threshold standing that a particular plaintiff pressure a particular platform to censor a particular topic before the platform suppressed the speech on that topic. Complicating the efforts to demonstrate that each platform acted due to government coercion rather than its own judgment is the fact that platforms began to suppress the plaintiff's content before the challenge communication started. I disagree with the Supreme Court on that. That doesn't make sense. I disagree. Just because they were doing it on their own, I don't think gets the government off the hook. Because the problem is the entanglement. That's the problem to me, right? If they're making the decisions on their own before the government gets involved, then it's a purely private decision. That's fine. But once the government gets involved and they get entangled, that doesn't matter anymore, at least to me, because the government is now entangled. And they're now the government because they're entangled. So their independent decisions are now governmental action. So I disagree with the Supreme Court on that. I don't agree. The plaintiffs fail by and large to link their past social media restrictions and the government defendant communications with platforms. The state plaintiffs, Louisiana and Missouri, refer only action taken by Facebook against Louisiana state representative post about children and the disease. But they never say when Facebook took action against the post, a critical fact in establishing a causal link. Okay. Nor have three plaintiff doctors established a likelihood that past restrictions are traceable to either the White House or CDC. I don't agree. They highlight restrictions imposed by Twitter and LinkedIn, but point only to Facebook communications with White House officials. Plaintiff Jim Hoft, who runs a news website, experienced election-related restrictions on various platforms. He points to the FBI's role in platforms' adoptions of hacked material policies and claims that Twitter restricted his content based on those policies. Yet Hoft's declaration reveals that Twitter took action according to its own rules against posting private, intimate media without consent. Hoft does not present evidence his past injuries are likely traceable to the FBI. Plaintiff Jill Hines, a healthcare activist, faced restrictions on Facebook. Though she makes the best showing of all the plaintiffs, most of the lines she draws are tenuous. But we're on a preliminary injunction stage. Okay. The Idaho mom reports became an uncivilian. Thank you very much. Plus, Facebook started targeting her content before almost all the communications with the White House and CDC, thus weakening the inference her subsequent restrictions are traceable. I don't agree with the Supreme Court. Even assuming Hines can eke out a showing of traceability, the past is only relevant insofar as it predicts the future. So if they didn't seek declaratory relief, if they really fucked up that hard and didn't seek declaratory relief, which would be amazing if they didn't, but if they didn't seek declaratory relief, then I'll agree with the Supreme Court. But if they did seek declaratory relief, which would be truly amazing if the attorneys didn't seek declaratory relief, because why wouldn't they? But I've seen it done. I've seen this fuck up before, so it's possible. But if they didn't ask for it, then fine. If they did ask for it, I don't think I agree. To obtain forward-looking relief, the plaintiffs must establish a substantial risk of future injury that's traceable to the government and likely to be redressed against an injunction. The plaintiffs who have not pointed to any past restrictions likely traceable to the government, see, I disagree.
are ill-suited to the task of establishing their standards to seek forward-looking relief. But even Hines, with her superior showing on past harm, has not done enough to demonstrate likely future harm. If all they asked for was prospective relief, then I would agree with the Supreme Court. If they were really that dumb and only asked for prospective relief, I'd agree. But their attorneys would have to be pretty stupid to not ask for declaratory relief, although I've seen it happen before. On this record, it appears that frequent, intense communications that took place in 2021 between the government and the platforms has considerably subsided when they filed suit. If it was only forward-looking, I'd agree. If they failed to ask for declaratory relief, I'd agree. Otherwise, I disagree. There's no more conjecture to assume that Hines will be subject to the government in the future. The plaintiff's counter-arguments are unpersuasive. First, they argue they suffer continuing present adverse effects from their past restrictions, as they mount a self-censor on social media, which is usually a pretty good argument in the First Amendment arena. But plaintiffs cannot manufacture standing merely by inflicting harms on themselves based on fears of hypothetical future harm that's not impending. That's not really true in First Amendment land, to be honest. The idea of the chilling effect with respect to First Amendment typically goes a bit further than this in the case law. So I don't think I agree with that either. Second, plaintiffs suggest that platforms continue to suppress their speech according to policies initially adopted under governmental pressure. But plaintiffs have a redressability problem. Without evidence of continuing pressure, the platforms remain free to enforce or not enforce their policies, even those tainted by initial governmental coercion. I'm not sure I agree with that either, to be honest. And the available evidence indicates the platforms have continued to enforce their policies even as the federal government wound down its own measures. Enjoining the government defendants, therefore, is unlikely to affect content moderation decisions. The plaintiffs next argue a right to listen theory of standing. The individual plaintiffs argue the First Amendment protects their interest in reading and engaging with content of other speakers. This theory is startlingly broad, as would grant all social media rights the right to sue over someone else's censorship, at least as long as they claim an interest in the speech. While the court has recognized a First Amendment right to receive information and ideas, the court has identified cognizable injury only where the listener has a concrete, specific connection to the speaker. Okay, I mean, fair enough. That's fair. Attempting to satisfy this requirement, the plaintiffs emphasize that hearing unfettered speech on social media is critical to their work as scientists, pundits, and activists, but they do not point to any specific instance of content moderation that caused them harm. They have therefore failed to establish injury that's sufficiently concrete and particularized. The state's plaintiffs assert sovereign interest in hearing from their citizens on social media, but they have not identified any specific speakers on topics they've been unable to hear or follow. And states do not have third-party standing as parent parente to bring action against the federal government on behalf of their citizens who face social media restrictions. Oh, okay. Reversed and remanded. Barrett follows an opinion of the court in which Roberts, Sotomayor, Kagan, Kavanaugh, and Jackson join. Alito dissents, in which Thomas and Gorsuch join. Yeah, I don't think I agree with that one. I suppose it depends how dumb they were in their lawsuit. So I'd have to go back to the original papers. It depends how dumb they were. If they really only asked for forward-looking relief, then I guess. If they were that dumb. But if their attorneys were dumb enough to not ask for declaratory relief, I'd be truly amazed, although I have seen it before. But I don't agree with large parts of the analysis on the assumption that their attorneys asked for declaratory relief and for compensation for past injury. Yeah, so I disagree. I don't agree with that decision. Okay, fine. Let's cover another Supreme Court case. Let's see. Okay, what's next? What is today? The 26th? There's only one other decision that came down today? Oh, I was expecting more to come down today. Okay, there's only one other decision that came down today. Okay, we read that one. What was the other one? Snyder versus United States came down today?
Okay, this will be fun. Maybe. All right. This is trying to determine whether a bribe is a bribe. Okay. A governmental official was convicted of taking a bribe. His argument was that he only received the money after he did the thing. It wasn't money given in advance. It wasn't quid pro quo. He only received the money afterwards. So it wasn't a bribe. It was merely a tip. That was what he went with. Yes, I received the money, but I only received the money after I did the thing. So it didn't induce me to do the thing. So it's not a bribe. Okay, Supreme Court, let's see what you got on this one. Let's figure out whether or not, let's figure out whether or not Trooper Proctor was being bribed, I guess. Hey, Lord. Federal and state law distinguish between two types of payments to public officials: briberies and gratuities, otherwise known as a tip. Bribes are typically payments made or agreed to before an official act in order to influence the public official with respect to a future act. Gratuities are typically payments made to a public official after an act as a reward or token of appreciation. Okay. While American law generally treats bribes as inherently coerced, corrupt, and unlawful, the law treats gratuities as more nuanced. Some gratuities might be innocuous, and others might raise ethical and appearance concerns. Federal, state, and local governments have drawn different lines on which gratuities and gifts are acceptable and which are not. For example, Congress has established a comprehensive prohibition on both bribes and gratuities to federal officials. If a federal official accepts a bribe for an official act, federal bribery law provides a 15-year maximum sentence. By contrast, if a federal official accepts a prohibited gratuity, the federal gratuity law sets a 2-year maximum sentence. In 1984, Congress passed and President Reagan signed into law as 18 U.S.C. 666, as relevant here, extended the gratuities prohibition to most state and local officials. Congress reversed course after 2 years and amended 666 to avoid the law's possible application to acceptable commercial and business practices. As amended, the text of 666 now closely resembles the bribery provision for federal officials, which makes it a crime for most state and local officials to corruptly solicit, accept, or agree to accept anything of value intended to be influenced or rewarded in connection with any official business or transaction worth $5,000 or more. The crime carries a 10-year maximum sentence. This case involves James Snyder, who was the former mayor of Portage, Indiana. In 2013, while Snyder was mayor, Portage awarded 2 contracts to a local truck company, Great Lakes Peterbilt, and ultimately purchased 5 trash trucks from the company for about $1.1 million. In 2014, Peterbilt cut a $13,000 check to Snyder, the person who had just bought their trucks. How nice. The FBI and federal officials suspected the payment was a gratuity for the contracts. But Snyder said the payment was for consulting services as a contractor for Peterbilt. It has nothing to do with my job as mayor. I just also happen to work as a contractor for the company on the side, which incidentally kind of seems to reflect a conflict of interest. If you really are both, if you're really both the mayor and also in your spare time a contractor for Peterbilt, then it seems like a bit of a conflict of interest is if mayor, you just happen to buy trucks from Peterbilt. That seems slightly problematic. Okay, but that's what he's going with. It wasn't a bribe, it was for my consulting work. Cool. All right. The federal grand jury ultimately convicted Snyder of accepting an illegal gratuity in violation of 666. The district court sentenced him to 1 year and 9 months. On appeal, Snyder argued that 666 criminalizes only bribes, not gratuities. Yeah, as I said, he took the money afterwards, so it's totally cool. Yeah. On appeal, yeah. The 7th Circuit affirmed the conviction, held Section 666 prescribes, which is to say forbids, bribes to state and local officials, but does not make it a crime to accept gratuities. Holy shit.
Okay. I mean, all right, fine. So, you know, that gift to Proctor was apparently fully legal because it's not a bribe. It's only a gift after for a good job done. Okay, I suppose I owe Proctor an apology. I had previously in previous videos referred to him, I've referred to it previously as a bribe. I have been corrected by the Supreme Court. It is not a bribe, it is a mere gratuity. I apologize for my previous legal error. All right, 6 reasons taken together lead the court to conclude the statute is bribery statute and not a gratuity statute. Text, statutory history, statutory structure, statutory payments, federalism, and fair notice. The statutory text strongly suggests that the law is a bribery statute, not a gratuity statute. The dividing line between the bribery provision and the gratuity provision is a bribe requires the official to have a corrupt state of mind and to accept or agree to accept the payment intending to be influenced in the official act. By contrast, this law bears little resemblance to that law, which contains no express mens rea requirement. The statutory history reinforces the result. When enacted, 666 borrowed language from 201, the gratuity statute for federal officials. 2 years later, Congress amended 666 to model instead on 201B, the bribery statute. It would be strange to interpret 666, as the government suggests, to mean the same thing now it did before the amendment. I suppose that's fair enough. This is a statutory thing. I can't believe Congress did that, but apparently Congress did that. Congress is okay with the after-the-fact gratuities. Not before-the-fact bribes, after-the-fact gratuities, which are totally different. Totally different. Statutory structure reinforces that 666 is a bribery statute, not a 2-for-1 bribery and gratuity statute. The government identifies no other provision in the U.S. Code that prohibits both bribes and gratuities, and 201 does not do so. That's because bribe and gratuities are 2 separate crimes with 2 different sets of elements. For federal officials, Congress has separated bribe and gratuities into 2 distinct provisions. The crime receives different punishments that reflect their relative seriousness. For example, accepting a bribe is punishable by up to 15 years, while accepting a gratuity is punishable by only 2. If the government were correct that 666 also covers gratuities, Congress would have inexplicably authorized punishing gratuities to state and local officials 5 times more severely than gratuities to federal officials. The government cannot explain why Congress would have created such a substantial sentencing disparity. Yeah. Interpreting 666 as a gratuity statute would significantly infringe on a bedrock federalism principle. So they're about to say that Congress can't even do this even if they wanted to? Is that what they're going to say? Okay, let's go with that. Generally, states have prerogative to regulate the permissible scope of interactions between state officials and their constituents. The differing approaches by the state and local governments reflect policy judgments about when gifts expressing appreciation to the public officials for their past acts cross the line from the innocuous to the problematic. Those carefully calibrated decisions would be gutted if the court were to accept the Congress's interpretation of 666. Reading 666 to create federal prohibition on gratuities would suddenly subject 19 million state and local officials to new and different regulatory systems for gratuities. The court should hesitate before concluding that Congress prohibited gratuities that state and local governments have allowed. After all, Congress does not lightly override state and local governments on such matters. Okay, that's fine. The government's new interpretation of the statute would create traps of the unwary state and local officials. The government says the statute would not cover innocuous or obviously benign gratuities, but the government does not identify any remotely clear line separating such a gratuity from a criminal gratuity. The government simply opines that state and local officials may not accept wrongful gratuities. The government's so-called guidance would leave the state and local officials entirely at sea to guess about what gifts they're allowed to accept under federal law, with a threat of up to 10 years in prison if they happen to guess wrong. That is not how federal crime works. And the court has rejected the view that it should constitute a criminal statute on the assumption the government will use it responsibly. I mean, that's fair enough as far as it goes.
Faced with the phalanx, I like that word, phalanx, that's a nice word choice. Faced with the phalanx of difficulties with interpreting of 666, the government argument boils down to one main point, that 666 uses the term rewarded as well as influenced. The government says that Congress would not have added the term rewarded to influence in 666 if the statute were meant to cover only bribes and not also gratuity. This argument is misconceived. Contrary to the proposition of the government's argument, bribery statutes sometimes use the word reward. Moreover, without the term rewarded, an official might try to defend against bribery by saying the payment was received only after the official act and therefore could not have influenced the act. By including the term rewarded, Congress made clear the timing of the agreement is key, not the timing of the payment. Although gratuity or reward offered and accepted by a state or local official may be unethical or illegal under other law, it does not violate 666. Kavanaugh delivers the opinion of the court in which Roberts, Thomas, Alito, Gorsuch, and Barrett join. Gorsuch files in a concurring opinion. Jackson, Sotomayor, and Kagan dissent. Okay, bribes are legal. Bribes are legal. So if you're a state or local official, you just have to not agree to it beforehand. You just have to not agree to it beforehand. And if they suddenly give you money, maybe if you receive money after the fact, maybe it might encourage you to give them future contracts in the future. But it's not quid pro quo, right? It's not quid pro quo. You've just received a tip for good service, and now you're incentivized to give more service in the future. Okay, well, that's a thing that happened. All right, well, conviction reversed. Good news. I incidentally don't necessarily have a problem with this from a legal perspective, because it sounds like Congress did a dumb. Although, of course, Congress can't do a dumb. I am sorry. I apologize. Congress can't do a dumb. That was a mistake on my part. Congress is a wise Congress. And Congress, in their infinite and unchallenged wisdom, decided to remove language from the statute. See, initially, they put in the language, and then they thought better of it. And there's like, we're a wise Congress, and our wisdom has come to us perhaps a bit late. But we're a wise Congress, and in our wisdom, we've decided that this language should not be in the statute anymore. And so the government tried to basically have their cake and eat it too. It's like Congress removed the language, but we still like to convict them anyway. And the Supreme Court's like, no, you can't do that. So I don't necessarily have a problem with this on a legal interpretation. I suppose my ire is more directed at Congress, which apparently decided that bribes are A-okay. So, noted. Of course, we have to interpret the law faithfully regardless of what we like. We should obviously say that, right? This may not be what you want to be. It's not necessarily what I want to be. But of course, as Justice Scalia once famously opined, a judge who always rules the way they want is not necessarily a good judge. So while I will chide the Supreme Court, depending on the pleadings in the other case, here I probably would agree with the Supreme Court in the end. So if I, at least based on the abstract, right, I probably would agree with the Supreme Court in the end if I were a justice. But that doesn't necessarily say I'm happy about it. It's just to say, well, I have to do what the law requires. And Congress, in their infinite wisdom, removed the language. So I can't hold them guilty on language that's no longer there. So, fair enough. Fair enough, I guess, as far as it goes. All right. Deanna Zandy became an uncivilian. Bulldog Mom D became an uncivilian. April Singh's gifted 20 gift memberships. Thank you very much for the thoughtful memberships. This is my full-time career at this point, so I really do appreciate your continuing support. It means a whole lot to me. So every way that you can support me is appreciated. And the 99 cents, of course, isn't a lot individually, but by your powers combined, it can feed an Uncivil. So, please throw 99 cents in the hat It is appreciated. Rachel L gifted €5 to say ha ha ha, and Emma Davis gave $7.99 Australian to say there is a not guilty option. Defense are arguing it should say not guilty of the offense charge and any lesser included offense. If that's true, if that's what's going on, then I would agree with the court. But I didn't understand that to be the argument. So if I misunderstood the argument, then fair enough. If there is in fact a not guilty option when it comes to the lesser includeds, then fair enough. But that isn't what I understood the court. That isn't what I understood to be the argument. So if I misunderstood the argument and there is a not guilty option for the lesser includeds, if that's on the jury form, then I will agree with the court. Then the court is correct. If there's not a not guilty option for the lessers, I will not agree with the court. So that, you know, that would be my delineation. The form is available. The actual form in this case is actually available. Is it on the docket? If so, I'd be happy to double check and so we can make sure. So, does any of my mods happen to have a link or a PDF that they can, if it has the stamp on it, you know, that says filed with the court? If anyone can on Discord provide me the PDF that, you know, is stamped, you know, with a court stamp or a suitable link, I'm happy to check, and then I can give you a firm opinion. The jury form's on Twitter. Is the jury form on Twitter stamped? Is it stamped? Because if it's not stamped, I'm not reading it. Could the feds sue the state police and DA on civil rights violations? Gender bias? Probably not gender bias. No, not specifically. Due process violations would be more appropriate. Other channels are reviewing it. Legal Bites has it. Okay. I mean, we can go check, but if it doesn't have a stamp, I'm skeptical. All right, let's go see if we can find it. Let's go see if we can hunt it down, and we'll talk about it. It's available? Okay, again, if someone on Discord could provide me the link or the form, that would be very, very helpful. Because otherwise I have to go hunt it down and I have to go faff around for a while. So if someone could provide it to me on Discord, I'd really appreciate it. You can provide it to me in general, or my mods can find it. Either way will be fine, as I go try to faff around to find it. The screenshots I've seen do not have a stamp. There's no stamp. If it doesn't have a stamp, then I don't know what it is. It might be a proposed form instead of the actual form. Right? It might be the defense's proposal as opposed to the actual form. So if it doesn't have a stamp on it, I don't know if it's official. So that's why I'm hesitant, because I don't know what it is. Yeah. No. Yeah, I don't know. This looks right. I mean, if this is correct, yeah, if this is correct, this is probably legally sufficient. So we will discuss this on the presumption this is an official form, with the caveat that it's not stamped, and I am skeptical. But this looks like this would be legally sufficient. But we'll go through the form and discuss it. So give me just a second to put it on screen, please. Yeah. All right, so here is what purports to be the jury form. So, as to offense 1, murder in the second degree, not guilty or guilty of the offense. I mean, that makes sense, right? That's easy enough as far as it goes. And then offense 2, manslaughter, we either find not guilty or guilty of one of the lesser includeds, which makes sense. I mean, kind of. Although I also understand the defense's point that it's a bit ambiguous. I got to stop with the up talk. It's dry. I can't do it anymore. I got to stop. All right.
So I do understand the defense points. So this may be legally sufficient because it is technically correct where it says offense 2, not guilty. And then it gives guilty of any lesser includeds. So I understand the defense's point because it's probably better. This form is ambiguous. We've seen jury forms where it is much more detailed, where they'll actually break it out in separate parts with clear instructions. So compared to some of the jury forms we've seen, I understand their point. That in other jury forms we've seen, it actually will say, each offense separately. And it would say something like guilty, not guilty for each offense. And then it would say at the bottom, if you find guilty, stop. If you find not guilty, proceed on to the next instruction. So I agree with the defense compared to some of the instructions we've seen in other cases. This jury form is perhaps slightly ambiguous, or more than slightly ambiguous, because you start with offense 2, manslaughter, and then you're not guilty as to the parent offense. And then it asks you about the child offense with no clear not guilty verdict. So I agree that this form is much more ambiguous and not as user-friendly compared to some of the verdict forms we've seen in other cases. Whether this is legally sufficient under the relevant case law, I couldn't speak to off the top of my head. But it may be legally sufficient. But I agree with the defense. There is an ambiguity problem, or a potential ambiguity problem, because you could parse it that way, right? The question is, what could a reasonable juror do? And a reasonable juror could parse it incorrectly. And that's the problem, because now you're no longer sure about what the jury is doing, because a reasonable juror could parse it incorrectly. The reasonable juror could say not guilty for the parent case, and then in their head now be like, okay, that case is gone. Now I'm going to consider the child case unto itself, because that would be legally correct. The child case is now unto itself. And say, okay, now considering the child case unto itself, let me consider the case of manslaughter while operating a motor vehicle. And there is no not guilty option explicit. So assuming that this is the correct form, I understand the defense's point. So fair enough. Fair enough. I need to work on two things as a streamer in my delivery. First, I need to stop with the up talk. That's bad. And I need to stop with as many ums, ahs, and other place fillers. Sometimes the ums and ahs are deliberate because I'm using them for comedic effect, but many times they're not deliberate. And I'm tired of listening back to my own audio and hearing ums, ahs, and other place fillers. I did Toastmasters for years. I need an ah counter, and I need someone to whack me over the head and get me to stop, because it's really annoying. It is not good speechcraft. You can just stop talking instead of using a place filler. And see, I just did the up talk again. So I need to work on it. Am I saying the child case? I'm saying the child charge, the lesser included. I call it the child charge. The lesser included charge is what I'm calling the child. So hopefully that's clear. Lesser included. Yeah. Can they request further explanation if they're unsure? Sure, the jury could request further explanation, yes. They could request further explanation. And if they get further explanation, then fine. Then the ambiguity is cleared. But if they simply check guilty without asking for clarification, there's a bit of uncertainty about exactly what they're checking for. So, yeah. What is up talk? Up talk is where you end the end of your sentence is in an upward inflection. Up talk is where you end a sentence like this, and you end it in an elevated pitch. So you speak like this, and it's a little bit distracting because you end your sentence in an upward inflection. It's not good. So I need to stop doing it. I need to stop doing the up talk, and I need to stop doing ums and ahs. That is what I would like in my life.
Let me go back to editing now that we've done Supreme Court speedrun. Yeah, it sounds like you're asking a question. Yeah, it sounds like you're asking a question. That's another good way to put it. You put the same inflection that you would for a question. It's very annoying. It's very annoying, and I need to stop doing it. I don't know if it's a recent thing, but I've noticed it recently in my edits, and I need to kick that to the curb. So, yeah. Let me try to find the edit window. Where's my edit window? Okay, there's my edit window. Okay. Resuming the edit where we were when I got interrupted by the court of the Karen Reed trial, and I got interrupted by the Supreme Court. Returning back to where I was in the edit.
What are the words that every single person who testified in this case used about Karen Reed and John O'Keefe that night? Getting along, no issues, good mood, happy, affectionate, even lovey-dovey. No issues, no toxicity. They were a loving couple right up into the time Karen Reed dropped him off and he walked into 34 Fairview. If an argument with a loved one is a motive for murder, folks, we're all in trouble.
You gotta love that. It just
For murder, folks, we're all in trouble.
you gotta love that. You gotta love that, and it's very illustrative and very true. We've all said things, I'm sure, in various relationships in the heat of the moment that we didn't really mean, and perhaps were too aggressive. And yeah, so everyone describes them as in a good mood. See just there where I said, and yeah, that would be an example of a place filler. I shouldn't be doing that. It's the little things like that. Maggie gave $19.99 to say, good morning, Kurt, uncivilians and all. Thank you very much. Gianna Kialis gave me the Texas horns. Juval Eval became an uncivilian. Oling Dog Design became an uncivilian. Thank you very much for your continuing support. Yeah. And having fun and lovey-dovey and all the rest of it. So are there some voicemails in which you might be a bit aggressive? Perhaps there are some voicemails, but if that's enough to condemn someone for murder, somehow it's shattered. What kind of lawyer am I? Historically, I was patent law. That was my practice law. My practice was patent law. My undergrad is computer science. And so I did patent law. I was on the transactional side of patent law. That's what I did for 15 years. I moved paper around. So that was place filler. So I retired or gave up about 2 years ago and went full-time YouTube. I did it largely because my job was becoming completely untenable. I was very depressed. We've talked about it in depth. I don't really want to talk about it in depth right now because it puts me in a negative headspace. But since then, I've been just basically doing full-time YouTube, and I've been doing consulting work on the side. But that's principally what I've been doing. My expertise is in constitutional law and federal law, primarily, is my expertise, because it's the thing I like reading the most about and studying the most. So hopefully that answers your question. Dave Hallcroft from England says okay. First of all, Dirk Schwartz for 20 euros said, I'm familiar with the ah problem. After 15 years of giving business presentations, I still can't get rid of them. I observe that officers in the military are great at talking clearly and without such interjections. I used to be better about this. I've done Toastmasters for years and years. I'm used to giving speeches without ums and ahs. It's become a bad habit that needs to be eliminated from my YouTube channel. Dave Hallcroft for £5 says, hello from England. Can you explain how the judge can be so biased when a woman's life is on the line? Not an English rule. To be fair, I think the history of English law has its own problems with judges at times and court systems at times, but I appreciate your comment nonetheless. Thank you very much.
They were a loving couple right up into the time murder. Folks were all in trouble.
You gotta love that. You gotta love that, and it's very. With a computer science background, did you see through the ladies' SQL light BS? Yeah. April Sings gifted 10 gift memberships. Illustrative and very true. We've all said things, I'm sure, in various relationships in the heat of the moment that we didn't really mean and perhaps were too aggressive. And yeah, so everyone describes them as in a good mood. $4.99 from Jonathan Aguiwal. I don't mind the fillers when you surround it with coherent and knowledgeable thoughts. I appreciate that. As this is my full-time job, I'd like to come off even more professional. And it is not as professional as it could be. I want to try to do better, but I appreciate your thought. Thank you. And having fun and lovey-dovey and all the rest of it. So are there some voicemails in which you might be a bit aggressive? Perhaps there are some voicemails, but you know, if that's enough to condemn someone for murder, yeah, we're all very, very in trouble indeed. A very good illustrative point. Takes the wind out of sails, basically attacks motive as non-existent. Good stuff. Very good work. Excellently done.
Speaking of which, what is the evidence that John went into the house? The Commonwealth will tell you, undoubtedly, no, he never went in the house. And they'll it's not connected to the Albert family. How about John's Apple Health data? It shows that at 12:21...
Really effective use of the evidence here to explain.
It matters. In the kitchen, as you recall, from Nicole. Third, at least one witness, Brian Higgins, forgot his narrative, at least for a second, and he admitted a man did, in fact, come into the house. And when he was caught and asked to describe that man, he had to. It was a little bit vague. You remember what he said. He was tall, with dark hair. That was a telling slip of the tongue by Brian Higgins. But what's the real evidence of the unbiased data, the data that's not connected to the Albert family? How about John's Apple Health data? It shows that at 12:21...
Can delete that. Move from there. Work. Excellently done.
But what's the real evidence of the unbiased data?
Roosevelt says, as a professional, you should critique yourself all the time. It diminishes you. Well, I'm not sure if you meant shouldn't, but I would tend to disagree. A professional should be evaluating themselves because they need to improve their craft. So I would tend to disagree, but thank you for your super chat anyway.
Data, the data that's not connected to the Albert family. How about John's Apple Health data? It shows that at 12:21 a.m., an important time, John arrived. That's established by the monotonic time clock that you heard about in this trial that was on his phone, and that represents...
I agree that it could be unprofessional to mention it out loud. That's fair. We're just having a behind-the-scenes moment, so I was just expressing some vulnerability, but that vulnerability could be unprofessional. That's a fair critique.
Huge problem for the Commonwealth. It shows that he took 80 steps and ascended or descended 3 flights of stairs at that time. And that makes perfect sense, doesn't it? It matches. Walks into the house, goes directly to the basement. There's your 80 steps. and you're descending flights of stairs. The big problem for the Commonwealth is he wasn't outside at the car ascending and descending stairs, wasn't climbing on top of the car. So they'll tell you, wait, don't look at the Apple Health data, look at this other thing called Waze. But Rick Green explained that if you apply the 3-minute offset that is built into that monatomic time, it aligns perfectly.
Really effective use of the evidence here to explain how the health data and other data align. Oh, we binged. Is my thing behind me is wrong. And my thing behind me is wrong. It says 140,000. It's wrong. We binged. The correct subscriber count is 141,257. Thank you for everyone who subscribes and supports the channel. It's also wrong on the total video views for some reason. It's off by like 1 million. It says the correct video count is 15.5 million. That's wrong. The correct count for total views is 16.4 million. It's off by 900,000 for some reason. But cool. 141,000 subscribers, 16.4 million total views. Cool. Excellent. It showed 141 when you got here a minute ago. Yeah, I'm not sure what's up with that. But I can tell you the exact count because I just was on the YouTube back end, so I can tell you exactly what it is. The sign is wrong. Let's see. Going back to the edit. Line to show that the victim was taking steps, including doing flights of stairs, which everyone said he wasn't in the house, but his own health data says he was because he's climbing up and down stairs. And what stairs are there? Not much except inside the house. And then there's like, okay, there's a contradiction, but no, there's not, because if you just offset the time, then they line up perfectly, which makes sense because not everything records perfectly on the same time frame. So, you know, you have to adjust the time interval. It's like, oh, okay, so it all comes together. Really good command of the facts, really good command of a perfectly objective piece of evidence to show that he was in the house, despite the protestations of all the people who said he wasn't. Good work.
They don't want you to see that. They don't want you to pay attention. They want you to look the other way. But even...
Well, that's a bit of a blow on the state's timeline, isn't it? Her phone connected to...
Told you that Karen Reed's phone connected at 12:30. She had already left the location. She left at 12. Because by 12:32 a.m., Karen Reed...
I've been watching you since before KJ when the goal was 20K. I appreciate that. I appreciate that. I remember when the goal was 100K. I was so excited to hit that. I still am. The YouTube plaque on my wall, on my shelf, is very, very valuable to me. And we've grown. We've continued to grow. Slowly but surely, we're making progress. Very, very cool.
Reed was gone. She had already left the location. She left at 12:30. Trooper Garino told you that Karen Reed's phone connected to John's Wi-Fi at what time? 12:36. It is undisputed in this case that it's a 6-minute drive on a good day from 34 Fairview over to One Meadows. She was gone by 12:30.
10 Australian dollars from Roch Hunting. Roch Hunting for 10 Australian dollars. I've been watching you since Take Care of Maya.
You've been doing the inflection and filters since then. I taught myself to take a sip of water when I want to say, no. Longer do it anymore. That is disturbing that I've been doing the inflection and fillers since then. That is unfortunate. I am conscious of the problem. I'm going to try to solve it. So we'll see what we can do. But thank you for your super chat.
And John's...
Well, that's a bit of a blow on the state's timeline, isn't it? Her phone connected to John's Wi-Fi at 12:36. So she had to be there. And since it's a 6-minute drive, she had to be gone by 12:30. That's a bit of a blow to the state's timeline. Yep.
phone was taking 36 steps and logging 25 meters at 12:32 after she'd left. So don't be fooled. John walked into that house, after which Karen drove away, and the scientific data all prove it.
Yep.
But also, Ryan Nagel and because by 12:32 a.m.
Courts perfectly on the same time.
she had already left the location. She left at 12:30. And John's...
Well, that's a bit of a blow. Nagels were copying Nasty and Canton. I've heard some of the stuff that's going on with Turtle Boy and the assault and other stuff that's going on. It's a lot. It's a lot of stuff, man. This case has been interesting every step of the way. What is the jury doing? I plan to cover the Baldwin trial. I'll probably cover it live, to be honest, and probably also try to do wrap-up streams in the evening. It's such a huge trial. It's such a huge trial with national importance. I'll probably cover it live, plus do some sort of wrap-up streams. So we'll see how that goes, but that's kind of the working plan.
She was gone by 12:30. Phone was taking 36 steps and
Delete that little segment there. Blend it in.
she was gone by 12:30. Phone was taking 36 steps and logging 25 meters at 12:32. All prove it. And John's
Well, that's a bit of a cross dissolve there.
data all prove it. And John's
Well, that's a bit of a blow on the state's timeline. Let's see if I can get rid of that little trailer at the beginning.
and John's
Oh yeah, dude, delete it, cut it there. Get rid of that little audio. What is this? Is there a little... There's a little segment there for some reason. Delete that too. Ripple, delete that. Create a blend.
scientific data all prove it.
Well, that's a bit of a blow on the state's timeline, isn't it? Her phone connected to John's Wi-Fi at 12:36. So she had to be there. And since it's a 6-minute drive, she had to be gone by 12:30. That's a bit of a blow to the state's timeline. Yep.
But also, Ryan Nagel and Heather Maxson prove it. In addition to the
Yeah, multiple butt dials is a bit of a unlike.
by about 12:30. Had to be in order to connect to the Wi-Fi at 12:36. So unequivocally, Jennifer McCabe was lying about watching that SUV, and it makes you wonder why. And to add to that deceit, she was also blatantly lying about the calls to very specific about that time frame. Damaged. That brings up another difficulty for the Commonwealth, and that's their star witness, Jennifer McCabe. You'll recall
If the state has to disclose their exhibits to you, can they use them in your close to point out how they're wrong? Sure, you can use the other party's exhibits against them. That's fine. Every man's evidence. Every man's evidence. Everything belongs to everybody. Sure. And if you can do that, it's pretty hilarious, incidentally. To use your opponent's own words or their own thing against them is always a pretty baller move. If you have your choice, if you can use the judge's words, that's best. If you can use your opponent's words, that's second best. And then finally, it's your own words.
Which Karen drove away, and the scientific data all prove it.
Well, that's a bit of a blow on the state's. Stonebleed says, I have a vague memory of you and Leonard French doing the Pledge of Allegiance in a video. Did that happen? Yes, we did. Yes, we did. Leonard French was a friend. We sort of lost track of each other when he moved overseas. And we don't really keep in touch anymore. I guess we just live different lives. I guess that happens sometimes. I'm watching a video of me watching a video. I'm editing a video for hopefully release. Hopefully I get to release it before it becomes moot. And since it's a 6-minute drive, she had to be gone by 12:30. That's a bit of a blow to the state's timeline. Yep.
That brings up another difficulty for the Commonwealth, and that's their star witness, Jennifer McCabe. You'll recall that Jennifer McCabe claimed that she was looking out the door, staring at that SUV over and over and over.
Yeah, I have nothing against Leonard French. He was a very good friend of me. And I hope he's having a happy, happy life. I have nothing against the man. I hope he has nothing against me.
Again, from 12:29 to 12:50. She was very specific about that time frame. But we know that the SUV was gone from 34 Fairview by about 12:30. Had to be in order to connect to the Wi-Fi at 12:36. So unequivocally, Jennifer McCabe was lying about watching that SUV, and it makes you wonder why.
Desert Cat gives $5 to say, sorry if addressed. Thought on lack of not guilty on the forums. I find the forums to not be good. We've seen forums that give much thorough and more detailed instructions and are much clearer. These forums are not. These forums leave something to be desired in terms of the forums we've seen. There is ambiguity that is not good. I'm afraid the jury may assume they have to pick a lesser because of the dumb. That is unfortunately a potential interpretation of the instruction because it is unclear. Yeah. That is, yeah.
And to add to that deceit, she was also blatantly lying about the calls to John's phone. You remember that colloquy back and forth. She said that every single one of those calls to John's phone during that time was a butt dial.
Yeah. No.
How are those lies connected? And why are they connected?
Cut it there. Cut it there. Blend it into there.
Dial.
No.
How are those lies connected? And why are they connected?
Yeah, multiple butt dials is a bit of a unlikely explanation. A singular butt dial, maybe, but multiple different butt dials that all apparently, trying over and over again. That's a bit of a unlikely explanation. I do appreciate throwing Skeletor under the bus over here. That makes me very, very happy because this woman was, what is the opposite of a treat on the stand? So yeah, that's good. Fly Fox Pro 499 says, former pro editor, no reason to use anything but DaVinci. Fair enough. It is, and I just keep it simple. I just do a simple jump cut with a cross dissolve. Seems to work pretty well. That's all I really know how to do. I don't really have any fancy editing skills. I can't do graphics, can't do anything fancy. but I can do jump cuts with a cross dissolve. So yeah, work. I appreciate that.
Let's talk for a second about what actually happened in the time leading up to everyone going to 34 Fairview. Brian Albert, Brian Higgins show up drunk at the waterfall. They'd been drinking in the afternoon. You know about the
scene interior, the way he walks through the crime scene interior in his telling.
We know that once John actually did walk in the door, it's about 2 steps, 4 feet or so, 2 steps. Who doesn't know John all that well seems to want to coax John to 34 Fairview.
Hair very
12,
including leading to the scars on his arm. Yeah, I mean, it's just really good.
Keith walked into that house at 34 Fairview. We know that once John actually did walk in the door, it's about. This is what they were doing just minutes before John O'Keefe walked into that house at 34 Fairview. We know that once John actually did walk in the door, it's about 2 steps.
I did have one problem in DaVinci Resolve. I had gotten this transitions pack from Elgato Elements, which I paid for, which is supposed to have all these fancy transitions. And the instructions said put it in this directory, which didn't exist. So I just tried to create the directory, and it seems to have broken DaVinci Resolve. So I don't have my fancier transitions, which is annoying. Yeah, I saw the argument about the verdict forms. We discussed it already. Treat on the stand. So yeah, that's good work. I appreciate that.
We know that once John actually did walk in the door, it's
2 SEK from entry required. Bowden instructions give me hope. Yeah, that was a nice touch. The Bowden instruction is a voluntary instruction that can be given in Massachusetts. It's an instruction that basically the court can say, hey, members of the jury, just to let you know, you can use the shoddy investigation by the government against them. It's an instruction that's voluntary. It doesn't have to be given. The court initially said they weren't going to give it. The defense, of course, is free to argue it in either case, but the fact that the judge gave the instruction is powerful because now it's also coming from the judge. So that was a nice win for them. And also they did not get the consciousness of guilt instruction that the prosecution wanted, which was also a nice win for the defense. So there were some nice wins in there. Thank you, Emily Brandt, for becoming an uncivilian. I do appreciate all of you who join.
It's about 2 steps, 4 feet or so, 2 steps for an adult male to reach that basement door. Remember, everybody was gathered in the kitchen. That's what Nicole Albert said. And every single witness agreed that at some point, Brian Higgins and Brian Albert left the group and went to another room. Where did they go? Where did they go together? Another important point. Chloe was not upstairs. Brian Albert slipped. Another important point. Chloe was not upstairs. Brian Albert slipped in one of his in testimony that he provided. Quote, I was watching Chloe downstairs, monitoring her.
Thank you, Amelia Brandt, for the 5 gift
house.
memberships. We do appreciate everyone who helps to support the channel. It means a lot to me. Thank you very, very much. Yep.
So what happened next? We absolutely know that John was in the house. The data, Ryan, Heather, they all established that. We know that John ascended or descended stairs. We know that Brian Higgins and Brian Albert excused themselves. How long does it take
Is Tony
to
here?
have a crossword? How long does it
By any
take to have a
chance?
fight? How long would it take for Brian
If
Higgins
you are,
to
could
say
you
to John,
help me with the thumbnail for the
you
closing
know, your
argument?
girl's been texting me.
Otherwise, I'll put one together
Push,
myself.
a punch, a fall, pull Chloe off his arm, and now it's done.
Cut it there. Do that. No, Tony? That's okay. Tony's a great mod. He does so much for us. Tony is really awesome.
Pull Chloe off his arm, and now it's done.
I really like the way he walks through the crime scene interior in his telling of the story. And he's just a fantastic storyteller. He has two really good traits as an attorney that are really admirable. One is the attention to detail, because he knows the minutia. So really good attention to detail. And two, he's really good at storytelling. And those are really good qualities. And here he brings out those traits. He brings out the attention to detail to walk through all the players, including Chloe, talks about how these people left the room, talks about how there was a desire to bring him to the scene of the murder, how the one person seemed to want to get with the girl, and there might have been a crossword, and how long does that take? And he just walks through it in a really, and he talks about how Chloe was on the ground floor, possibly leading to the scars on his arm. Yeah, I mean, it's just really good attention to detail, and he puts it together in a very easy to listen to, very engaging story. This is, if you can get story right, in your opening and your closing, you're there, baby. And this guy knows story. It's a master's class. It's fantastic. What if the four-person writes in a not guilty box?
And then the panic.
I don't know how the judge would respond to that. It's an interesting question. Thank you, Pterodactyl, for the $2, and thank you, Honey and Salt, for the 20 gift memberships. Your contributions are extensively appreciated. Don't forget to check out our merch store. The link should be pinned above. There's some cool stuff on there.
What's done is done. And then some very, very odd things start happening.
Yeah, Chloe, the dog, hashtag.
Was the Albert family pet? Was he there? Is it both? Was it neither? Or was he there to gather intel? Ask yourself, why go? But the odd things keep piling up, and here's another. Chloe was the Albert family pet. Not only did she appear to be gone from the house that morning on January 29th, nobody saw her there. Even Jim McCabe admitted.
Fortunately, I don't mind my own voice too much, so editing isn't too big a deal.
But they actually got rid of the dog altogether. Within months of this incident, the dog was gone, out of the house, rehomed, never to be seen again. This was a dog they had had for 7 years. Also a dog who had a bite history. Why was it so important to get rid of that dog? Was there something about the dog they did not want law enforcement to find out?
Kurt, thanks for hanging out. Hey, no problem. I figured we could do some stuff. And if I'm done with editing, we can play Mario Kart together while we wait for the jury. Once I'm done with editing and post it, it's like I have no other plans for today. Well, the only other thing I could do would be edit some of the expert testimony. But I'll do that tomorrow if we're still on jury watch, I guess, because I'll have to post something tomorrow. So if jury watch continues past today, then I guess we'll do more editing tomorrow. There's no reason to do it now. Because if the jury returns a verdict today, there's not really much reason to post further videos. So, yeah. So after I'm done editing, we can play Mario Kart. For those of you guys who have Mario Kart 8 on Nintendo Switch, we can play Mario Kart. It'll be fun.
They did not want law
I'm not that great. You guys will kick my ass. It'll be fun.
enforcement to find out.
Yeah. Chloe, the dog, hashtag justice for Chloe, as she has been rehomed to a farm in Vermont. Yeah, the family dog they had for 7 years, who had a bite history of other dogs, who the family says wasn't good with other people. And we have scratches in the arm that look suspiciously like they might be dog scratches. And the family dog just so happens to not be available for any sort of review. Some rehoming going on. Chloe, wherever you are, you got done dirty. Hopefully justice will be brought to you someday.
All what Dr. Russell said. But there are more odd and unexplained things. After a night of drinking and hanging out, simply say he didn't know the property, he knows the owners, he's grown up with these folks, he passes by all the time this was going on. There is no innocent explanation for that Google search at 2:27 a.m. None. At the end of the day, clearing away all the confusion, the Commonwealth's experts were left with two things that are true. First, neither of their experts could absolutely rule out that Jennifer McCabe made that search at 2:27 a.m.
What if the fire Pete son, right, for foreperson presumably writes in not guilty box? I don't know how the judge would respond to that, but thank you, Pterodactyl, for the $2. Is there a joke here in Fire Pizza that I'm missing? I hope not, but thank you for the super chat.
Neither. And second, the only person to use the actual phone model, the actual data, and the actual precise operating system was Rick Green. And he was clear. That search was at or before 2:27. After that call, decides to call Brian Higgins. That call was missed with 17 seconds, doesn't it? And it fits a very neither. And second, at the end of the search became a focal point. Jennifer McCabe is on her phone at her house, Google searching how long it takes for someone to die in the cold. That was at 2:27 a.m. Talked about Jennifer minutes after that call that we just talked about. Jennifer McCabe is on her phone at her house, Google searching how long it takes for someone to die in the cold. That was at 2:27 a.m. That timeline seems to fit, doesn't it? And it fits a very telling and a very clear story. That search became a focal point of the Commonwealth's entire case. This case was starting to look a lot more like the defense of Jennifer McCabe than anything else. That's probably because there is no innocent explanation for that Google search at 2:27 a.m. None. At the end of the day, clearing away all the confusion, the Commonwealth's experts were left with two things that are true. First, neither of their experts could absolutely rule out that at the end of the day, clearing away all the confusion, the Commonwealth's experts were left with two things that are true. First, neither of their experts could absolutely rule out that Jennifer McCabe made that search at 2:27 a.m. Neither. And second, the only person to use the actual phone model, the actual data, and the actual precise operating system was Rick Green. And he was clear. That search was at or before 2:27 a.m. And then
Yeah, Snowplow man.
And he told you that there is no body laying on the lawn at 34 Fairview. When all this suspicious activity was happening. So what else was going on at or around this same time?
Okay, delete this, I think. Delete this. Yeah, all right, so this should be flowing to this, I think. How am I doing? I'm doing fine. Thank you for asking. I'm feeling good, feeling relatively positive. All's well in my world. How are you doing? We're all doing great, I hope. Thank you for the 1,700 of you who are joining me and spending some time with me on Verdict Watch, /editing, /Supreme Court discussion. Thoughts on the Supreme Court ruling government can pressure big tech to remove content? We discussed it. I went through the Supreme Court decisions earlier on stream. It depends how the original pleading was done. If they really only asked for forward-looking relief, then I think the Supreme Court is correct. If in the original pleadings they asked for declaratory relief, then I would disagree. And it's hard to believe they didn't ask for declaratory relief. So I agreed in part and disagreed in part. Thank you for asking. Hopefully justice will be brought to you someday.
So what?
And also it sounds like they didn't bring suit against the tech people, which would be a massive error based on the written description or the abstract. So it seemed like they might have sued the wrong person and maybe not asked for the right thing. Any idea when the Tumblr will be back in stock? No, that's not up to me. Probably 3 weeks, I would imagine, but it's not up to me.
What else was going on at or around this same time, when all this suspicious activity was happening at the Albert house and the McCabe house. 3 minutes after that search, and 8 minutes after the Albert Higgins 2:22 a.m. call, Brian Loughran drives down the street in his snowplow.
Yeah, Snowplow man.
And he told you that there is no body laying on the lawn at 34 Fairview at 2:30 in the morning. Importantly, he didn't just simply say he didn't see a body, he wasn't paying attention. He said there was no body there. He knows the property, he knows the owners, he's grown up with these folks, he passes by all the time, not once, not twice, 3 passes. There was nobody on that lawn, period, at 2:30 a.m.
I think Snowplow man is my favorite witness. Entry required 20 SEK. Okay, will seek Chloe if I go back to my Virginia house property or Vermont house property. Let us know if you find Chloe. I have a sneaking suspicion Chloe is no more. Of the trial, a simple, normal, unpretentious, down-to-earth man. I love this guy. He's just a normal guy, uncomplicated, and he's like, yep, I drive the snowplow. It's what I do. I passed by the house 3 times that day, 2:30 in the morning being the first of them. Not so much with seeing a body, no. No. Very, very clear. Very, very clear. Body, no. No. Very, very clear. Lucky is great. Yeah. Thank you for the super chats. We do appreciate them. Of course, they make a huge difference. Thank you.
Body was found. And by 6 a.m., John's body was, in fact, now outside. Well, this flurry of murder, she called him not once, not twice, 53 times. Learn what she was thinking and what she was feeling. Now it's 5:23 a.m. She's sitting in the cold, dark, freezing outside in the
What trial in history do you wish you could have seen streamed? Scope's monkey trial would be pretty cool.
And by 6 a.m., John's body was, in fact, now outside. While this flurry of suspicious activity was going on with the Alberts and the McCabes, what's happening with Karen? All she knows.
Doing a great job? Thank you. I try. In honor of verdict watch, will you shave your head? No. For that shiny, fresh Massachusetts state trooper look? No. Thank you. I'm good. No.
Knows at this point, think about it, at approximately 2:21, she dropped off John. He walked into 34 Fairview, and she knows nothing else going on. So what was she left to think? He goes in to check the party out, but all of a sudden he's not coming back. He's not responding. Minutes start to pass. 1 minute turns to 2, 2 turn to 10. Where is he? Why isn't he responding? She's sitting in the cold, dark, freezing outside in the car. Naturally, she's perturbed. Being perturbed turns into being peeved. Being peeved eventually turns into being pissed. By 12:30, Karen's mad. She's left 34 Fairview to make a point, but she's still texting and calling. What could she reasonably be thinking at this point? What's going through her mind? 12:33 turns into 12:34. I can't believe he'd do this to me. 12:34 turns into 12:35. Where is he? Why aren't you answering, John?
We did have a look at the verdict form, yes.
12:35 turns to 12:36. Jesus Christ. I'm calling and you're not answering. Where are you? Pick up the phone. But there's still no answer. There's still no response.
Mm-hmm.
By 12:37, she's getting furious. She does not know that something has happened to John. She does not know that. So she leaves the first angry voicemail. Illustrates for have. You and I gets home. You can hear her heels clicking across the garage The next open voicemail has Karen parking at John's garage after she gets home. You can hear her heels clicking across the garage floor. For all she knows at this point, John's just drunk, he's been partying, he's hanging out, just forgot about her, blowing her off. But John's still not responding, and as the minutes tick by, Karen becomes increasingly upset. Those are the voicemails that you heard. How could he do this? Why is he ignoring me? Why is he ignoring the kids? Those are the thoughts bearing down on Karen Reed as she sat in an empty house late at night by herself. Ladies and gentlemen, she did not know what had happened to John. But within the next voicemail, you quickly learn what she was thinking. Just forgot about her, blowing her off. The next open voicemail has Karen parking at John's garage after she gets home.
I think I'll cut it here.
The next open voicemail has Karen parking at John's garage after she gets home.
Yeah, I think I'll cut it here. That's a lot of audio I can get rid of. Let's give that a shot and see if that's the right place to cut it.
No. Very, very clear.
The next open voicemail
Jury
has
has a
Karen
question.
parking at John's
Well,
garage
whenever the court
after
comes
she gets
back,
home.
we'll
You can
put it
hear
on.
her heels clicking across
I'm
the
watching.
garage floor. For all she
got it in
knows
my
at this
corner.
point, John's just drunk, he's been partying, he's hanging out, just forgot about her, blowing her off. But John's still not responding, and as the minutes tick by, Karen becomes increasingly upset. Those are the voicemails that you heard. How could he do this? Why is he ignoring me? Why is he ignoring the kids? Those are the thoughts bearing down on Karen Reed as she sat in an empty house late at night by herself. Ladies and gentlemen, she did not know what had happened to John. But within the next voicemail, you quickly learn what she was thinking and what she was feeling. Now it's 5:23 a.m. She's
Yep,
woken
that
up,
works.
she's realized that he hasn't come home and he hasn't responded to a single text, not a single call, and anger quickly turns to panic and abject fear. She's so distraught, she reaches out to him again. John,
How many monitors do I run
where
with?
are
Just
you?
one. It's a 42-inch TV.
She says
So
through tears
it's a lot
and
of screen real estate.
desperation. And at 6:03, her question was answered, and her worst fears are realized when she finds his body laying, dying in the cold in Brian Albert's front yard. You heard her. You can feel the grief. You can feel the raw anguish. You heard her. You can feel the grief. You can feel the raw anguish. You could see it. You don't have to wonder the emotional journey that Karen traveled that night. You can see it in the video. You can hear it in the audio. From the time he left her and walked into 34 Fairview and she called,
Okay, delete that little segment there because it's a little side that we don't need. Transition between.
laying, dying in the cold in Brian Albert's front yard. From the time he left her and walked into 34 Fairview and she called, she reached out 53 times. She called him 53 times before finding his body. Think about
Rick's
that.
back. I'm watching the feed.
Commonwealth wants you to believe that she murdered this man. And then after that murder, she called him not once, not twice, 53 times. It makes no sense.
I'm watching the feed.
What
I tend to agree. That doesn't make a lot of sense. I mean, that doesn't sound
53 times. It makes no sense.
Right now, all I'm seeing is spinning fan. So there's no need to switch feeds. I'm watching the feed. When they actually come back, we will switch feeds.
It makes no sense.
I tend to agree. That doesn't make a lot of sense. I mean, that doesn't sound like normal behavior. I mean, you might think a call maybe to like cover your tracks, but 53 calls by this person.
Please don't be a verdict. 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 Well, I suppose if it's a verdict, I can always publish Karen Reed, the closing argument that won the case. So okay, it can be a verdict. That's fine. I'll just rename the stream. It'll be fine.
Person is like, I don't think so, man. Yeah, it sounds more like someone in a panic, desperately trying to figure out where this person is, than a cold-blooded killer. That doesn't make sense. I tend to agree. So, yeah, it doesn't really add up, Commonwealth.
What does make sense is that she emotionally moved from anger, then to panic, then to grief. So back at 5:07, when she began her search looking for John, she backed out of the garage, and what would happen next would change the entire course of this case. As she backed out of that garage, she hit John's Traverse and cracked her right rear taillight. Folks, the Commonwealth has one job to do, and if there
Yeah, you know, if this is the taillight at
an audible gasp in the courtroom when we finally showed you the actual video, you can see that tire move. I'm only going to show you one series of exhibits during my...
Okay, delete that. Transition between. Good stuff. Yeah, it doesn't really add up, Commonwealth.
I'm only going to show you one series of exhibits during my...
I'm still just seeing a spinning fan. All I got is spinning fan
important.
action.
And it's this. Look at the condition of
The
her
spinning
taillight
fan
when
might
she
have a
pulls out of the
question, but it's
driveway
unclear what it
at
is.
5:07. That taillight, and I'm going to choose my words very carefully here. That taillight is cracked, but it's not completely damaged. And if there...
Yeah, you know, if this is the taillight at 5:07 in the morning, which it is, it's caught on video apparently at 5:07, I'm seeing an awful lot of red brake light. An awful lot of red brake light. Yeah, that looks pretty intact to me.
The jury feed is
At
fit,
5
switching.
o'clock in the morning.
Okay, time for me to switch feeds. Hold on. Don't want you to be deprived. Where's the thing? Oh shit. Okay.
We'll figure that out. I'll get some language from you. But Mr. Jackson, after our hearing this morning, I considered what you said. I went back and I read the jury instructions I gave yesterday. So I do appreciate the concern about the confusion this might cause the jury. I think it's easily clarified with a supplemental instruction. I don't think it's the verdict slip. I think it's how they're to follow the verdict slip. So what I've written up, this is a very rough draft. I'll read it to you. I'll take a break and let you consider it if you want. And this works out. I received this, I don't know, 15 minutes ago, and I've been, the letter, the question from the jury. So it seems a good time, so I was working on this. It seems a good time to bring them in for an answer to that question. And I would say, as long as I have you here, I want to clarify my instructions regarding your verdict as to count 2 of the indictment. As I instructed you yesterday, there are 2 lesser offenses of that crime, which are involuntary manslaughter and motor vehicle homicide, felony, OUI, liquor, and negligence. Therefore, count 2 encompasses 3 separate charges, the most serious of which is manslaughter while operating a motor vehicle under the influence of liquor. In considering count 2, you should first focus on the crime of manslaughter while operating a motor vehicle under the influence of liquor, and if the Commonwealth has failed to prove that crime beyond a reasonable doubt, then you are to consider the remaining lesser included offenses in descending order. The lead charge is manslaughter while operating a motor vehicle under the influence of liquor. If you find that the Commonwealth has proved all 5 elements, or proven all 5 elements of this charge beyond a reasonable doubt, then your verdict shall be guilty of manslaughter while operating a motor vehicle under the influence of liquor. If, however, you find that the Commonwealth has not proven all 5 elements of manslaughter while operating a motor vehicle under the influence of liquor, then you are to consider whether the Commonwealth has proven beyond a reasonable doubt the 3 elements of the lesser included offense of involuntary manslaughter. If the Commonwealth has proven the 3 elements of involuntary manslaughter, then your verdict shall be guilty on the lesser included offense of involuntary manslaughter. If, however, you find the Commonwealth has failed to prove beyond a reasonable doubt the crime of manslaughter while operating a motor vehicle under the influence of liquor, and the lesser included offense of involuntary manslaughter, then you are to consider whether the Commonwealth has proven beyond a reasonable doubt the 5 elements of motor vehicle homicide, felony OUI, liquor, and negligence. If the Commonwealth has proven beyond a reasonable doubt the 5 elements of motor vehicle homicide, then your verdict shall be guilty of the lesser included offense of motor vehicle homicide, OUI, liquor, and negligence. If, however, the Commonwealth has failed to prove beyond a reasonable doubt all elements of manslaughter while operating a motor vehicle under the influence of liquor, and has failed to prove all of the elements of the lesser included offenses of involuntary manslaughter or motor vehicle homicide, felony, OUI, liquor, and negligence, then your verdict must be not guilty to count 2.
May I have just a moment?
Yes.
Yeah, we're changing the jury instructions. We're proposing a new instruction, is what we're doing right now. So Jackson's earlier argument of this form is confusing, apparently,
Thank you,
was...
Your Honor. May I be heard?
Yes.
I deeply appreciate the court's additional clarifying language. I would simply ask for one very simple amendment, and that is at the top of the verdict slip, it says the 2 words, not guilty. We would ask that the verdict slip read, not guilty of the offense charged or any lesser included offense. That's it. And I think that and the court's clarifying instruction would satisfy the defense. Not I think, I know it will. That's all we ask.
All right.
I can repeat that if the court wishes.
So there are some like minor changes we have to make to the verdict slip anyway. Just, you know, it has to be consistent. So the manslaughter while operating a motor vehicle under the influence, the tab needs to, actually, Tori. So there needs to be some physical changes on the verdict slip. Anyway, it needs to be indented. There needs to be a colon after guilty of offense charged. It's not complete. It doesn't have under the influence of liquor. It just says under the influence. So there are some minor changes that need to be made to the verdict.
Oh my God. Just some minor changes to the verdict form. Minor changes to the verdict form and some minor changes to the jury instructions. It's going really great over here. Just fantastic news. Okay, let's press on.
Slip. Does the Commonwealth oppose the suggestion made by Mr. Jackson, which seems like a reasonable one?
No, Your Honor.
All right, so it will be not guilty. So tell me again how you want it.
Sure.
You want
not guilty of the offense charged or any lesser included offense.
Yeah, that sounds better. That sounds better.
All right, I think the clarifying language that I proposed is important.
I do too, and I appreciate that. I think with that amendment to the slip and the clarifying language, I think coupling those up is exactly what the defense was asking for. I appreciate that.
So I need to clean. I'd like to send in a written copy of what I just read. I have a couple of things bolded. I need to fix this up a little bit. I mean, it was just done quickly. The jury's been waiting. Why don't we bring them in? And I will tell them that a new verdict slip will come into them. How's that?
Okay.
I do, though, have to make a finding that the verdict slip as is was proper. All right, so we'll just leave it at that. I'll make the amendment that you want, but that's my finding.
Thank you, Your Honor. Just from a logistics standpoint, once the new verdict slip is prepared and ready,
We all need to see it.
I was just going to ask, do we have that emailed to us or something?
Yeah, we all need to see it. I will work with Tori. All right. All right, can we bring...
There are no mistakes on the jury form, people. She wants to make that very clear. She wants to be very, very clear that there are no mistakes on the previous jury form. Just some happy little accidents. Happy little accidents. Yeah. Jay McCarthy gives $10 to say just some minor changes to the verdict sheet and jury instructions because we won't make things more confusing look the other way. The judge apparently thought the better of it
and decided, you know what, maybe I should not do that. Much like she initially denied the instruction regarding the corruption of the investigation. She initially said, no, I'm not going to give that instruction. Then she said, you know what, maybe I should give that instruction. She has said, you know what, maybe I should reconsider the form is perfect decision. It's perfect, but we're going to fix it. Okay, right.
The jurors in, please.
This is good shit.
All right, so jurors, we're in receipt of your question. Can we request the cert report detailing the search performed? I take this as a request, and the answer is that you folks, you have all the evidence in the case. So what you have is the evidence in the case. You won't be receiving any additional evidence. But as long as I have you here, I want to clarify my instructions regarding your verdict as to count 2 of the indictment. As I instructed you yesterday, there are 2 lesser offenses of that crime, which are involuntary manslaughter and motor vehicle homicide, felony OUI, liquor, and negligence. Therefore, count 2 encompasses 3 separate charges, the most serious of which is manslaughter while operating a motor vehicle under the influence of liquor. In considering count 2, you should first focus on the crime of manslaughter while operating a motor vehicle under the influence of liquor, and if the Commonwealth has failed to prove that crime beyond a reasonable doubt, then you are to consider the remaining lesser included offenses in descending order. So, the lead charge is manslaughter while operating a motor vehicle under the influence of liquor. If you find that the Commonwealth has proven all 5 elements of this charge beyond a reasonable doubt, then your verdict shall be guilty of manslaughter while operating a motor vehicle under the influence of liquor. If, however, you find that the Commonwealth has not proven all 5 elements of manslaughter while operating a motor vehicle under the influence of liquor, then you are to consider whether the Commonwealth has proven beyond a reasonable doubt the 3 elements of the lesser included offense of involuntary manslaughter. If the Commonwealth has proven the 3 elements of involuntary manslaughter, then your verdict shall be guilty on the lesser included offense of involuntary manslaughter. If, however, you find the Commonwealth has failed to prove beyond a reasonable doubt the crime of manslaughter while operating a motor vehicle under the influence of liquor and the lesser included offense of involuntary manslaughter, then you are to consider whether the Commonwealth has proven beyond a reasonable doubt the 5 elements of motor vehicle homicide, felony, OUI, liquor, and negligence. If the Commonwealth has proven beyond a reasonable doubt the 5 elements of motor vehicle homicide, then your verdict shall be guilty of the lesser included offense of motor vehicle homicide, OUI, liquor, and negligence. If, however, the Commonwealth has failed to prove beyond a reasonable doubt all the elements of manslaughter while operating a motor vehicle under the influence of liquor and has failed to prove all the elements of the lesser included offenses of involuntary manslaughter or motor vehicle homicide, felony, OUI, liquor, and negligence, then your verdict must be not guilty to count 2. So I'm going to send in a new verdict slip on count 2 that's just a little bit different, and we have to sort of change we have to indent something and change the spacing a little bit to make it a little bit clearer for you. Okay, so we'll get that into you in the next 10 minutes. All right, thank you all very much.
Yeah. Yeah, this is my legal question for the day. The judge kept saying the intoxicating influence of liquor. Does beer or wine not count in Massachusetts? If you get into a DUI homicide, but it's only beer, does that mean that you're cool? Is that how that works? Because if that's a thing, yeah. Beer and wine are totally okay. DUI. It's only that evil liquor we have a problem with. Yeah. So I don't know. Okay. So long story short about what just happened. First of all, the jury said, can we see the cert report? The judge says you already have all the evidence and there's nothing else. So you already have everything.
So, you know, look again because it's already there. Fine. That was the question. Then, per the defense's request, the jury gets new exciting jury instructions and a new exciting jury form, because the defense pointed out that the old, not wrong form, the judge wants to make very clear, by the way, that the old form is in no way a problem, but we're going to correct it anyway. So per the defense's request, we're going to give some new exciting jury instructions that makes clear that when you find her not, if you find her not guilty of the top count of the second charge, when you consider the lesser charges, not guilty is also an option. Plus, we're going to change the verdict form. So instead of it just saying not guilty at the top, it will now say not guilty of the top count or any lesser charge, to make clear that it's not guilty for everything. But, you know, the old instructions and the old verdict form were totally fine, but we're going to fix it anyway. So this was all at the defense's request. So Aunt Bev continues to reconsider things as she cools down, I guess. Because initially the defense wanted that instruction about if this investigation sucks, you can hold it against the state. And initially said, no, I'm not going to give that instruction. Then the next day, she gave the instruction. And I was like, oh, okay. Well, you said you weren't going to, but then you just did. So you gave this exciting instruction that the defense wanted, I guess, after reconsidering it. And the defense comes in and says, you know, we see a problem with the verdict form. Looks a little bit ambiguous to me. And the judge is like, nope, this is the way we do it. This is the way we do it in Massachusetts. No problem with the verdict form here. Everything is fine. It's a great verdict form. Then apparently some time later, 30 minutes later, as they might say in SpongeBob land, the judge is like, you know what? Maybe it could be a little bit clearer. So she says, okay, here's some new exciting instructions I have to try to clarify this issue. And the defense is like, that's cool. Do you also mind if we change the verdict form to add this language? And the judge is like, sure. And so she's going to change both the instructions, or a supplemental instruction, I guess, not strictly change it, just an additional instruction, plus a change of the verdict form to make it clearer that not guilty of everything is in fact an option, which cures the error from the appellate posture, if there was one in the first place. Not that there was an error. It was totally fine. But yeah, no, it wasn't the jury who requested clarification. That is not what happened. That is not what happened. No. The jury's question, the judge read it. The jury's question was, hey, can we see the cert report? Can we see the search report from the cert team? That was their question. And the judge said, you already have all the evidence. The jury did not ask for clarification. No, it was the defense team who asked for clarification. JT000 said, I guess Bev missed judge school when they advised, one, listen to both sides of an argument, two, maybe reflect instead of giving knee-jerk reactions. There is no error stop. Well, there's not now. I don't know what you're trying to correct me on. I don't know what you're trying to correct me on. The implication that there was an error on the first form? We discussed it at some length. I thought it was a bit ambiguous and led to problems. So if you're just disagreeing with my legal opinion that there might be a problem on the first form, then I'll just disagree. In my legal judgment, there was a potential problem on the first form. And that problem has now been cured. So I'll just disagree. True Seeker for $9.99. Thank you very much for the super chat. And it is appreciated. Does the jury have the report? I think they should. It's probably in the evidence somewhere, I'd imagine. Yeah. All right, back to editing. What's the CERT team? Remember? The search and rescue team, which apparently came to do the search after the initial team that found the
3 or maybe it's 5 or maybe it's however many people with plastic, that those people, the people with the brooms, as opposed to the leaf blowers, those people with the brooms, they're asking for a report from that team. And assuming such a report exists, the jury has been provided it, and I would assume the report exists. If it yeah. So the jury's been provided with whatever exists. There was no cert report. Okay, fair enough. And there was no report, and the jury has everything they have. So fair enough. If there's no cert report, there's no cert report. All right, fair. All right, what am I doing right now? Okay, I'm trying to find the... Nope, that's not what I want. Nope. Nope. There's no formal search report. That's the problem. I believe that. I believe that because, you know, it's a pile of stupid. All right, returning to editing. Are there any other questions about what just happened in court before I go back to the editing issue? Just to make sure that we're all clear on what just happened. Basically, the defense got what they want, is the short version. The defense won. So, yeah. And it's also nice because they get an additional reminder that not guilty is an option, which is also a nice bonus for the defense. So first they get the instruction, and they also get an additional reminder that not guilty is an option. So, hey, that's always nice. So the defense got a bit of a win. Good for them. What do I think the question meant about them searching? I don't know. They just wanted to see a report. If none exists, then they have all the evidence that exists. So maybe there is no report. I don't know. Entry required gives SA key 50 to say liquor. Could this be an artifact in law distinguishable, taxable distilled beverages from beer and wine? New England has a lot of colonial and early American quirks. I don't know. Maybe liquor does also include beer and wine by law. I just found it interesting. Maybe the definition of liquor includes beer. It's hard to believe it doesn't. I just found it was interesting. It's like, oh, they kept saying liquor. I'm like, does that include beer? Because that's a reasonable question. So let us return to editing. Then Mario Kart, which I'm looking forward to because I could use the mental break because I can turn my brain off with Mario Kart, and that is a win for us all. Uncivil could use the break. All right, let's see. Where am I going? Okay. All right. Here's where I was. All right. Let's go back here. Yeah, it doesn't really add up, Commonwealth. Yeah. Don't even know her. I thought real hard about making that joke. It definitely passed through my mind to make the joke. I apparently decided discretion was the better part of valor. But, yeah. Yeah.
I'm only going to show you one series of exhibits during my entire closing, but it's that important. And it's this. Look at the condition of her taillight when she pulls out of the driveway at 5:07. That taillight, and I'm going to choose my words very carefully here. That taillight is cracked, but it's not completely damaged. And if there...
Yeah, you know, if this is the taillight at 5:07 in the morning, which it is, it's caught on video, apparently at 5:07, I'm seeing an awful lot of red brake light. An awful lot of red brake light. Yeah, that looks pretty intact to me at 5 o'clock in the morning. Kind of difficult to see how that squares with the state's timeline. That the lens, the plastic cover shattered
It shattered so hard, this plastic carbonite, which is designed not to shatter at all, by the way. It's designed not to shatter at all, but never mind. Somehow it shattered, and shattered so into such sharp pieces that it created these deep knife-like things to cause the wounds in his arm. And that happened several hours earlier than this, but somehow when we look at it, not so much. The taillight actually looks intact. Yeah, no, that seems like a bit of a devastating image to the state's theory of the case. Not really seeing a broken taillight there. Looks normal to me at 5 in the morning. Seeing some problems with the state's theory of the case, it seems to me.
Was any question in your mind about the level of damage to that taillight at 5:07, all doubt was extinguished. When Dighton Police Officer Barrows walked into this courtroom, he's a sworn...
Okay, so I can like delete just that little gap and make it a little bit more fast. Also allows for a little visual change, which is nice. Problems with the state's theory of the case, it seems to me.
Was any question in your mind about the level of damage to that taillight at 5:07, all doubt was extinguished. When Dighton Police Officer Barrows walked into this courtroom, he's a sworn officer. He's not associated with Canton. He's not associated with...
When it's Mario Kart time, don't worry. I will give you the room code. And then you can join using the room code when it's Mario Kart time. So when it's time, don't worry. I will get... I don't even know what the room code is just because I haven't created it. But, you know, when it's Mario Kart time, the code will go on screen and everyone will have a fair chance to join. So don't worry, we'll get there.
With the Alberts, he's not associated with the McCabe's. He doesn't know Michael Proctor. In other words, he doesn't answer to any of these folks. He's an outsider and he's completely independent. And his words were the following.
We're gonna have
quote,
fun. It's gonna be great.
That taillight was not completely damaged. It was cracked. A piece was missing.
This is
but
DaVinci
not
Resolve. It's
completely
free.
Damaged.
Which is its chief benefit. I mean, that does seem to be like the photograph we just saw. If you could even say cracked, I can't really tell from the photograph, but yeah, not so much with completely damaged. The completely independent cop says it looked only cracked to me, maybe missing a small piece, but looked mostly okay. That seems to be more reflective of the image we just saw at 5 in the morning on the camera, unless we think the camera lies. But you know, okay, sure, fine. On the camera, unless we think the camera lies. But you know, okay.
Officer telling you so.
Yeah.
The reconstructed light on the left is what that light looked like before it was in Trooper.
Yep, delete that little bit, do a little dissolve, a little magic. It's great. Saw at 5 in the morning on the camera.
Which one looks like Officer Barrows' description?
I don't know whether or not you can reverse up to 25 miles an hour. I'm not sure whether or not we could test the state's theory of the case within Mario Kart. Probably not, but that would be hilarious. It would probably be a more accurate accident reconstruction simulator than anything the state used. So why not? Why not?
The reconstructed light on the left is what that light looked like before it was in Trooper Proctor's possession. Remember that. That's what it looked like before Trooper Proctor had access to the SUV. And you have an independent police officer telling you so.
Yeah, this image seems to be more reflective of the image I just saw from that camera at 5 in the morning. Seemed like the taillight was pretty intact to me. So if you said which of these taillights is more reflective of the image we saw at 5 in the morning on the video, is the left one more indicative or the right one more indicative? I saw an awful lot of red on that image. So I'd say, yeah, probably more like the left than the right, because I could see red, clearly red. But who am I to believe? Me and my lying eyes, I guess.
You'll recall that after John's body was discovered, Lang out.
They sure did. They sure did. When this is all over, we need to get Proctor a gift.
That's tough luck, but the guy who catches the case is Michael Proctor, a guy we go back with for decades.
Yeah.
Who catches the case is Michael. That's tough luck, but the guy who catches the case is Michael Proctor, a guy we go back with for decades.
Yep.
At such a break, they probably thought, when this is over, we need to get that dude a gift. Oh, wait a minute. They didn't think that. They said it out loud.
They sure did. They sure did. When this is all over, we need to get Proctor a gift. The guy that was investigating the independent guy. The independent guy who's investigating them, who knows the family and goes back with them for decades. We need to get that guy a gift. Yeah, maybe not as independent as otherwise first indicated. It seems possible. Yeah. Do you think he's still going to get a gift?
But still, you've got to imagine that the Alberts had to be stressed.
Do you think he still gets a gift?
Whole thing about a dead body being on their lawn.
Are they going to go to a trip together?
Some attention, and they had
you have some Mai Tais?
Will he set up a crime scene? Is he going to come into the house? Is he going to search the house? Is he going to send in a forensics? Nope.
Yeah, that pretty much sums it up. Feel like the investigation.
With that whole thing about a dead body being on their lawn. That might get some attention, and they had to be wondering, will he set up a crime scene? That might get some attention, and they had to be wondering, that might get some attention, and they had to be wondering, will he set up attention? And they had.
Shiny set of bracelets. I think he's going to probably quietly resign and wind up in a different law enforcement division somewhere. That's my working bet. He won't even be put on a Brady list. I have very low expectations for what's the consequences here are going to be. Indicated, it seems possible, yeah.
And they had to be wondering, will he set up a crime scene? Is he going to come into the house? Is he going to search the house? Is he going to send in a forensics team? Is he going to interview witnesses? Is he going to take us to the station? Will he take our phones? Will he look at our communications? Will he look at our Google searches? Will he look at our early morning phone calls? Is he going to look in the basement? And Michael Proctor answered every single one of those questions resoundingly. Nope. He's a...
Yeah, that pretty much sums it up.
Nope.
How do you find out who gifted you membership? I'm not sure if there's a way to figure out who specifically gifted you a membership. I'm not sure if there's a way to know specifically who did that. But our members are generous. And we do appreciate everyone who helps other members. And remember, it is only 99 cents a month to join. So we do make it literally the least YouTube will let me charge you, 99 cents a month. I understand that people's budgets can be tight, which is one of the reasons we try to make it as affordable as possible. Because I certainly know that when you're a member to multiple channels at $5 a piece, that can really add up after a while. You know, I've been there before on Patreon or something like that, and you're you know, $5 a piece can really add up after a while. So I very deliberately wanted to make it as inexpensive as possible so that it would not be a burden, even if you wanted to support other creators who might charge more. So I try to make it as affordable as possible. So it's only 99 cents a month, $1 an entire month. I know everyone doesn't necessarily have $1, but I did want to make it as accessible as possible and to help support the channel and show support. And we do have higher membership tiers, of course, at different levels. If you'd like to support us at a higher membership tier, we do have higher membership tiers if you'd like to join those as well. Those are, of course, always appreciated, but we did want to make it as accessible as possible. What do you get for your 99 cents a month? Well, for example, you get behind the scenes content. For example, editing streams are normally members only. Because we're on Verdict Watch, this one is public. But typically this would be members only content where you get to be part of the edit and contribute to the edit and provide suggestions. They also are a time when I provide more authentic, or no, authentic's the wrong word. I provide more of myself, I suppose, because I'm just much more free as opposed to like on a live stream, because typically I can pause and talk about other things. And so they allow for more dynamic in experience. So you get access to members only streams. You also get access, for example, to past gaming content. That's members only. You also get access to other off-brand content when I do things that are not legally related. You also get access to cool emojis You get the bee fish emojis and stuff like that. You also get your cool little scale by your name to represent the fact that you're an uncivilian, and just slightly better than the uncivilians, and that slight sense of superiority that you richly deserve for being a supporter of the channel. Plus, you get to help me eat, and that's nice. So if you would like to, please hit the join button. It would be extensively appreciated. We do really appreciate everyone who supports the channel on an ongoing basis. Thank you. Susan B gifted 5 gift memberships. Arkey Maine 1999 said, thanks for all the hard work, wit, expertise, and humor. Karen F became an uncivilian. Miss Mandy Rex gifted 1 gift membership. Cheryl Fodell gave $5 to say, thanks for making the membership so inexpensive. Then I can super chat from time to time. Of course, you're welcome. Back to the edit. For example, last night we did a recording that was members only. We did a VOD recording that was members only. So you get access to stuff like that. That's cool. Tekanos became an uncivilian. Thank you very much.
Nope.
Yeah, that pretty much sums it up. Feel like the investigation could have potentially been a little bit more thorough. Feel like perhaps some additional investigative steps might even be readily apparent, and you can also sub to us on Twitch if you have Amazon Prime for free. It is a bit cumbersome. ! Twitch should give you enough instruction. The complication with Twitch is that you have to renew it every month manually, as opposed to if you paid for it yourself. If you pay for it yourself, Twitch is more than happy to auto-renew you. But if you have your Amazon Prime membership and you're using that, you don't pay me. So you do have to renew it every month. So if you go over to Twitch and hook it up to your Amazon account, and the ! Twitch should give you the instruction on how to do that, and you sync it up, you can become a subscriber, which on Twitch is a paid option. It's a paid option. It costs $5, but if you have Amazon Prime, it doesn't cost you anything. It costs you $0. So I get paid. It doesn't cost you anything. I get paid, and Amazon gives me money, which is a net positive. It's a win-win-win for everybody. So we have 43 subscribers on Twitch right now. They're all just giving me free money. So, hey, if you have Amazon Prime, you can do that on Twitch, and it costs you nothing. It costs you $0. The only complication is that you have to renew it every month manually. So don't forget to set that calendar entry. Perhaps we should have pursued those, but Michael Proctor is here, and he's got the case cracked 18 hours in, and he doesn't need to do any of those pesky investigation steps. All right, sure. I'm sensing some problems here with the state's case in every possible way. Okay, let's keep doing this.
Boston Cop 2. And with that, Michael Proctor didn't draw a thin blue. And with that,
yeah, I'm sensing some problems here with the state's case. Can't get rid of that for the transition. There's going to be a lot of video. Possible way.
And with
I'm using DaVinci Resolve
Michael
for video
Proctor
editing.
Didn't draw a thin blue line.
Thank you very much, Sally Stone, for becoming an uncivilian. Thank you much, Hilde, for gifting 10 gift memberships. Thank you, Elise Lane, for gifting 20 gift memberships. They are appreciated.
A wall that you can't scale. A wall that Karen Reed certainly couldn't get over. A wall between us and them. A place you folks are not invited. We protect our own. It's us or it's them.
Okay, I just have to say, I have to take a moment here to just...
We protect our own.
Okay, delete that. Delete that. Do the transition here. Do this. We're only like halfway through this video. This is taking a while to
We
edit.
protect our own.
Okay, I just have to say, I have to take a moment here to just say, I really appreciate the way he just said the same thing like 6 times in a row. It's that whole repetition is the mother of learning thing. And he does it masterfully. He talks about the thin blue line being the thin blue or the big blue wall. And then he says basically that exact same thing.
Folks are not invited. We protect.
And he does it masterfully. He talks about the thin blue line being the thin blue or the big blue
So
wall.
I guess this video
and
gets
then
posted.
He says basically
this video
that
we're
exact
doing gets posted
same
at
thing,
3
but 6
or
different
3:30
ways.
because it'll be the end of the day.
Right, one after another after another.
What are
And
they
it is
deliberating?
just a masterful way of making sure the point gets home and not get lost. Repetition is the mother of learning, as my high school history teacher reminded me repeatedly. And this attorney has learned that lesson. Repeat to the jury, make sure they don't miss it. Very, very good rhetoric, very good illustration, strong choice of language.
Delete that little bit. Blend it together.
Imaginative,
The spinny fan continues to
visually
spin.
resonant. Really, really nice moment there. Good work.
It's the only reliable thing in the Commonwealth.
And by the way, who's she after all? Nobody. An outsider. This is gonna be easy. Or so they thought. Let's look at what Michael Proctor actually did and did not do in this case. One of the consistent issues
How are
that's
they
come up throughout this
deliberating?
trial is how evidence always seems to be changing and evolving when in Michael Proctor's hands or somebody in his orbit. If it happens once, let's chalk it up to a
They're going to
mistake.
convict, aren't they?
Twice,
They're going to really piss me
starting
off.
to look a little bit like incompetence. If that happens every single time, it becomes intentional, which means orbit. Look at what Michael Proctor actually did and did not do. In
There. Good work.
Let's look at what Michael Proctor actually did and did not do in this case. One of the consistent issues that's come up throughout this trial.
I mean, it's a clear not guilty just based on the image of the car at 507. It's a clear not guilty based on the image of the car at 507. It shows an intact light. So, no, it didn't. Yeah, no.
Is how evidence always seems to be changing and evolving when in Michael Proctor's hands or somebody in his orbit. If it happens once, let's chalk it up to a mistake. Twice.
Okay, I'm going to delete that little pause there because I don't need it. Delete that little pause there. They're going to come back with a guilty verdict and piss me off. I know it's going to happen. It's just been that kind of day.
In his orbit. If it happens once, let's chalk it up to a mistake. Twice, it's starting to look a little bit like incompetence. If that happens every single time, it becomes intentional, which means it becomes corruption.
Yeah, no, fair. It's a little bit difficult to say that it happens over and over and over again, so it's merely incompetence or a mistake. It's much more suggestive of a...
Michelle L. Belly for $4.99 says, "Hi, Sir Grumpalot." I suppose that's me. "Love your channel. Dr. Wolf said he reviewed the crime scene report. Is that what the jury was asking for?" All I can base on is what the jury said. They said they wanted the CERT report, and they already have all the evidence. So I don't know anything more than what the note said, but thank you for your super chat. Sir Grumpalot hurt me a little bit. I know you were trying to be probably cute, but depression is a bitch, and I'm sorry if I'm grumpy sometimes. I'm trying to do my best, and sorry if I'm grumpy. It's difficult sometimes. We press on. We do our best. Deliberate intent to not care and not look. Reckless disregard of his duties, or even intentional disregard of his duties because he was trying to protect the Alberts. Yeah, very, very sharp, well observed, good work. This attorney is fantastic. Let's listen to some more.
The defense spent some time, we spent some time discussing the tow time that Michael Proctor swore to in affidavits. There was a reason that we believed it was so important, and I want to talk about that for
A lot of typo.
a dozen times, a typo. You'll remember what that testimony was. The truth is that car was in Michael Proctor's possession from about 5 p.m.
Yeah.
That the plow drivers were out that night. There would be a witness, potentially.
That is fantastic. This is a potential eyewitness to the event.
Proctor not only did not interview Brian Lockwood, 34 Fairview had to hide human beings from you and from us. Or 16, when he finally had to tell the truth or some version of the truth. Those first pieces of taillight were not found until after 5:45 p.m.
Yep.
That is the very fact that Michael Proctor was trying to hide by those falsified.
Well observed, good work. You know, and on a different day, it probably wouldn't hit me a different way. It's not really your fault, incidentally. I wasn't trying to blame you. On a different day, I probably would take it in better stride. It's just one of the natures of depression, and there's no rhyme or reason to it that I can find that I've been able to deduce. Some days there's basically a bell curve distribution, is the best way I've thought to put it. And some days you're on one side of the bell curve distribution, some days you're on the other side of the bell curve distribution. And there's no particular rhyme or reason to it. The only thing I found that is consistent at all is if I have sort of setbacks, and they don't necessarily have to be big setbacks, but I just have things that just kind of don't go completely right. And if I have some setbacks, that has a tendency to push me a little bit into depression. But that's the only thing I've found, and I haven't really found a universal positive for it. So it wasn't your fault. It's just, maybe I shouldn't have said anything. Maybe it was wrong for me to say anything. It's just today it just struck me wrong. I'm sorry. I should have just taken it in good affect. I should have just taken it in cheer. I apologize. I'm sorry. This attorney is fantastic. Let's listen to some more.
Those first pieces of taillight were not found until after 5:45 p.m.
Yep.
That is the very fact that Michael Proctor was trying to hide by those falsified affidavits, saying he didn't seize the car until 5:30. But that wasn't Michael Proctor's only manipulation of the investigation. What about Brian Lockwood? Michael Proctor did his level best to not just hide evidence, but to hide human beings from you and from us. Michael Proctor was informed that the plow drivers were out that night. There would be a witness, potentially along 34 Fairview, at the exact times in question. Even Michael Trotta expressly told Michael Proctor that 34 Fairview had in fact been plowed that morning, and by whom. Proctor not only did not interview Brian Lockwood.
I've tried ketamine therapy before. It was intramuscular injection. I found it to be not particularly helpful in a long-term sense. It was okay while I was getting the therapy, but the ketamine therapy that I was having, the intramuscular, had a very quick onset and a very quick offset. And it had about an hour, maybe a little bit more of actual practical time. And I didn't really find any long-term change. I was on ketamine therapy for about 12 weeks. And so I didn't really find any long-term relief from it. I know it can do wonders for some people. Unfortunately, it just didn't do wonders for me. And, you know, what can you do? That's just how it goes. Entry required, give SE key 20, said tall blue wall, Fenway Park, green monster chance. Biblo Beggins became an uncivilian. Sonny R became an uncivilian. MLC became an uncivilian. I know my depression is holding me back as a streamer. I know it is. which is all the more insidious, incidentally, because the depression holds me back as a streamer, which contributes to the depression, and around we go. But we are growing, if albeit slowly.
He never disclosed his name in a single report.
Yep.
He hid him.
Yep.
This is a witness who was literally on 34 Fairview at the time in question where a body was found on the lawn. Wouldn't you want to get the truth from an eyewitness? Wouldn't you want to seek that out?
Yep.
Not if you're Michael Proctor, a close friend of the Albans. If it were up to Proctor, you literally never would have heard of or from Brian Loughran.
That is fantastic. This is a potential eyewitness to the event.
Or from Brian Loughran.
It also doesn't particularly help that I'm alone and single, to be quite honest, as long as we're discussing that, but yeah.
From Brian Loughran.
That is fantastic. This is a potential eyewitness to the event. Thank you, PJ Tyler, for the $5. The police would want to interview potential eyewitnesses to the event. Maybe he didn't see anything, maybe he did, but you might want to check with potential eyewitnesses. Seems like, that's something that police would want to do. And Proctor knew the guy. He knew his name. And he made no attempt to interview the Snowplow. No attempt. It didn't even appear in any of his reports. Didn't even appear, and the name didn't even appear. It's almost like he was trying to hide something. It's almost like he didn't want to look. It's almost like he was trying to hide an inconvenient thing that might somewhat change the narrative. Yep. No. Yeah, it seems like a deliberate intent to conceal. Yeah, I've heard good things about modern electroshock therapy, but I don't know if my case is severe enough to really warrant that level of intervention. I'm not sure a doctor would approve it, to be honest. I never really seriously considered it. To conceal. Skeeve Man gives me 10 pounds to say, take my money and hit me with that law, Daddy Uncivil. You know it, baby. You know it. Thank you for your 10 pounds. I do appreciate your and everyone else's support. Preach. One of the pieces that was supposedly
Interesting there by itself. From how? It didn't get there by being the glass on the bumper has nothing to do with the glass. She told you unequivocally the glass on the bumper did not match. She established to a scientific certainty that the glass on the bumper, which was told to you in opening statement, was going to have something to do with this case. The glass on the
Tracy D says $5 new subscriber, and I think you're great, Kurt. Thank you. I appreciate that. I'm glad that you like it. My strength, and my fellow law tubers would agree, is in my analytical ability, particularly as it relates to the U.S. Supreme Court. I am generally recognized by my peers on this platform as the leading expert in LawTube on Supreme Court analysis and my ability to understand and quote cases and understand it. So I'm generally seen as the leading expert among our peer group, which is validating. And I'm generally seen as incredibly analytical and also seen as very faithful to the law as a concept. So those are my strengths. And those are generally what people would say about me. And so it's nice to be recognized by your peers. That's validating, of course.
to you in opening statement was going to have something to do with this case. The glass on the bumper was going to match that cocktail glass. She told you unequivocally the glass on the bumper did not match the cocktail glass. They came from two different sources. The glass on the bumper has nothing to do with the cocktail glass. So that glass on the bumper had to get there somehow. It didn't get there by being broken from the cocktail glass. See the point? It had to get on the bumper somehow. It didn't jump up there by itself.
Yep.
And what's really interesting is that there was one piece on the bumper, one, only one, that matched something else in the case. It was a perfect match to a piece of glass that was supposedly found at the scene. Who do you think had possession of that matching glass?
Preach. Preach. One of the pieces that was supposedly found on the bumper also happens to match a piece that was supposedly found at the crime scene. Who possibly could have done this? Who had possession of the car? Who was it? Who could have done this? How did that piece get there? Yeah. I'm sensing some potential malfeasance by some governmental actors on this one. Also, I can do 750 pounds on the leg press for reps, 3 times 10 at 750. So that's not bad. Just saying. Sorry, Sky, for mispronouncing your name. Sky Veman.
Pounds of pressure.
Yeah, I mean, it should be.
That they now claim crashed into his arm. The DNA on the outside of the taillight housing also merits very little discussion. John's DNA would be expected to be found all over that SUV, inside, outside, the exterior, the interior, everything he touched would have had his DNA on it. Here's what's actually important about that DNA. No DNA was found on the interior of that taillight. The taillight that they now claim crashed into his arm and shattered. No blood was found anywhere on that
You love my
taillight
nose?
or any taillight
What else do I
pieces.
love about
No
myself?
tissue was.
What do I love about myself? Well, I do love my mind because I think it's my strongest asset. And I do love my ability to reason and logic and think because I think it's my strongest asset. That is what I love about myself. I also love my way to work through a problem in a very analytical way and find solutions to problems in an analytical way. That's what I would say I love about myself. Also, I have decent public speaking ability, which is nice. Also, I have reasonably decent acting chops. I've been doing improv acting for those guys who know. And I'm pretty decent at it. I know short form improv pretty well. Those would be things I like about myself. I'm loyal, potentially to a fault. Perhaps stayed in relationships I wasn't supposed to stay in for loyalty reasons. So loyalty, I'm loyal perhaps to a fault. I think I'm kind. I think that I'm supportive of others. Those are good qualities. Cheryl Fodell for $10 says, bro, and I'm honest, I'm truthful. Which I think is pretty self-reflective of what you see. I'm honest with you. I try to be honest about my weaknesses, personality issues, depression. I'm truthful. Those are good qualities. Cheryl Fidel for $10 says, Kurt, my bro-in-law has been going outside every morning lately, barefoot and walking around the yard. Something about reconnecting with the planet. Maybe that would help you also. Am I a good cook? I'm an okay cook. I'm not exceptional, but I do have a couple of dishes that I can do. I also make a good beef Wellington. I generally follow Gordon Ramsay's recipe, and I do a pretty decent job. But yeah, I can make soups and stews and chilies and other sort of things. I'm an okay cook.
Found anywhere on that taillight or any taillight pieces. But we're to believe that that taillight literally exploded on John's arm at 25 miles an hour with 1,000 pounds of pressure.
Yeah, I mean, it should be fairly obvious that those pieces, that the plastic on that is somewhat designed to not shatter into 1,000 pieces. It's built for that, to not shatter into 1,000 pieces. But so that's one thing. And then second thing, none of those pieces, which apparently, again, according to the state, according to their theory of the state, it is the shards of the plastic which somehow shattered into knife-like pieces.
Thank you for the $2.
Like plate glass. So apparently we are confusing plastic for plate glass somehow. And these knife-like pieces cut up his arm and made all the injuries, yet we found no blood on any of the pieces, nor any tissue on any of the pieces.
They're saying verdict is
and
in.
these are the pieces that are supposed to have caused
On
these
Law
arm
and Crimes
injuries.
chat, they're saying verdict is in.
That doesn't seem very plausible. I'm having a very difficult time with that one. Not one drop of blood, despite the many shards cutting up his arm. Not one drop of blood on any of the plastic or one piece of tissue. Yeah, no, I'm not really buying that story, government. Not feeling it.
We talked about the evidence doing very funny things when in Proctor's possession or the possession of somebody in his orbit. Now think about the videos that you saw.
I never tried
How many
ayahuasca.
videos appear to be somehow manipulated or
I'm not sure
altered?
that's legal
Just
in the
about
United
every single one of
States.
them.
Yep.
Look at the video of the Sally port. Let's take that one, for example. That grainy one. It's missing the exact time that would
Just got to love that. The video just happened.
or alter. We talked about the evidence doing very funny things when in Proctor's possession.
Oh, shit. Hold on.
Judge, we're back on the record on 22117. Counsel have both had an opportunity to look at the new verdict slip.
All right, so does the defense say the verdict slip's in order?
It is, Your Honor.
Okay.
Thank you, and we appreciate the call.
Okay, does the Commonwealth say the verdict slip's in order?
Yes, Your Honor.
All right, so the verdict slip will go in. Officer Delano, I'll let you do what you're doing.
Okay, I don't think there's a verdict because they didn't even have the verdict form yet. So I don't think there's a verdict.
All right, so the verdict slip will go into the jury. I instruct you or Officer Leiden to remove verdict slip for count number 2 from the jury, have the jurors fold it, put it in an envelope and seal it. And we'll bring that in and we'll mark that for identification. I'm also going to send in a transcript of the supplemental instruction I gave this morning. May we mark that? Madam Court Reporter, please. I have copies for counsel if you'd like. Yes.
So it doesn't sound like there's a verdict because they're still like talking about the verdict form.
All right. So with that, we'll be in recess. And you'll remember that the jurors were instructed that we won't take any questions or verdict during 1 o'clock to 2 o'clock. Okay.
I missed that last one.
The jurors were instructed in the instructions I gave yesterday that we will not take a verdict or a question from 1 to 2. So everybody's free to go for lunch.
Okay.
Court, please.
All right, guys. So no verdict, and there will not be a verdict at least until for another hour. So all they changed was the verdict form. So the jury's off to lunch, but verdicts very frequently come after lunch. I don't know. It's just a thing. I said this at the start of the day. It's like if you had to predict what the most likely time for the jury to come is like right after lunch. So they come back at 2. So a jury verdict at 3 would not be unexpected. So fortunately, we have an hour of no verdict. So that's good stuff. So, yeah. Vlad said massholes are going to masshole, and then Princess Caldwell become an uncivilian. Angela Cook for 20 euros said, I love your dry sense of humor and you've got kind eyes. Thank you. Now, if I could just find a woman that actually wanted to be with me, life would be good. fun. Let's see. Nope. Yep. Great. All right, good. Let's see. Go back to the edit. I keep hoping I'll meet someone through my channel. Leonard French did. Government not feeling it.
We talked about the evidence doing very funny things when in Proctor's possession or the possession of somebody in his orbit. Now think about the videos that you saw. How many videos appear to be somehow manipulated or altered? Just about every single one of them.
Yep.
Look at the video of the Sally port. Let's take that one, for example. That grainy one. It's missing the exact time that would show the condition of the taillight when it was pulled in to the
I'd
Sally
like to be
port.
your friend. That's not what I'm looking for, my friend. Yep.
Did someone not want you to see what the condition of the taillight was at that exact time?
You gotta love that. You've just got to love that. The video just happens to be missing the exact time of the arrival of the car, which would show, for example, the condition of the car, and just happens to be missing that segment of time. What are the odds?
But the good news is there's a second video. It's much clearer. And it's from the same time frame. We didn't get that one for about 2.5 years into the investigation.
I like that segment, right? So he starts with the videotape and how the witness said, oh, it's all fine and everything's great, but finally confronts him. And
that was not a mistake.
Yep.
And when caught in that obvious fabrication, right side of the car. And that trick might have worked. Did you or Trooper Proctor edit video showing what was clearly the right side of the car? The Commonwealth introduced you, was turned over.
Yeah.
And this is important. The Commonwealth introduced you to a person by the name of Yuri Buchanan. They presented video showing what was clearly the right side of the car.
When you're not looking, that's when you'll find her. I don't think that's how that works. And just happens to be missing that segment of time. What are the odds?
They presented video showing what was clearly the right side of the car.
Derek says $10. Love seeing you work with your twin brother. Question: who, if any, of your twin brother blogger bro has funny or sarcastic wit and dry humor? Well, Runkle the Bailey has also been noted for his sarcasm. So I would have to say Runkle, who I'm very good friends with.
They asked questions about the right side of the car. You'll recall, Mr. Lally asked Sergeant Buchanan, did you or Trooper Proctor ever go at, or near the right side of that taillight? And while he was asking the question, what appeared to be the right side of the car was looking at you. The video was still up. Buchanan paused, turned earnestly into the microphone, stared at you and said, never. We never went anywhere around that taillight. While he was showing you the right side of the car. And that trick might have worked until we got up to cross-examine him. And only then, on the second day of his testimony, did he have to admit that the video was actually inverted.
I'm in Houston, Texas.
It was backward.
Yep.
And it was cleverly inverted at that. The timestamp had the proper orientation, which means that timestamp had to be removed, the video inverted, and the timestamp placed back on it. Which means that was done intentionally. That was not a mistake.
Yep.
And when caught in that obvious fabrication, Buchanan doubled down and said, it's exactly the same. You remember that back and forth. It's exactly the same, he said, as if we're stupid. Is it exactly the same, or is it exactly opposite? Ladies and gentlemen, you were lied to. There is no other way to say it. It's inexcusable. It's abhorrent. But it's also a paradigm of everything that the investigators have been willing to do in this case. Lie, obfuscate, manipulate, alter. And when they're caught, they just excuse it away. Doesn't matter. It's the same thing. What's the big deal?
Don't show weakness
just look
ever.
the other way.
Yeah, that's a real problem. I agree. Yep. Well, I like that segment. Yeah, don't show weakness ever is probably correct. vulnerability is not attractive. I think that's unfortunately very true for men. So my showing vulnerability on the stream is a fundamental mistake. That's sadly true. I think that's true. So he starts with the videotape and how the witness said, oh, it's all fine and everything's great, but finally confronts him and proves it's inverted, and then uses that idea of that deception to then merge into a broader idea of deception, and then capstones the entire segment with that phrase, just look the other way, re-echoing the explicit theme from the start of it, and brings it back home here to emphasize the point and brings in the theme. This guy is one of the best storytellers for lawyers I have ever seen in my life. He is very, very good at story. He's very rich with his word choice and vocabulary. It's visually evocative. It's emotionally evocative. He repeats without it being repetitive. He uses slightly different words or slightly different ideas to echo the same point so you don't miss it. Brings in the theming.
Desperation doesn't play.
Brings in the idea. Moves from topic to topic in a way that's extremely followable. I mean, as far as storytelling for lawyers go, this guy is masterclass. I mean, you could do it a different way. It doesn't have to be done this way. There are other ways to go about it. So there might be other ways to do this in a way that would work, but this way is masterclass. So just bravo all around.
And don't forget, they were searching with their feet, and they even used tools, a leaf blower.
Can't forget the leaf blower. It's critical, my friend, who are working the scene. So 5 officers can't find a single piece, and somehow 47 pieces. But that's not
classical injuries from an auto pedestrian accident. That by itself, how hard is it to drop a piece of plastic? We spent a long time talking about the compromised and altered and tampered and manipulated evidence, and now I want to switch and talk a little bit about the true facts in this case, because you did hear some true evidence, and talk a little bit about the true facts. We spent a long time talking about the compromised and altered and tampered and manipulated evidence, and I want to switch and talk a little bit about the true facts in this case, because you did hear some true evidence and true facts. The Commonwealth presented about 67, maybe more, witnesses, and expended 30-plus days of trial and 9 weeks of your life. Maybe we're in the 10th week. For what? It should be relatively simple, right? The Commonwealth claims that Karen Reed pulled up to 34 Fairview. John got out of the car. She reversed into him and hit him, and then she drove home. That's 4 facts. It's just 4 facts. That's all it is. What evidence do they actually have to prove that that SUV ever hit John? The answer is none. They don't have any. There's no evidence whatsoever that Karen Reed's vehicle ever struck John O'Keefe, or that Karen Reed ever wanted to strike John O'Keefe. In fact, every single piece of material evidence in this case unequivocally proves the opposite. John went into that house. That SUV was not damaged by hitting John, and John's injuries did not come from being hit by a car.
Yep.
That's what the evidence actually shows. The Commonwealth knows that, and they've known it for a long time, and Proctor knows that. And because of that, the Commonwealth just resorts to character assassination and talking for weeks on end about the snow. Let's talk about what the real evidence actually shows, the unassailable science. Let's talk about the truth.
Can't delete that. Cut it there. Don't overthink it. Well, that maybe is a flaw of mine. I overthink everything. Maybe less these days, but definitely when I was a kid, I overthought everything a lot. My analytical ability and thinking ability is very high, and I tended to use it very extensively. So just bravo all around.
Let's talk about what the real evidence actually shows, the unassailable science. Let's talk about the truth. Concerning John's injuries first. The Commonwealth's own medical examiner, Dr. Scortibello, could not conclude that John was hit by a car. Think about that. And she would not even say that it was a homicide. She told you without any dispute in this case, quote, evidence pointing toward one manner of death is no more compelling than evidence of a competing manner of death, end quote. Her words, not mine. She went on to say it's just as likely that he was punched and fell backward. His injuries are consistent with that. In fact, in her expert opinion, his injuries are consistent with a physical altercation, as she testified, but they are not, in her words, not classical injuries from an auto pedestrian accident. That by itself is reasonable doubt. But the evidence...
I mean, pretty much, right? Pretty much. The state's own medical examiner said that these injuries are not consistent with a pedestrian accident, which of course they're not. No bruising, no broken bones.
Get fit, eat
no...
right. I'm trying, man. I'm trying very hard to get fit and eat right. Been doing these pre-made meals things for like 3 weeks. I've been exercising a lot more, as you can see from my community chat. I'm trying, man. I'm trying. It's, yeah.
Fractures from a 7,000-pound car going 25 miles an hour, all hitting his arm. Not sure I need an MD to reach the conclusion that 7,000 pounds of car going 25 miles an hour, all hitting his arm, should probably leave some sort of bruising and probably more severe damage. And even the ME has to confess the truth because, yep, pretty much it's bullshit to say this was done by a car.
And the truth goes far further. We introduced you to not one but two thoroughly credentialed medical examiners. We introduced you to not one but two thoroughly credentialed medical examiners, or medical experts, Dr. Sher.
Much it's bullshit to say this was done by a car.
We introduced you to not one but two thoroughly credentialed medical examiners, or medical experts, Dr. Sheridan and Dr. Russell, both of whom said John's arm injury is consistent with an animal attack. Dr. Russell studied, diagnosed, and treated up to 1,000 animal wounds. She's an expert in animal wounds, and she was unequivocal. Those wounds are from an animal, likely a large dog, which means that John was attacked inside the home where Chloe was. There is no other possibility. And Dr. Sheridan, for his part, with thousands of 13,000 autopsies under his belt, decades of experience as the chief medical examiner who's triple credentialed in anatomical, forensic, and neuropathology, he told you that John's injuries are inconsistent with a motor vehicle accident or incident.
I mean, that does sound like a lot of credentials between the two of them. The triple credential, pathology, emergency medicine, all the rest of it. Sounds like these guys might know what they're talking about. They don't buy it. Yep, that makes sense.
They're consistent, however, with a physical altercation. Scientifically, they were not hired by the defense.
Degree?
They explained, period. We should put it into this case.
Kind of sounds like reasonable doubt to me. Do they have an associate's degree?
Scientifically, did analysis, they evaluated, they reviewed this case, they did testing, they did analysis, they evaluated the case scientifically. They were not hired by the defense.
Oops. Well, they don't buy it. Yep, that makes sense.
They reviewed this case, they did testing, they did analysis, they evaluated the case scientifically. They were not hired by the defense, not by the Commonwealth. They're completely 100% independent of any party in this case. And they were equally available, by the way, to the Commonwealth.
But do they have an associate's degree?
They explained that John's injuries were not caused by being hit by Miss Reed's SUV, and that the SUV was not damaged by coming in contact with John O'Keefe's body. That should end the inquiry right there. Both sides of the equation. From a physics, engineering, and biomechanical standpoint, they established that John O'Keefe was not struck by Karen Reed's vehicle, period.
Yep. Yeah, I don't have an associate's degree.
that establishes
I
reasonable
don't have an
doubt
associate's
and
degree. Maybe I'm
stupidity in this
underqualified. I
case.
mean, I could always go get one, I guess. Kind of sounds like reasonable doubt to me. I mean, you know,
Plenty of community colleges
two
around there.
MDs and 2 engineers with many degrees. One of the MDs
Thank you,
literally
Roosevelt,
wrote
for
the
saying I should
book
teach.
on animal bites. One is a
For
forensic
saying I should teach law
pathologist,
classes, very kind.
studies this stuff. One is a biomedical engineer. One's a mechanical engineer. This is what they study. They do this for their living, and they're all like, nope. When we actually know formulas, we can tell you what the formulas are because we know science. So, yeah, I feel like that's quite a lot of reasonable doubt. Yeah, that's good.
But you guys are my students.
So instead of calling the ARCA
You guys are
experts,
my
which they
students.
had available to them, the Commonwealth chose to introduce you to Trooper Joe Paul. You'll remember
Yep.
his testimony.
Yeah,
I think I'm being kind.
You get a top quality education for basically nothing. I should charge you guys $10,000 a year or something. That'd be good.
so yeah, I feel like that's quite a lot of reasonable doubt. Yeah, that's good.
So instead of calling the ARCA experts, which they had available to them, the Commonwealth chose to introduce you to Trooper Joe Paul. You'll remember
Yep.
his testimony.
Yeah,
I think I'm being kind when I say that Trooper Paul's analysis lacked credibility.
I would somewhat tend to agree. I mean, you know, he does have that associate's degree, which I don't believe any of the defense's experts had. I don't think any of them had an associate's degree. So Trooper Paul does have that going for him. The only one testifying who has an associate's degree. And yeah, I mean, I found Trooper Paul's testimony at times to be slightly suspect, maybe a bit questionable, a little wanting, perhaps slightly underdeveloped, could have been a little bit more thorough at times, a little bit difficult to fully appreciate, and somewhat, perhaps, if I be so bold, even inept. Yeah, I did leave myself in wanting more. I have to be honest on that one. Trooper Paul wasn't really doing it for me.
Laughable.
I disagree.
Pavement before coming to his final resting place with his unbroken phone tucked neatly long enough for the sharp area of his arm. He makes
Yeah.
the absurd claim that John was even understand the issues themselves. He makes
Yeah.
the absurd claim that John was hit on the elbow area. Trooper Paul lacks the experience, the education, the training, the background, and the knowledge to not only render opinions on these issues, but to even understand the issues themselves. He makes
Yeah.
the absurd claim that John was hit on the elbow area of his arm by a taillight. He was spun to the left in a pirouette. His arm stayed on the light long enough for the shards of plastic to explode around him, scratching his arm even though he was wearing long sleeves, then projecting him 30 feet to the left, but not before making a stop to hit his head on either the curb or the pavement, before coming to his final resting place with his unbroken phone tucked neatly under his
Yeah.
body.
Yeah.
It's nonsensical. It borders on laughable.
I disagree. I don't think it borders on laughable.
Compare that testimony to Dr. Dan Wolf and Dr. Andrew Rinchler. Both PhDs in engineering, both top of their field in accident reconstruction, both published peer-review articles.
I really like that moment by the defense lawyer because he preempts an argument from the skip that understanding of physics or the human body or reality. That does seem literally incredible, as in not credible. Yeah, yeah, that doesn't. The best and brightest, Trooper Paul. 10.
And what of that right arm? According to the Commonwealth's best and brightest, Trooper Paul, John absorbed the entirety of the collision, the whole collision.
I do love the shade. I love the shade. The best and brightest, Trooper Paul. 10 out of 10 shade. I'm here for it. Good work, sir. I could really use a beer with some people in Houston. We could just get together for a beer. I could use a beer with some people. I don't know if there's people in the Houston area, but if there are people in the Houston area, we could join our Discord. Maybe there's enough of us we could get together and just have a beer. Maybe we can go to the waterfall. I assume there might be a waterfall in Houston. If not, we'll find one. We'll create one. I could use a beer with some people and just be like, yep. Maybe a beer and a slice of pizza might be nice.
With that 3.5-ton SUV entirely with his right arm, launching him some 30
Nate
feet.
is here, yeah. I could get
But
together with
amazingly,
Nate.
the arm suffered no break, no
I could
fracture.
get together with Nate and hang out.
didn't
That's fair.
even get
I was thinking, you know,
bruised.
other people in chat.
So how are those injuries properly
You guys,
explained?
collectively. Some of you guys might be
The evidence is
interested.
simple.
Might be fun to hang.
John got into an altercation.
We can
He
hang.
was punched. He tried to defend himself by putting his hands up. He may have even scratched his own nose by putting his hands in front of his face to defend himself.
For it. Good work, sir.
With that 3.5-ton SUV entirely with his right arm,
You'll be there?
launching him some 30 feet. But amazingly, the arm suffered no break, no fracture, and didn't even get a bruise. So how are those injuries tried?
Comedy
They
clubs is
cannot-
nice, yeah.
They cannot distance themselves.
We could have
from the
Buffalo
stench
Chicken. We could go to a
of
wing
him
place.
on
That'd be
this
fine.
case
I'm down
and
with
this
that.
investigation. Those secret
Great. We
group
could do some
chats
wings. Preach. We could do some wings.
illustrate the quality and character of his investigation. Remind yourself.
Is it really verdict? Is it really verdict? Well, my friends, that was a very good let me try again. Well, my friends, that was a very good closing argument. Okay, so let's see if there's anything more we can do here. I don't think it borders on laughable. Yeah, I'd like to have like another break if I could.
And what of that right arm? According to the Commonwealth's best and brightest, Trooper Paul, John absorbed the entirety of the collision, the whole collision.
I do love the shade. I love the shade. The best and
3.5-ton SUV entirely with his right arm, launching him some 30 feet. With that 3.5-ton SUV entirely with his right arm, launching him some 30 feet. But amazingly, the arm suffered no break, no fracture.
we could meet like at
didn't
Katie Mills or
even
something,
get
maybe.
a bruise.
Or somewhere in
So
that
how
area
are
might
those
be good.
injuries properly explained? The evidence is simple. John got into an altercation. He was punched. He tried to defend himself by putting his hands up. He may have even scratched his own nose by putting his hands in front of his face to defend himself. His hands were bruised and covering up. But as-
5 minutes, Mr. Jackson.
Thank you, Your Honor. As he continued, he got hit, a punch went through, and he fell to the ground, fracturing his skull. At some point during that altercation, the dog got a hold of him, and the dog was pulled away. Every single injury is...
Okay, let's try this.
He got hit, a punch went through, and he fell to the ground, fracturing his skull. At some point during that altercation, the dog got a hold of him, and the dog was pulled away. Every single injury is answered. Every single injury.
So if you guys want to actually meet up
Explained
today
by
or something, or meet up this week, join my Discord and like hit me up in general.
Ladies
So
and
if we
gentlemen,
can get together like 3 or 4 people, we can meet up somewhere in Houston. That'd be cool.
given what we know about the facts and the physical evidence in this case,
I would like. It'd be nice to meet some
How did we
friends.
end up here?
I'm down for
We
some
ended up
friends.
here because of relationships, insider trading, playing the who you know game, and building a tall blue wall, which takes decades and generations. But the real question is it going to continue? Will this festering malignancy that allows a lead detective and his supervisor to gloat and sneer while while looking over naked pictures or looking for
So if
naked
there's 3 or
pictures
4
of
of
the
you
woman
who are in
they've
Houston,
targeted, will that continue?
we'll get
And
together
the
for
answer
some
should
beers.
be, not if you have anything to say about it.
Let me know
Michael
when.
Proctor's
Tonight would be
the lead
fine.
investigator in this
If you
case,
happen to be in the
and much
area.
as the
But it'd be
Commonwealth
helpful
likes
to have a couple
try,
people, because I just
they
don't want to
cannot-
come for like one
they
person,
cannot
obviously.
distance
But it'd
themselves
be helpful to have like 3 or
from the
4 people that
stench
said yes.
of him on this case and this investigation. Those secret
Great.
group chats
Preach.
illustrate the quality and character of his investigation. Remind yourself how an, quote, unbiased and
thank you, Republic.
objective investigator, someone who's supposed to be looking for facts. Ask yourself, how did he approach his job? Late at night, sitting there in his office,
You're in Houston,
deviously
Weezy?
looking for naked pictures
Cool.
of Karen
Message me
Reed
on
and
Discord
talking
in
about her
general. If we can
like
get a
she's
couple
piece
group
of
people
meat.
together, we'll put it together.
Talking about her bodily functions, her medical conditions.
I'm willing to
calling her
drive. I know
vile
Houston's
names.
big, but
I
I'm
don't
willing to
even have
drive
it
if we
in
can
me
get enough people
to
together.
repeat what he said about her. He reduced her
We can go downtown or
to an
something, I don't
object,
care.
and he went further by insulting her. He went further than insulting her, and he dehumanized her. And when he was done betraying that very humanity, he wished for her to commit suicide. That, ladies and gentlemen, is how you frame someone. That's how you dehumanize someone so viciously that you can just pin
We
it
could
on
get
the
ribs,
wall
we could get wings, we could get pizza.
and cover for the
I'm down for all
homeowner
these options.
because
These
he's
all
a
sound
Boston
fine.
cop. That's how you rip a person's life apart
get some
and
Mexican?
sleep like a baby while doing it.
Mm-hmm.
And
I haven't really
further
been to a
that
really great Mexican
by saying,
restaurant
"I
in
hope she
Houston. We could
kills
go to,
herself."
maybe there's a really good Mexican restaurant we could go to.
Ladies and gentlemen, I just began the discussion this afternoon or this morning with a quote about the truth, and I did that because that's what this case is about. Top to bottom, tip to tail, it's about the truth. Not hiding it or concealing it, but exposing the truth. The truth is immutable. It's not a feeling, it's not a whim. It's unflinching, it's unchanging, and it's everlasting. That's why the law is steady. That's why it's not captive to the whims of people drunk with power who think they're above the law, who think they're above
Nova Scotia might be a bit of a
scrutiny.
hike.
That's why you stand as the guardian of justice and the protector of justice. The law demands the very integrity that Trooper Proctor and his investigation lacks, and it requires that you cannot convict Karen Reed unless the Commonwealth has met its incredibly high burden to prove every element beyond a reasonable doubt and to a moral certainty. And a moral certainty
EU
is
might be
defined
even more
as
of a
the
hike, to
highest
be
degree
honest.
of certainty possible in
might
matters
be difficult
related
to drive.
human affairs. It's the highest degree possible in your life. That's the level of certainty. And I'll leave you with this. You have the most powerful tool known to American jurisprudence. The highest degree possible in your life. That's the level of certainty.
I might cut it
And I'll
there.
leave you with this. You have the most powerful tool known to American jurisprudence because you have your vote. No one can take that away from you, not me,
Las
not the
Palmas?
Commonwealth, not the court.
Okay, try to keep that in
You may
mind.
not have asked to be here, but each of you have given something very special of yourselves. You've agreed to do that, which is the highest calling a
probably skip
citizen
this part.
can answer in any way. You've agreed to give your community
They're saying the jury's coming back in. It's there's a debate about why, but all I see is
your life. That's the
yep. I think that's the place to cut it. All right, guys. I think we have it down. I think we have got it down. We've trimmed this hour close to 15 minutes with commentary. So for a short, this is going to be a fairly lengthy video. But that's what I came up with in my edit. Let me see if I made all the transitions. Sure was like a way to do this in bulk. Props for doing my own editing. Came from necessity, to be quite honest. I just simply can't afford someone to do my editing. It's too expensive. People want too much money. So I was like, okay, well, I'll just do it myself. Fortunately, I don't mind the sound of my own voice too much, so that's fine. Just adding in all the cross dissolves I missed along the way. So it doesn't jump. In case you're wondering what I'm doing, just checking to see the cross dissolves are there. Oops. See, there's one I missed. So it doesn't jump when there's a cut. Yep. Do that. Do that. Do that. Do a cross dissolve there. Okay. All right. Do we listen back to it or do we just say it's fine? Hopefully it's fine. Doing a second pass would take a long time. Lifetime fitness is great. Sitting in a sauna for 30 minutes burns 600 calories. I didn't know that. That's interesting. I have a little portable sauna somewhere in my house. You know, one that folds up and stuff, a little infrared portable sauna. I could try to figure out where that is. I bought one time on Amazon. What if there's a way to play it back at faster than 100%? So that you don't have to listen back to it at 100% speed. I don't know. All of Texas is sauna, that's a fair point. You burn more calories in cold? That's probably true. Because you have to heat up, so you burn more heat. That's probably true. Yeah.
Look the other way. Look the other way. 4 words that sum up the Commonwealth's entire case. 4 words that sum up the hopes of those who have tried to deceive you. Conflicts of interest? Doesn't matter. Just look the other way. Magic hairs. Magic glass. Look the other way. Late night calls and Google searches, falsified affidavits, inverted videos, and butt dials galore. Just look the other way. That's what they want. That's what they're counting on, but the uncontrovertible fact is you have been lied to.
I'll get a girlfriend and we'll
in
get
this
a puppy
courtroom.
and we can all go on walks together.
And your
It'll be
job is to
fun.
make sure you don't ever look the other way.
We can
All
go on
right,
walks
really
together.
strong opening here and really strong thematic elements.
Really,
This is
Kurt,
really
really
good.
what?
So in the same way he
What'd I
started
say?
his opening with Karen
What'd I
Reed
say?
was framed, strong thematic, strong element. He chooses the phrase "look the other way" as his thematic element. And so he
What do you mean, really?
echoes
What
that
did I
phrase
say?
several times and gives an example. So this is an example, once again, of a very strong, powerful opening. He starts with a simple phrase. In the opening, it was Karen Reed was framed. Here, it's look the other way. It doesn't have to be complicated, and it's not complicated. It's very simple, sets the tone, and establishes a strong theme that will carry us through. So, outstanding job, as always, right from the start. I am intrigued.
Your singular duty is to stare down the evidence and do it unflinchingly and do it unwaveringly. You see, you're the
can
only
just
thing
ship it?
standing between Karen Reed and the tyranny
So we don't
of
have to listen to it
injustice.
and we can just
All
play
right.
Mario Kart?
It's a job you didn't ask for, probably a job you didn't want. But it's the greatest responsibility we have as citizens here in America.
All right, there you
Unless
go.
the government stops
If you need an
answering
editor,
to us, and we start answering to the
The
government.
problem is I need like turnaround
I
times.
mean, you know, I love
need
the
something I can depend on
patriotism
reliably.
and this.
And low betide anyone, any one of us. No vice so mean, so pitiful, so contemptible, and those who permit it grows.
Very good there.
Ladies and gentlemen, there was a cover-up
Really strong opening as
in
opposed
this
to really
case,
strong
plain
closing?
and simple.
Well, I meant a really
Surely
strong
say
opening to
yourself,
the
I don't want to believe
remarks.
it. I don't want to believe that could happen in
It's
our
a strong
community.
start, I guess
But
I should have
sadly,
said
over the
instead of
past 8
opening.
weeks,
I should have said start
seen it.
instead of opening.
Right before your eyes.
Fine.
So how does a cover-up happen? How could that happen? Well, let's count the ways, shall we? Handpick your investigator. Make sure it's someone we know, someone on our side. Keep him close. Offer him help. Offer him a gift. Have secret friends and family meetings. It's not that it could happen. It's that every single one of those things I...
All right, for my money.
What are the words that every single person who testified in this case used?
You gotta love.
But what's the real evidence?
Really effective use of the evidence here to...
Because by 12:32 a.m., the phone was taking 36 steps and logging 25 meters at 12.
Well, that's a bit of a blow on the state's...
That brings up another...
Yeah, multiple but...
Another...
I really... All right,
But the odd things
I'm
keep
shipping it.
piling up.
I'm shipping it. I'm tired of looking at it. I'm shipping it. I'm tired of looking at it. All right. Send it. All right. I need to use the restroom. I need to use the restroom. I need to eat some sort of food product, and then we can play Mario Kart. Are you guys down for that? I hope so, because that's what's happening. We're doing those things. Yeah, we're playing Mario Kart now. So get out your Nintendo Switch. We're playing some Mario Kart after I have lunch. Probably take about 10 minutes for me to do those two things. So we'll take a break for about 10 minutes. You can talk amongst yourselves. We will return. I'm not stopping the stream, but you guys will be about 10 minutes long, and you guys can, chill out until we come back. Oh, Lord. Hello. How you doing? We're back. All right, let's see. Okay, I got my verdict watch screen up. All right, let's get the earphones in. Huh? Let's see. Okay. USB, no audio. Why do I not have any audio? Do 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 see, no, I don't want negative infinity. I'm not sure how that happens. There we go. Let's see. Who do I want to be? I'll be Toad. All right, guys. L300B, if you'd like to join. We can play together. L300B, if you'd like to join me playing Mario Kart, I'd love to have you. The best thing about the end of this trial is we'll never have to hear their voices again. You're not including the possibility of a mistrial in that calculation. Watch there be like a jury verdict like as soon as we start racing or something. This may be a very, very short match. With 1,000 of you here, I thought there'd be a few more people with a Nintendo Switch. Well, the three of us can play, I guess. Murphy's Law, if something can go wrong, it will go wrong. Yeah, maybe something like that. Will it possess Lally to bring this case again? That's a fair point. Maybe he's just a glutton for punishment. Maybe it's just the way he likes to roll. I have a Switch, but no Mario Kart. Mario Kart's awesome. I believe people can join while the game is underway. So, stupid work. Yeah, some of you guys might be at work. That's fair. That's fair. Just can't play and work at the same time. Fair. Fair. I can. Lawyer You Know had 40K earlier watching. He's crushing it recently. I'm not sure exactly what his secret is, but whatever it is, he's doing something right. All right, let's go ahead and just get started. No teams. We'll do normal items. We'll do hard computer. We'll do all vehicles, 4 races. Sounds good. Yep. Random, I don't care. Who's my favorite Mario Kart racer? I don't really have a strong favorite. Could be the hair. Yeah. Lawyer You Know is doing something right with 40K watching. I'm telling you what. He's got like 400. He's got 400,000 subs, 40K watching. It's unbelievable, man. Could be the attractiveness factor. He may be more attractive than me. I think that's a strong possibility. But does Lawyer You Know have Mario Kart? I don't think he does. Maybe like he pays his team. Design his streams. I don't have the money. I wish I did. I just don't have enough income to support it. He has more people, so he has more money. So, you know, rich gets richer and such. You know, I just don't have the money to support, to pay anybody. Yeah, Lawyer, you know, has an entire team of both timestamp, take notes, and design his streams. Fair. I got you with the green shell. Nice. What? Go up, thanks. Oh, thanks for saying the best. Well, the biggest audience ever, I believe it. Yeah, it's a huge audience. Yeah, this is Switch, Nintendo Switch. Yeah. Do you think she can be convicted? I don't think she should be convicted, but apparently the jury's deliberating something. So, yeah, I'd have to say there's some chance. I think they're back. I'm watching the feed. I'm not seeing anything in the court long crime feed about them coming back. And they would have just gotten back from lunch. So. How do I play and keep an eye on the chat at the same time? If I could pay you guys, I would. Mods, I mean, I'd pay the mods if I could. You just don't bring in enough revenue to justify that. Sucks. How long were in-house deliberations? It's been 3 days. If I researched correctly. It's been a while. I think they were 3 days. We should sign up the fan for an OnlyFans account. It'd be awesome. We could just have it on the loop. Just record thing on the loop, and that would be the OnlyFans content. That'd be funny. Yeah, Lawyer now has an entire law firm sports channel. That's fair. Yeah, I do my best to give my best legal analysis. This really should be not guilty. It should have been a very easy not guilty, to be quite honest about it. The fact they're still deliberating makes me exceptionally nervous. Honey and Salt gives $4.99. Thank you very much. This is an even easier not guilty than Kyle Rittenhouse, in my humble opinion. This is the most batshit crazy case we've seen by far. So, yeah. Come on. Yeah, what should we call the fans only fan account? Treehouse Guy and I have texted briefly. He is not particularly interested in legal representation at this time. Yeah. Or at least he wasn't at that time. Maybe that changed, who knows. I wasn't in that conversation suggesting me. I was just saying he needed a lawyer desperately. He already has. I'm pretty sure he has lawyers that would represent him where competent in this case. On-Lee fan? That's not bad. On-Lee fan. Hot Massachusetts action. I spin for you, baby. I spin for your donations. I do a nice turn on the dance floor. Potential. So there's a guilty holding out is pretty reasonable. Someone who's just like, nope, I'm gonna convict her or something. I don't know if either of the either if the lawyers made it onto the jury. If either of the lawyers make it onto the jury and they convict them, I'm going to be particularly disappointed. The lawyers should know, obviously know better. And we could find other fans, maybe. And we could have like a stream of different kinds of fans. I'm sure it's been done before, though. It wouldn't be an original idea. I'm sure someone's done it before. We could also just have an OnlyFans account where I'm just uploading the same content I always am. I mean, probably no one would subscribe to it, but it would be kind of funny. You know, an OnlyFans account that's just a creator. Just creating, you know, normal content. Am I playing Nintendo Switch? I sure am. Mario Kart 8, you got it. Yep. You're more than welcome to play with us. They had a cop on the jury? Not a cop to the best of my knowledge, but I thought they had 2 lawyers. I thought they had 2 lawyers. I don't know if they had a cop on the jury or not. You think a cop would have preemptively struck?
Maybe. You would think the lawyers would be preemptively struck, but apparently here we are. Yeah, my understanding is that there were lawyers on the jury. That's my understanding. I might have been mistaken, but this is what I had heard at one point. Lawyers are the worst to have on juries? I've heard lawyers say that lawyers are the worst to have on juries. I'm not sure what that says about anything, but I've definitely heard that. Yeah, I think DUI might be just a rite of passage up there. Like, if you don't have a DUI, who are you even, right? Yeah, I don't know if they both made it onto the jury. I was like, well, even one of them made it onto the jury, I really hope the lawyer would be like, this is some bullshit. A lawyer who convicts, man. But then again, there was that judge who just got thrown off the bench in Georgia because she was super duper corrupt. After weaseling her way into being the highest paid judge in the entire state, this brand new judge, first term judge, probate. She deals with wills and such. Okay. She weasels her way into being the highest paid judge in the entire state by far, by basically crying racism. And then she does a whole bunch of corrupt shit. And yesterday, the Georgia Supreme Court threw her off the bench for 7 years. I wound up 4th overall. Alright, I guess that's something. Can they get in trouble for not participating? Not really, no. If they just refuse to participate, no, they can't really get in trouble. Alright, we'll see if anyone else wants to join. L300B, you're more than welcome to join as we're waiting for a verdict. Give you a chance to join. I'd love to have you here. Otherwise, it'll just be the 5 of us. That's fine too. Cat in Virginia gives $1.99. Thank you very much. That's very kind. Mostly female jury. It was in the, it was before they eliminated it. It was 9 to 6. I'm not sure what the, yeah, 7 years. She's kicked off the bench for 7 years. Yeah. She can't serve as a judge for 7 years. Yeah, that's what they said. She might get disbarred. We'll see. The jury is now 6 men, 6 women. Okay, there you go, 6 to 6. Okay.
So they kicked off 2 women. That's interesting. I mean, just by random chance, I guess. JC says, Frazar 199.99. Good evening, boss. Any chance we can turn down Mario Kart so we can hear you? Sure, of course we can. It's already pretty low, but I'm happy to turn it down more. No problem. I'll cap it down at -30, so that way you won't have to worry about it as much. Thank you for your super chat. I appreciate it. Brought the Mario Kart volume down to -30, so my volume should hypothetically be at least 10 decibels louder. South African? Real or something? That's cool. Is jury IQ deficient or maybe tainted? I don't know, man. I don't know. Mario Kart is greater than Ceiling Fan. That's definitely what I'm going with. 30,000 people are currently watching a Ceiling Fan, which is kind of hilarious. $29,785 people are watching a Ceiling Fan. I'm one of them. Who knew? Who knew, right? If it's guilty, I will be sad panda. And it looks like guilty. I'm not sure what they can find her guilty of. I don't think they really can. I don't think they can find her guilty of anything. I just don't. I don't see how. For me, that picture of the car at 5:07 in the morning with an intact taillight. That taillight is intact. How do you look at that and be like, oh yes, this car was in an accident that shattered its taillight 3 hours earlier? That seems pretty. It seems pretty damning to me. This beats listening to Lally. That much is true. There's not much that doesn't beat listening to Lally. That much cannot be denied. 1 rand is 55 cents American? Okay. Oh, it's 0.05 cents American. Okay. So it's a nickel American. Okay, that's fine. I appreciate it. So you gave me 200, so that's 1/20th. So it's what, $10 or something? Okay, that's cool. I appreciate it. Thank you. Will the judge say JNOV? Not a chance. She should, but she won't. If the judge JNOVs it, I will be amazing. It will give me some hope. But it's not going to happen. There's no way. It's not going to happen. I will happily take your donations in any currency. All the currencies are welcome here at Uncivil Law, as long as they're recognized by some government somewhere. You know, yeah. Do people with medical issues go to a prison with accommodations? Yes, or more to the point, they're given accommodations usually in the prison. They're not usually given a special prison, but sure. Depending on their condition, they would have to be accommodated to their medical condition, medical necessity. Yeah. Was JNOV? Judgment notwithstanding the verdict. It's the judge overruling the verdict. Is JNOV. It's where the jury says one thing and the judge says another thing.
That's J-N-O-V. Judgment notwithstanding the verdict. It's J-N-O-V because it's Latin. Judgment non-observant of the verdict, if you want to say it in Latin. But we call it judge notwithstanding the verdict in English. And now you know. The acronym is Latin. So. It's where the jury says guilty and the judge is like, no. And in a criminal case, it doesn't go the other way around. The judge can't overrule a not guilty, but they can overrule guilty in a criminal case. In most jurisdictions, local laws may change. Some jurisdictions restrict the ability of judges to do it, but that's what it is in principle. Did I do a video about Florida decreasing the vote for a death penalty? I don't know if I did a vote about it, but it's almost certainly unconstitutional. It's almost certainly unconstitutional. Yeah, jury, they do 8 out of 10. Yeah, that's almost certainly unconstitutional. I'm sure the Supreme Court of the United States will tell us that in about 5 to 10 years. I'm going to cover Baldwin? Yes, I am. I'm going to live stream it. It's just too big a case. It's too big a case. I would imagine it's going to bring in a lot of traffic and a lot of subs. So I'd be somewhat foolish not to cover it. I don't know if it's going to get into Johnny Depp territory, but it probably will be popular, I'd imagine. So yes, we will absolutely do Baldwin, gavel to gavel, if there's any interest on this channel at all. Right? So as long as we get like any sort of traffic, we'll do it. If the jury hangs and there's a retrial, can testimony from this trial be used to impeach? Yes, it can. They can use any, well, you can use any statement, really, whether it's under oath or not, but especially a statement under oath. Sure. So if in a later trial, and you already seen that done, incidentally, you've already seen that, because people were impeached on their grand jury testimony, which was also under oath. So you've already seen that happen. So yes, if there's a mistrial, you could absolutely impeach them for any inconsistency between this trial and the next trial. Absolutely. You can impeach them on any statement basically they made in any context. Sworn statements obviously are better, but yeah. You think my bias is obvious? I don't think I'm biased. Judgment's not the same thing as bias. I've talked about that before. Having a strong opinion is not the same thing as bias. If the scales are heavily weighted, they're just heavily weighted. So saying the scale is heavily weighted, if it is in fact heavily weighted, is not bias. That's just accurately saying what the scale is. So I don't think I'm biased. But that's what I think. What are the charges for Baldwin? Involuntary manslaughter. Unintentional killing of another. Involuntary manslaughter. He faces up to 18 months. The same as Hannah Gutierrez Reed. Yeah, a judge cannot discard an acquittal. That's true. Not guilty is not guilty. A judge cannot discard an acquittal. Not in the U.S. Yeah, we've watched the trial and come to a conclusion based on the facts. That's right. And I've tried to show my work along the way. You know, to show why I think certain things. If it was found by the feds there was a cover-up, would they be able to charge only officers or the accomplices? Probably only the officers. It would have to be state action in order to charge non-state actors. I don't even know if that's possible in a criminal context, whether that's possible or not. But if you could, you'd have to show such a deep entanglement they became state actors, assuming it's possible in the first place. You can do it in a civil context, where you say that this person is really government because they're so entangled. I'm not sure whether or not you can do that in a criminal context. The guy who pulled the trigger gets the same punishment as the employee? Yes. Because they're charged with the same crime and held him manslaughter, so that would be correct. Or of course he could get less. Because his sentencing is independent. And his guilt is arguably lesser than the employee, to be honest. So I wouldn't be surprised, even if he's convicted, if he gets a lesser sentence. Or potentially no sentence. His defenses are a lot more interesting than Hannah Gutierrez reads, to me. I think he has a decent shot at not guilty. It should be a very interesting argument. Or at least it could be a very interesting argument, depending on how they go about it. So if they argue the case that I have in my head, because I've thought about this, if they argue the case I have in my head, it'll be an interesting argument. If they make some other kind of argument, then we'll see. The argument I have in my head, in case you're curious, the state's argument in my head is a gun is an inherently dangerous object. Everyone who handles a gun knows that they're dangerous and have to be checked. It's the person who holds the gun who's ultimately responsible. Plus, by the way, here are various armorers from other movies he's been on that will all testify that he's been told that it's his responsibility. Plus, here's whatever, association he's a member of that says in their guidelines that actors are responsible. And he has, in fact, had this training on multiple different occasions and is well aware of the dangers of guns. And he chose to operate the gun without double checking, and this is his responsibility as he's been informed multiple times. So that is roughly the state's case in my head. The defense's case in my head is, okay, Baldwin is an actor. That is what he does. He does not, for example, check the rigging because he's not the safety coordinator. He does not, for example, check the electrical lines because he is not the gaffer. He does not, for example, check the film because he's not the filmographer. He relies on everybody to provide him things, including things that go to people's safety and his own safety as it relates to, for example, stunts. And he relies on those things, and he relies on the professionals. And he was told by a person that was a professional that it was a safe gun, and he was reasonable for relying on that representation, and therefore does not have the reckless state of mens rea. He was not reckless because it was reasonable for him to rely on the professional that gave him the representation. That's what I imagine the defense's case would look like. And then it just becomes a question of which of those narratives is more compelling to the jury in the end. That's what I think. We'll see what they do. I'm not sure the degree to which he's a producer will matter. I imagine the state will mention it, but producer can be a title without any particular meaning, and I think that that's true here. So they might try to mention that he's a producer, but unless he actually had a hand in hiring her, which I don't think is true, I just expect them to be like, producer is a meaningless title. It's just given out as a courtesy for people who sufficiently contribute to a project. And, so we gave him the title in lieu of pay, for example. So I don't think the producer argument really goes anywhere unless he actually had a hand in hiring her, which I don't believe is true. But that's assuming that the state and the defense make the arguments that I think are interesting. They may think other arguments are interesting, and it'll become if they have better arguments or lesser arguments. But those are the best arguments I got in my head. You sound way less political. I'm just trying to give you a legal analysis. It's like, can I find a legal argument? That's my job. I'm a legal educator. It's like, can I find a valid legal argument here? It's like, yes, I think I can.
And it's like I just illustrated to you. And just do my best to give you an honest legal assessment. That's what I do. But thank you for saying it. It makes me feel better. Baldwin is an ass. That's not really a good legal argument, no. The jury may think that, but they're not supposed to. Yeah, only the officers can be charged. Only government officials can be charged by the feds. I don't really see how anyone else can be charged by the feds here. I don't... Unless they can charge them with some sort of tangential crime. So they might be able to charge them, for example, with lying to the FBI, if they can prove that. Because these people were interviewed by the FBI. And so if they can prove that they lied, they might be charged with something like that. So they might be charged with some tangential crime. But it would only be a crime relating to the feds investigation. Obstruction of the feds or lying to the feds. Perjury before a federal grand jury. Something like that. But otherwise, the feds have no jurisdiction. So, alright, I didn't do so well that time. I came in 11th. How would I argue for civil asset forfeiture? If I had to? Well, I'd say that no one is entitled to the proceeds of a crime. And it is civil in its nature, and the standard for a civil case is preponderance of the evidence. And so we're just doing the same thing that we do in any civil case. I think would be my foundation, my argument. If I had to make it. Should we do one more Mario Kart? Should we do another one? Is there something else you guys would rather be doing instead of Mario Kart? We could do something else. We could do like some other Supreme Court cases from recent terms. We could go through some Supreme Court stuff. You guys want to do that? We could just do some Supreme Court stuff. Let's do one more, and then let's do some Supreme Court stuff while we're waiting. We'll do some older cases. Well, by older, I mean like a week ago. I'm not sure how I can get to criminal negligence. Fair. Well, we can't give you. I can't give you the Karen Reed verdict. I don't have it, so I can't give you what I don't have. What is the power of a court to adjudicate issues presented in the case? I'll take why Lancer is a jackass in over his head for $500. Funny. Am I covering Alec Baldwin? Yes, I will be. Yeah, we'll do some Supreme Court stuff while we're waiting. I can't give you the Karen Reed verdict. I can't give you what I don't have, guys. That is beyond my power. I am sorry to say. I know you think I'm all powerful, but can't do it. I can keep screaming not guilty into the void, but I'm not sure how much it's helping at this point. We could always rewatch Lally's Close. Maybe it gets better the second time. Maybe if we watch it and take pauses at every time he says something that, you know, is intelligent, we could squeak out another video out of this trial. Yeah. If the jury convicts, I suppose maybe I'll have to do a breakdown of Lowry's clothes. Because apparently, somehow, some way, I guess they were persuaded by it. So I'll have to go back and try to figure out what the jury heard, I guess. What, if any, points did Lally make in his closing argument? That could be a fun stream. And then we'll have to have a content warning. May induce insomnia. Do not watch while doing heavy machinery. Am I the one playing this? Yeah, I'm playing. I'm just, you know, not doing particularly great, but that's okay. I'm just hanging out and having fun. But yeah, I'm playing. What do you think? What do you think I'm doing? I'm just watching someone else's stream. Yeah, I'm playing and talking to the chat. I'm just that good, or not. Oh, I got hit by a green shell. That sucks. I'm Toad. I'm Toad, and I'm dominating. Gotcha. They fixed the issue in the jury instructions. They fixed it. Not that there was anything wrong with the jury instructions. The judge would like to let you know there was nothing wrong with the jury instructions, but they did fix it. They clarified. You listen to Gideon? Cool. Yeah, how much oral arguments have changed? Yeah. It's pretty interesting, isn't it? I never listened to Gideon versus Wainwright oral arguments. That could be fun to listen to. I think they started doing oral argument recording in 65, something like that. Let's listen to Binger's closing argument. His closing argument was good in the first half. And then in the second half, not so much. But his closing argument was still better than Lally's by far. I'd rather listen to that, or I'd rather listen to that closing than Lally. I'd rather listen to almost any closing than Lally. Listening to Gideon was like having molasses in your ears. It's funny. The oral argument was probably longer too, wasn't it?
because I don't think they had standardized on the 30 minutes per side yet. At that point in history, they're probably a long before argument. Third time you've had to resubscribe as a member? I'm sorry to hear that. Yeah. I'm surprised it's taking us long to deliberate too, man. I really am. The rebuttal in the Rittenhouse case with, yeah, that was interesting. Everyone takes a beating sometimes. Not one of the sharper moments of legal history. A badge simp on the jury. The Rittenhouse prosecutor was pretty good in the open. The opening was very good. I seem to remember rating it fairly highly, like 9 out of 10. It was very well organized. His closing was good in the first half, and then the second half, not as much. But he was a better prosecutor than Lally is. Not that it's hard. And he had more to work with, and it was even more intellectually honest. Not by much, but still. I don't know anything about Fort Worth or what happened in Fort Worth. So you got me on that one. Do I think there will be a verdict by the end of the day? I think there will be a verdict 3 hours from now. Yeah, they go home in an hour and change. Yeah. Are we doing Verdict Watch tomorrow? We might do Verdict Watch tomorrow too. Which means more editing. I'll edit some of the expert witnesses for tomorrow if I need to. What time is it here? Central Time? It's 1:42 in the afternoon here. We're 1 hour behind the court. (2:42) where the court is. 1:42 where I am. Yeah, they are leaving at 4. I know. Yep. You're not wrong. So doesn't look like a verdict today. And the jury started the day with like we have to leave at 4. That's how they started the day. So it didn't sound like they were super optimistic that they were gonna be done today. I don't know what the hell they're discussing.
Drive me nuts. It's gonna drive me insane. They're gonna convict. They're gonna convict us. This is insanity. I got second that race. All right. Yeah, apparently jury of your peers is a much more frightening phase than anyone thought. There won't be a plea deal. There's nothing to plead to. There won't be a plea deal. I'm pretty damn confident. You get to edit with me tonight? No edit tonight. I don't know if it makes me feel better or not, but having read the appellate case law, I seem to vaguely recall reading cases in which it was arguably worse than this in terms of being lopsided and bullshit. There have been some bullshit convictions in appellate law history. Firearms auto key card case. I vaguely know about that case. Wasn't his conviction affirmed by a court of appeals? Or am I having a misremember? Yeah, so as I remember the case, it's been a while, but this guy came up with this like business card or credit card size piece of metal that had etchings in it. That if you cut out the etchings, that it allowed a gun to become a machine gun somehow. And so they regulated the entire thing as a machine gun. So, Supreme Court posted a draft opinion? Not again. So that's the case, I believe, that was with that guy. And I believe he was tried, and I believe he was convicted, and I believe his appeal was affirmed. Vaguely. Can I go over Dobbs? We've discussed Dobbs. I discussed Dobbs when it was brand new. I did a live stream on it. We covered it when it was happening. I was in LA at the time. We discussed it as it was happening. It's a poor summary of the auto card key case. Aww. But close enough. Aww. Except the ATF couldn't get to work as a machine gun when they did it. Okay. Yeah, I didn't know that part. Alright, that's enough Mario Kart for now.
I've enjoyed playing with you guys, but we're going to do some Supreme Court stuff. We're going to do something legal education. And possibly even record some content or something. So let me go ahead and punch out of this. And we'll do some other things. Shut up. Okay. This wired controller seems to be having some sort of problem with it. I'm not sure exactly why. All right, leave the group. Okay, cool. All right. Okay, let's pull up some Supreme Court stuff and do some stuff. All right. While we're waiting. All right. Do I think Aunt Bev would let them deliberate? Oh, I imagine, but the jury already said they had to go home, so that's not going to happen. But I imagine if they wanted to go longer, they'd let them. But yeah, that's not going to happen. Who do I think Lally? Why do I think Lally took this case? I'm not sure. It was assigned to him, I guess. I'm not sure how it works in the prosecutor's office. I'm not sure he necessarily had a choice, but you know. Let me do I'm a little bit depressed today. I'm a little bit depressed today. We talked about it earlier. Yeah. I suffer from depression, and today I'm just a little bit lower than I might be other days. That's just in the nature of depression for me. There's no particular reason. It just is. But yeah, I'm a little bit low today. But, you know, we press through. We press through. Some days are good and some days are bad. And today is just, you know, not a great day. It happens. Do prosecutors have a duty to not take a case? Yeah, if they can't, if they have a duty to make sure justice is done, basically, broadly speaking. So yeah, they sure do. Go work out the endorphins will do you. I haven't worked out in a couple days at this point. I really should. Mario Kart on jury watch? Yes, please. Yeah, we had fun with the Mario Kart. Not as many people joined me as I thought would, but you know, we feel. Thanks, you feeling better? Yeah, thank you. It just is what it is. Some days are good and some days are not great. I imagine it's like any sort of medical condition in that way. You know, some days are good and some days are not good. And you just hope that you wake up on the right side of the bed on any given day. Let's see what's going on in U.S. Supreme Court land. All right. Armed Career Criminal Act. All right, let's take a look at this. Mario Kart was fun. I agree. Mario Kart was definitely fun. Jackson's heading into court. Yeah? Are we about to have a verdict? Or is there a question? That could mean a lot of things. Keep an eye on OnlyFans cam. Something might be up. Fair enough. We'll do. All right. Let's discuss the Supreme Court case while we're figuring out whatever the hell's going on over there. Okay. Okay. Okay, everyone, let's discuss this case of Erlinger versus United States, writ of certiorari from the Seventh Circuit Court of Appeals. Let's see what the Supreme Court has to say. Paul Erlinger pled guilty to being a felon in possession of a firearm in violation of law. At sentencing, the judge found Erlinger eligible for an enhanced sentence under the Armed Career Criminal Act, which increases the penalty for a 922 conviction from a maximum sentence of 10 years to a mandatory minimum of 15 years when defendant has 3 or more qualifying convictions for offenses committed on different occasions. Okay, so right away we know that Mr. Erlinger has not necessarily been super compliant with the law up to this point in his life. He is a felon, so he's been previously convicted. He has a firearm in his possession. That's illegal. Okay, that normally would require a maximum sentence of 10 years. But under the relevant law, because of his rich criminal history, instead of 10 years max, how about 15 years minimum? So there's a pretty big difference there. And so we're taking a look at whether or not that was a fair thing to do. Okay. Subsequently, the Seventh Circuit held in unrelated decisions, so not this case, but in a different case that has impact, that 2 of the offenses on which the government relied for Mr. Erlinger's sentence no longer qualified as a predicate offense. So he has to have 3 or more predicate offenses, and the Court of Appeals are like, 2 of these are not predicates. So that would be really helpful for Mr. Erlinger's case. The district court vacated the original sentence and scheduled resentencing. At resentencing, prosecutors again pursued a sentencing enhancement based on a new set of 26-year-old convictions for burglaries by Mr. Erlinger over the course of several days. All right, so the government lost. He was originally convicted, and he was sentenced to 15 years minimum. He appealed in an unrelated case. 2 of those were thrown out. So his case is sent back for resentencing. You can no longer use these crimes as predicates. The government's like, no problem. We can't use those crimes as predicates, but we have exciting new predicates that we can bring in. So we're going to try the exciting new predicates so that we can get our 15-year minimum instead of the 10-year max. All right, so that's what they're trying to do. Mr. Erlinger protested that the burglaries in question were part of a single criminal episode and did not occur on separate occasions as was required by the relevant law. So as we might say in the trade, he says they're part of the same criminal transaction. The criminal transaction is the set of crimes that occur for a common purpose or closely related in purpose and or time is how you define a criminal transaction. Typically, but not always, that means those sentences are run concurrent, which means they're treated as though there's only one crime or only the most severe crime counts. That is the typical rule, but not exclusively. But yeah, he says, okay, these crimes, these burglaries were all part, they were separate legally, and they're separate legally distinct, but they all occurred, what we would say, the same criminal transaction. So they only count as one thing, not separate things. Okay, fair enough, as far as it goes. Okay. Moreover, Mr. Erlinger argued the question of whether he committed these prior burglaries during a single episode or on distinct occasions required an assessment of facts surrounding the offense, and the Fifth and Sixth Amendments require the jury make the assessment. So he thinks the jury should have decided this issue. The district court rejected Erlinger's request for a jury and instead issued the 15-year minimum. On appeal, the government confessed error. So the government says we were wrong. They won at trial, but on appeal, they say they're wrong. Pursuant to this court's recent decision in Wooden v. United States, which acknowledged that the ACCA occasions inquiry can be intensely factual in nature, the government admitted that given the factual nature of the inquiry and its impact on the defendant's sentence, the Constitution requires a jury to decide unanimously and beyond a reasonable doubt as to whether Mr. Erlinger's prior offenses were committed on different occasions. This court grants certiorari and appointed counsel to defend the judgment below. So this is an unusual case.
This is an unusual case. The defendant says he's right. The government says the defendant is right. So both the parties agree he's right. So the U.S. Supreme Court does what it sometimes does and appoints a lawyer to defend the decision below. That's not affiliated with the parties. So now we have three parties in this case. We got the defendant and the prosecution who are in agreement, and third guy who's going to try to argue that the court below made the right decision. That's his job. Okay. All right. All right, let's proceed on. Held. The Fifth and Sixth Amendment require a unanimous jury to make the determination beyond a reasonable doubt defendant's past offenses were committed on separate occasions. Fair enough. The Sixth Amendment promises that in all criminal prosecutions, the accused has the right to a speedy and public trial by an impartial jury. Inherent in that guarantees is the assurance that any guilty verdict will issue only from a unanimous jury, citing Ramos versus Louisiana, which said that yes, unanimous juries are in fact required. The Fifth Amendment further promises the government may not deprive individuals of liberty without due process of law. It safeguards for the criminal defendant well-established common law protections, including the ancient rule that the government must prove to a jury every one of the charges beyond a reasonable doubt. Together, these amendments place the jury at the heart of our criminal justice system and ensure a judge's power to punish is derived wholly from and remains controlled by the jury and its verdict. The court has repeatedly cautioned that trial and sentencing practice must remain within the guardrails provided by these two amendments. Thus, in Apprendi versus New Jersey, the court held that a novel sentencing enhancement was unconstitutional because it violated the rule that only the jury may find facts that increase the prescribed range of penalties. If you want to make the sentence more severe, it has to be based on a fact the jury found, either explicitly or implicitly, because it was required for the criminal offense. You can assume the jury found every fact that was argued at trial, but you have to actually present evidence. The principle applies when a judge seeks to issue a sentence that exceeds the maximum penalty authorized by the jury's findings, as well as when a judge seeks to increase a defendant's minimum punishment. So if you want to make the sentence worse, either way, it has to be based on what the jury does. That makes logical sense. The government concedes what all this means for Mr. Erlinger. To trigger the ACC's mandatory minimum, the government had to prove, among other things, the three predicate convictions were committed on occasions different from one another. And as Wooden observed, deciding whether those past offenses occurred on three or more different occasions is a fact-laden task, as the government recognized virtually any fact that increases the prescribed range of penalties to which a criminal defendant is exposed must be resolved by a unanimous jury beyond reasonable doubt or freely admitted in a guilty plea. Here, the sentencing court made a factual finding that Mr. Erlinger's offenses occurred on at least three separate occasions. That's a factual finding by the court, and that's not allowed because it makes the sentence worse. If it made the sentence better, fine, but it doesn't. It makes it worse, so it has to be decided by a jury. And as Apprendi and Eleni, the factual finding that had the effect of increasing both the maximum and minimum sentences Mr. Erlinger faced. So other one will be fine, because either way you're increasing it. Any increase has to be based on what the jury did. Increasing the minimum, increasing the maximum, either way. It has to be based on a fact the jury found. Thus, Mr. Erlinger was entitled to have the jury resolve the inquiry unanimously and beyond a reasonable doubt. This court decides no more than that. The amici relies on an exception announced in Alejandrez-Torres versus United States, which he argues permits a judge to find certain facts related to a defendant's past offenses, including whether he committed them on different occasions. That decision is an outlier, so the Supreme Court disagrees with itself. And the court has described it as, at best, an exceptional departure from historic practice. It persists as a narrow exception, permitting judges to find only the fact of a prior conviction. So they can find the prior conviction occurred, but they can't find more than that. Amicus responds that if Alejandrez-Torres permits a judge to find the fact of the conviction, that necessarily implies the judge may also find the jurisdiction in which the underlying offense occurred and the date it happened, which is generally enough to resolve the occasion's inquiry, making sending it to the jury pointless. The court disagrees. To answer such questions, a court will sometimes consult the Shepard documents in a case, which includes judicial records, plea agreements, and colloquies between the judge and the offendant. The video blipped for a second, so it caught my attention. This court disagree. Okay. This court's cases hold that a sentencing judge may use information gleaned from a Shepard document for the limited function of determining the fact of a prior conviction and the then existing element of offense. No more than this is allowed. Moreover, and often, Shepard documents will not contain all the information needed to conduct a sensible inquiry, and they can be prone to error. Amicus insists this court's Amelioras-Torres precedents are mistaken, because the Fifth and Sixth Amendments' original meaning and common law traditions authorize judges at sentencing to find all manner of facts about offenders' past crimes. But this court has been down this road many times before, and to reconsider all those precedents now would, at the very least, require convincing proof indeed. Yet Amicus offers nothing like that, and the evidence he does offer does more to hurt his case than help. Amicus points to supplementary information procedures that a few states employed in the early 19th century. But a sound sentencing procedure following by a few states hardly represents convincing proof that our precedent has been mistaken about the original meaning of the Fifth and Sixth Amendments. And upholding one such scheme, the court stressed that under the law's terms, that even the fact of a former conviction had been charged by the prosecutors and then determined by a jury in a proceeding that then ensued. Amicus next turns to the double jeopardy clause, which permits a judge to look in defendant's past conduct to ask whether the government has charged the defendant for the same crime a second crime. While the double jeopardy clause protects the defendant by prohibiting a judge from even impaneling a jury in which a defendant has already faced trial on a charged crime, the Fifth and Sixth Amendments' jury trial rights provide a defendant with an entire complementary protection at different stages of proceedings by ensuring that, once a jury is lawfully impaneled, the government must prove beyond a reasonable doubt the unanimous facts required to sustain the conviction. Finally, Amicus points to case law and statutes in 4 other states, but while this evidence may suggest that in a small number of jurisdictions, judges could find the existence, numbers, and dates of prior convictions, none of this provides a basis for revisiting this court's many precedents forbidding a judge from doing more, let alone provide a long-standing tradition. Yeah, so long story short, the jury is required to find every single fact that makes it worse. You can take notice of a prior conviction because a jury found that, and so that's something that's been decided. But you can't take note of anything more than that. So you can take note of the prior trial to say whether it's double jeopardy. You can take note of the prior conviction to say that it happened. But anything else, including when the offense occurred, is a fact that has to be proved to this jury, which may be very trivial, incidentally, in most cases, but still is a fact that has to be proved. So that makes logical sense, and that is what's going on. All right. Amicus argues that leaving occasions inquiry jury would do more prejudice than protect defendants. The concern, like arguments about efficiency, cannot alter the demands of the Fifth and Sixth Amendment. Tools such as bifurcation, which is where you split the trial in half, you have a separate phase for liability, which is to say guilt, and a separate phase for sentencing, which many courts do anyway. They have 2 different phases. It's also done in death penalty cases as a matter of course, but some states do them otherwise. So you can separate the trial of liability from the trial of sentencing, and you can bring in new facts into the trial for sentencing under relevant rules. So, fair enough. So you can do that. Tools such as bifurcation exist to address the prejudicial effect the evidence about defendants' past crimes may have on the jury. Gorsuch, my fanboy, I love him over there, in which Roberts, Thomas, Sotomayor, Kagan, and Barrett join. Jackson, surprisingly perhaps, files a dissent along with Kavanaugh and Alito. So a 6-3 decision in this case. So yes, my friends, long story short, the jury has to find all the facts in your case. They are the finder of fact. It's what they do. And if they want to use something against you and it's factually related as to, for example, whether something occurred on different occasions or not, which is a question of fact, then that is a question that has to be decided by a jury. Could be trivial. You may be able to bring new evidence into a sentencing phase, but you have to actually go do that. So his sentence will be reverted, and presumably there will be another trial, at least based on this limited question. But for the moment, that brings us to the end of discussion of this case. Stuff is happening in the verdict in the case, not a courtroom.
What's going on? I'll turn up the volume of the court just in case something happens. I've now got the fan volume up in case Fan wants to join us for a discussion about the Supreme Court. I'm not sure whether or not Fan has any thoughts on the U.S. Supreme Court, but if it does, I'd like to hear them. I trust in Fan. Fan is reliable and steadfast and does not deceive. All right. I need to upload the video for today so that I can publish it at 4. Because we're going to stop the stream probably around then. And then we can watch the video together. So I need to upload it real quick. Any thoughts from the Fan would be circular? We do always seem to wind up back where we started with Fan. That's fair. We don't really seem to be making much progress in the end. Things are going great for a while, but we always seem to end up where we started. Yeah. That's true. I suppose we could also briefly talk about Dr. Disrespect, because that's in the news. Dr. Disrespect, who people may or may not know, was at the time, I believe, the leading #1 Twitch streamer. Twitch, of course, is a gaming platform, at least traditionally. That's where people go to stream games. And he was a big gamer in the late 2010s. So his contract with Twitch was terminated somewhat unexpectedly about 3 years ago, 4 years ago at this point. So yeah, 2020, I believe, is when it was terminated. And there's long been speculation about what's going on. Check WCVB stream. Okay, I will do that. I'm not sure why the stream would matter, but I'm happy to check a different stream. Okay, give me a second. WCVB. They don't seem to have a stream. Well, I guess they do. Well, they have Very Boston News. They're doing a Boston News program thing, but they're not doing a live coverage, trial coverage. So I don't know what you want me to watch. They don't seem to have live coverage of the thing, so I'm not sure what you're asking me to do. Anyways, so he was kicked out of Twitch in 2020, and the reasons were unclear as to why. There's been really no clarity on this issue. About a week ago, someone who is reasonably high up in Twitch said that they thought the reason was because he was sexting minors, and that was the real reason. And I believe it was yesterday now at this point, Dr. Disrespect largely confirms this with some ambiguity, but not much. He confirms that he did in fact text a minor, and he confirms that at times the conversation got what he calls inappropriate, which sounds suspiciously like it might have been sexually involved, which is not good news, ideally. That poses any number of potential legal problems for talking to a minor across state lines in that way. It could be viewed potentially as soliciting or any number of things that could potentially be illegal. Now, he says that he didn't commit a crime, which might be correct, because just talking to someone under the age of 17 isn't illegal. I mean, some of you guys might be under the age of 17 or under the age of 18. So if I knew for a fact you were under the age of 18, I can still talk to you, right? I mean, that's not illegal to talk to someone who's under the age of 18. It's only illegal to do certain things with respect to a minor, not just have a conversation. But, it seems like it was more than that. And so it might not be illegal, because for you to cross the legal threshold, it obviously has to be more explicit. It has to be more clear, right? So it might be more ambiguous. So even talking to a minor about sexually charged subjects or in a sexual way might not necessarily be illegal.
But, you know, you probably want to avoid dancing on that line, all things being considered. If, you know, also it's possible that he didn't know it was a minor, but he didn't deny that he knew it. If he didn't know it was a minor, presumably he would have in his statement say, I did not know it was a minor. So obviously you have to know that. If you didn't know they're a minor, then it's not illegal because you didn't know. It goes to your mental state and your knowledge base. So, yeah. So it appears that he had, let's say, inappropriate conversations with a minor that may not cross the legal threshold. So that's what's going on with Dr. Disrespect. So it may not be illegal. Twitch apparently paid out his entire contract. So they apparently paid out everything as a settlement. And yeah. So that's where it is legally. And it will hurt his reputation dramatically as well. So probably best avoided. Probably best avoided. Would an NDA prevent Doc from saying, I didn't know it's a minor? No, I can't imagine how that's possible. If he's willing to go this far in talking about it, I can't see how any NDA would prevent him from saying, I didn't know it's a minor. That doesn't make sense to me. And if that was the truth, then presumably he would tell me. And then I'd be like, oh, okay. He was mistaken. And then we can discuss how foolish he is or not, but that would go a long way to assuaging our moral and legal analysis. And also he was married at the time, so there might be moral condemnation for that reason. But then again, that's moral, not legal, and I principally stick to legal analysis. So that's what's going on. Would Twitch have any duty to report that conduct? No, I don't think so. No affirmative duty. I'm not aware of any law that would apply. There might be a law that I'm missing because I don't know every law perfectly well. But unless there's some specific federal law that requires them to alert police, which I don't think there is one, no. Twitch has no duty, no affirmative duty. They have no obligation to alert the police that a crime is occurring, even if they have actual knowledge. Just the same way I have no actual knowledge, even if I have actual knowledge. You know, I might be a dick, but if I see someone being murdered outside my porch, I am legally allowed to not do anything about it, including not calling the police. Because I have no duty. I have no obligation. So I'm going to go with no. Twitch is not obligated to, no. Would Twitch have any liability for not stepping in to protect the minor? Civil liability? Potentially. Although the CDA 230 would probably come into play. So probably not. No, they probably would not. Well, no, there is the Child Online Protection Act now. There's COPA. So they might have some liability for not intervening civilly. That's possible. I'd have to double check COPA. So maybe. Twitch is not a mandatory reporter. Yeah, I don't believe so. No. Yeah, I don't think so. So, anyways, it is what it is. It's not great news. Maybe stick to people that are over the age of 18 would be helpful, particularly if you're crossing state lines. You know, if you're within a state and you're having a conversation with a minor and the age of consent is under 18, then I guess. But if you're crossing state lines, you know, probably want to avoid the under 18 because you're probably in violation of the Mann Act, even if the age of consent is younger than that, because it's crossing state lines. So don't do that. Maybe stick with the over 18-year-olds would probably be helpful, just to avoid headaches, right? You don't want your lawyer dancing on the finer points of whether it's legal or illegal. Probably when it comes to children, probably best to not have your lawyer dance on the finer points of that. You know. Federal 13 becomes a non-civilian. Thank you very much. What is the Mann Act? It's a federal law that prohibits, the Mann Act is two N's, M-A-N-N. It's a federal law that prohibits transporting minors across state lines for the purpose of sexual engagement. And it might have some components dealing with interstate communication that
that might apply. It's a federal law that makes it illegal to go across state lines for the purpose of having sex with someone under the age of 18, even if the age of consent is under 18 in the relevant jurisdiction, because you've crossed state lines. So that's the Mann Act. You gonna stick with over 30-year-olds? Fair. Fair. All right, let's see what else we got. Also, incidentally, as long as we're here and we want to learn something legally, it's also illegal for an American to travel overseas for the purpose of engaging sex with an under 18-year-old, even if the age of consent in that country is under the age of 18. Because the U.S. has jurisdiction over you everywhere, if you're a U.S. citizen. So if you're a U.S. citizen, and I assume a green card holder as well, you can't travel overseas for the purpose of having sex with a person under 18 if you're paying them. No sex tourism. Sex tourism is illegal under U.S. law, even if it's legal under that country's law. Just the more you know. Just in case you care, so as long as we want to learn something. I'm here to help. All right, should we discuss Rimini? The gun rights case? Yeah, you have to follow laws even if outside the U.S., correct. If you're a U.S. citizen or U.S. national, this is also why the U.S. gets to charge you income tax no matter where you are in the world. Because they have jurisdiction over you everywhere. Am I talking about maritime law? Strictly speaking, no, I'm not talking about maritime law. Strictly speaking, I'm talking about extraterritoriality of U.S. law, which is a big fancy word for when U.S. law applies outside the United States. So no, not maritime. No. Why is it legal for a U.S. citizen who's moved away forever from the U.S. and getting benefits in our country to still vote? Because it depends very technically on what their domicile is, which is a very interesting legal concept. If their domicile is overseas, then I'm not sure they can vote. But I'd have to double check. But if their domicile is inside the United States, they can, no matter how long they've lived overseas. Domicile is this legal concept that is basically, you can only have one domicile. You can only have one. And it's this legal concept of basically your permanent residence, where you intend to come back to, even if you live somewhere else for a long period of time. So you can live somewhere else for 20 years, but not change your domicile legally. It can get incredibly complicated. The most obvious place it would get complicated is if there's a will or not a will, because now we have to decide what state you died in, or what state your assets will be probated in more strictly. Right. So if you lived in California if your California was your domicile and now you lived in Iowa for a really long period of time and you die, okay, which state gets to probate you? Assuming you don't have a will. Even assuming you do have a will, incidentally, because it would have to be interpreted by one of the two. So which state gets to decide this case? So yeah, domicile is this concept that, so if your domicile remains in a U.S. state, you could live overseas for 20 years and it wouldn't matter because your domicile is still in the U.S. If your domicile is outside the United States, because it's now the place you intend to remain forever, I'm not sure whether or not you can vote or not in a U.S. state, because it's no longer your domicile. So I don't think you can vote in that state. So I don't know, but I'd have to double check. This is also technically the difference between residence and domicile. A person can have multiple residences. A residence is just anywhere you happen to live. But you can only have one domicile. It's your place of permanent residency, for lack of a better description. Extraterritoriality, is that one word? Yeah, it's one word. Yeah. With her on a cruise? I don't know. I don't know. I don't know. I'm not sure. Probably is based on the flag of the boat, I would imagine. It might be. Yeah, it might be the flag of the boat, no matter where you are, because the boat is under a particular flag. So if a crime is committed on a cruise line, it's probably the flag of the boat that has jurisdiction, no matter where they are. Well, no, that's not true. If they're inside the territorial waters, then they would also have jurisdiction. So multiple places can have jurisdiction at the same time. But if they're in international waters, it's the flag of the boat, I think, that governs. Yeah. It's the flag of the boat that governs. So, yeah. They're going back in, you think? Turtle Boy tweeted the verdict is in. Do we have a verdict? We have a verdict? Okay, we might have a verdict. All right, let's do this thing. Let me get it up on screen and we can do this thing. Thank you for your legal questions. I enjoy providing you legal information. It pleases me. Still watching a fan? I'm very much still watching a fan. I am very much still watching a fan. 100%. The fan is glorious. The fan does not... The fan... If the fan knows the verdict, it is not telling me. That's all I'm saying. The fan is keeping its mouth shut. No announcement of a verdict? You think they're just releasing them? It's a little early. Jury's coming in, but no verdict. You think they're getting released for the day? What happened to me uploading the video? Did I ever actually do that, or did you guys distract me? I think you guys distracted me and prevented me from uploading the video. You guys are jerks. I'm blaming you, collectively. Oh, I still don't have a thumbnail for my video. I never created one. Well, that sucks. Okay, I guess we're thumbnailless until I create one. Shit. I forgot to create a thumbnail. Okay, we will not have a thumbnail while I upload this video. You guys can watch Spinning Fan while I hastily create a thumbnail. There we go, that's better. All right, so I need a picture of Jackson. Jackson. Karen Reed. The fan is Zen. I tend to agree. Alan Jackson is the guy's name. All right, let's go find a picture of Alan Jackson. My Uncle Rock resents Randall Dale Adams, whose case was featured in the movie The Thin Blue Line. That's cool. Oh, yeah, that's a good photo. No, that's not the right guy. There's another Alan Jackson attorney. I need the right Alan Jackson. Was Alan Jackson an LA lawyer, or is he an LA lawyer by any chance? Because I'm coming up with a lot of LA things that looks like the guy. You sent fan mail, didn't get a reply? I'm sorry. I usually acknowledge it on stream. I might not have gotten it yet. I'd only check the box every so often. So I might not have gotten it. He was an LA lawyer? Okay, that makes sense. He ran for district attorney? Neat. Good photo of him. All right, let's create a thumbnail for this thing. Am I a romantic? I'd say I'm a romantic. Yeah, I'd say I'm a romantic. And Jackson worked with EDB. That's pretty cool. Have that tie-in. That's pretty cool. He's still an LA lawyer? Fair enough. Fair enough. Defense's master closing argument. That's a pretty good title, I think, for the thumbnail. Did I misspell defense? D-E-F-E-N-S-E. D-E-F-E-N-S-E. Defense is correct. It's defenses, right? With apostrophe S? Yeah. It's, for some reason, Google is trying to correct me when I throw an apostrophe S. That's right. D-E-F-E-N-S-E apostrophe S. Defense's master closing argument. Yeah, that's right. Stop trying to correct me, Google. All right, I need to change the background color on this real fast. I'm just going to use a 3-color gradient. Keep it simple. Okay, let's see. Do this, change this. All right, do that. Okay, and now set it up vertically. All right, that's an interesting look. All right, I think this red to orange look is going to be good. All right, let's try. Yeah, I'm not feeling that bottom color at all. Let's try this kind of 45-degree gradient looking thing. Okay, page 6, download. Okay, now I have a thumbnail. Yay. Excuse me while I change this real fast. You miss clock and chandelier? I feel you. I really do. Red is an angry color. Yeah, I guess it can be. It's fine. A master closer speaks for Karen. Karen Reed, a master closer speaks for Karen. That's a pretty good title. I am pleased with this title. All right, I'm going to set this as a premiere. So you guys can join me for that. And hopefully it'll be good. Okay. I would like to schedule this. I'd like to make it public today. I'd like to schedule it for, what time should we say? They're going to be done at 3 o'clock. Should we say, they're going to be done at 3 o'clock my time, right? Should we say 3:15? You think that's too early? No verdict today, it's too late? That's unlikely. I agree with that. Okay, I'd like to set this as a premiere. I'd like to do this 2 minute. Okay, what time do I want to do this? All right, I'm going to say 3:15 for now, I think. This is going to be a long premiere, man. I think 3:05. Oh, and I have to set up a redirect too. Fries without shake. You made your last mistake. Gave me fries without a shake. Yeah. I'll shake for you, baby, if it makes you feel better. Shake, shake, shake. Shake, shake, shake. Shake, shake, shake. Shake, shake, shake. All right, I got the redirect set up. Court TV says verdict. Well, something's happening.
The jurors have indicated they want to go home, so they're coming over.
Not so much. No. Not so much with verdict. I have no particular thoughts on the Assange deal. I have no particular thoughts. If it makes everyone happy, then fine. I'm not sure what they're talking about, but they're talking about something. I guess we're doing jury watch tomorrow, guys. I guess we're doing jury watch tomorrow. I want to go home too, and I'm already there. No, they're not going home early. Well, I guess they're going a little. Another Jay with jury watch with me? Well, I guess that's what we're doing. I'm tired. You're tired, Kestrel. I'm tired too. I feel it, Kestrel. I really do. I need a long break too. I need someone to massage me. And some sort of umbrella drink. That's what I need in my life.
You see the court of the session.
All right, jurors, you've been working hard today. I understand you want to go home, so we'll suspend for the day and we'll see you tomorrow morning ready to start right at 9. So please follow those same 3 instructions. Do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it. Put the whole case out of your mind until tomorrow. We'll see you tomorrow. Thank you.
All rise to the jury. Jury up.
Thank you, Tracy. I don't know what's going on. I don't know what's going on. I don't know if LTL Media or anyone else is live outside the courthouse. It'd be interesting to watch their coverage for a second.
All right, we'll see you tomorrow. We're all set.
All rise, please. We'll be in recess.
Case is over for the day. See if anyone's live outside the courthouse. Let's see if they're still live or something. He's probably in the courthouse, to be honest. So, yeah, I don't know if there's anyone outside the courthouse who's streaming. Will the Supreme Court give mind to the debates as far as releasing the verdict on immunity? I think that's what they're waiting for. Yeah. I don't think they're going to release it till after the debate. They don't want to be fodder. I think that's exactly what's happening. What are the rules regarding non-citizens, like work permit, on people being based on juries? You have to be a citizen to be on a jury. You have to be a citizen. Green card does not do it. You must be a citizen. Yeah. And Eddie looks tired. Him and me both. Him and me both. They'll be on in a minute. Okay, we'll sit for a minute and see if we can get some sort of coverage outside the courthouse. I saw goober lawyers on Twitter thinking Karen Reed is guilty. I don't know how you do that. I just don't know how that's possible. I don't know how you think Karen Reed is guilty. Not only did the state not prove the case, that photograph of the car at 5 o'clock in the morning kind of proves her innocence. So if you ask me, is she innocent beyond a reasonable doubt? I'd be like, yeah, kind of. Because it's like, how could, that doesn't make sense. You know, so yeah, I'm kind of with Peter on this one from Lawyer No. He said he thought it's been proven. He thought innocence has been proven beyond a reasonable doubt. I'm like, I mean, yeah, kind of a little bit. Do I think I'll have a verdict tomorrow? I thought they'd have a verdict 6 hours ago, so I'm not sure I'm the right person to ask anymore, to be honest. What photo? The photo that was in the closing argument of the lawyer? That the only exhibit he used in his closing argument, the lawyer put up a photograph of the car at 5:07 in the morning that was caught on camera, and it clearly showed the tail light still intact. Showed that red taillight, showed red in the tail light. That photo, the one that he was used in closing. It's a photograph taken at 5 in the morning that shows the taillight fully intact, to me. So yeah, why are lawyers allowed to lie? Strictly speaking, they're not. Strictly speaking, they're not allowed to lie. But they don't necessarily have to make things particularly clear. And why the prosecutor is allowed to do what he's allowed to do, I don't know. It doesn't make sense to me. Yeah. Absolute joke. I tend to agree. Something big is brewing? I don't know, man. I don't know. We may wind up doing this entire trial all over again. That'll be glorious. We'll do this entire trial over again in 6 months. Live coverage. We'll do all the witnesses again.
You get to hear from Proctor again and Paul again. How exciting. How do you message me? There's plenty of ways to contact me. Plenty of ways to contact me. Easiest way to contact me is probably on Discord. You can also send me an email. That's also fine. Is it Linktree? Exclamation mark Linktree. Does it link something? Yes. And what exactly is the thing for the bot? And there you go. So there's all the ways to connect with me. Can they use former testimony against them? Yes, absolutely they can. So I think I'm going to go ahead and sign off. I was kind of hoping for Karen Reed outside live, but I don't know if there's any outside live coverage. Dude, McKay gives $10. Say fitting that the jury asked for a report that, as far as we could tell, doesn't exist. Should really underscore the decision they need to be making. Yeah. Can I pull up people? Can I put up a poll on how many people in chat have served in a jury? I'm not sure if I can do that. I'm not sure that really makes sense as a poll. I'll do it anyway. What the fuck? Actually, can I do that easily? Not from my interface, I can't. I'm tired. I'm tired and I'm going home. I'm already home, but I'm going home. I'm going more home. We will be back on tomorrow with more live coverage. My video will be live in about a half hour. It's a 50-minute long video. It was hard to parse down the defense is closing because it was so good. But it's a 50. So this is a very long short. It's a very long short. It's a 50-minute short. But it is what it is. So we will have that video come out in 30 minutes. This should automatically redirect you that way. I hope. Let me double check my settings because I'm tired and I'm grumpy.